All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 8th. We have 9 bills on the docket. We're going to start off with Senator Sidnor with Senate Bill 583. We'll then move on to Senator James with Senate Bill 631. We'll then go to 759, 760, 676, 528, 569, 503, and then we'll wrap up with Senate Bill 459. So with that, we'll start off with Senator Sidnor, Senate Bill 583. Senator Sidnor, you're up.
All right. Good afternoon, Mr. Chair and committee. Senator Charles Sidnor talking on behalf of Senate Bill 583. In the years that I've been in this General Assembly, as many of you have known, I've always put forth bills that deal with the whole relationship of the Fourth Amendment and privacy rights and surveillance technology that law enforcement has used. With your help, we've passed legislation dealing with the regulation of cell site simulators, forensic genetic genealogy. We even have a bill before us where we're looking at facial recognition in that technology. What I have found is generally because of the way that law works, we tend to be running behind technology. So every year there's always something new. When we look at how things like cell site simulators came to bear, it was finding out this information in the newspaper. Recently, Baltimore City, they began using these surveillance planes that they were flying over the city that no one knew about. This particular piece of legislation, which is based off of a model that's used in Oakland, would create essentially, I'll call it a commission for lack of a better term, but an entity that would look at and ensure that we know what types of surveillance technology law enforcement is using. If you were to look at, I believe it's page 4 of the bill, it talks about what this particular board would do. So, and it attempts to address some of the things or some of the problems that I've seen. As I said, as law enforcement has used this without public knowledge or public input. So what this board would do is would authorize the purchase, use, and continued use of certain surveillance technology by law enforcement agencies. It would also authorize the use of existing surveillance technology or certain information of that surveillance technology. We'd have public meetings. It would consist of a variety of people from law enforcement, from public defenders, as well as I believe there was also a spot for, let's see who else. Someone from the state people, as well as some folk from the, like I said, privacy advocacy organizations, the technology industry, as well as someone with a background in Fourth Amendment jurisprudence. So this is essentially a bill to try to tie up some loose ends. And with that, I will rest and ask for a favorable Senate report, a favorable report.
Senator, you had said that this was in Oakland.
Oh, not in Oakland, California. I'm sorry, not your Oakland. I wish it wasn't. I wish it wasn't Oakland, Maryland.
Two very different Oakland. That's what's up. All right, Senator Washington.
That's why you were looking. That's why you kept looking. I know.
Thanks, Mr. Chairman. Senator, can you just, I see that the Maryland Department of State Police is in opposition of the bill. You want to speak to their opposition? You can say no too if you don't.
You know, it's what I expected. With this type of legislation, usually it takes a little while to get things going. So I've put it in, and fully expect that this is something that's gonna take some time to work on and to work out. The state police, I've worked with them in the past, and I will continue to do so moving forward.
Thank you.
Mhm.
So additional questions from the committee? All right, seeing none, thank you very much, Senator
Thank you.
Sidnor. We have two guests that are joining us virtually. Neither of whom are in the room where it happens. All right. So with that, not there? Okay. So that'll conclude the hearing of the testimony for Senate Bill 583. We'll now move on to Senate Bill 631 with Senator James, if you're ready. And then we'll move over to Senate Bill 759, Senator Carter.
Mr. Chairman and members of the community, members of the committee, thank you for allowing me to speak on behalf of Senate Bill 631. 631 has a pretty simple goal, which is to better align it with a federal law. Its acronym is CAPTA, but also stands for Child Abuse Prevention and Treatment. Better disclosure in cases of child fatality or near fatality when the child is under the protection or monitoring of a state or government actor. Maryland does have some public disclosure laws, and certainly there's one that we're trying to amend here, 1-203 of the Human Services section of the code, but it was drafted and done and amended before or without an appreciation for CAPTA. And without getting too into the weeds about CAPTA, it is a federal law that is one of its primary purposes is to ask for more transparency and accountability with children that are, under the care and custody of the government and then more generally in the public. But the current practice in Maryland, in the section that we're trying to revise, let me tell you how it really works. Even if the affected community, the press, or an advocacy group that cared deeply about improving child welfare services wanted to know about a child fatality or serious injury, they would pretty much be blocked, because the way the law reads and allows, the state's attorney has broad, absolute discretion to block any information with the sort of what I would consider a highly subjective standard of what might undermine a prosecution or investigation. And there are no time constraints on this review, and no guidance to the public as to how or when they might get a response. What SB 631 does, and by the way, I worked very hard with the state's attorney's office to try to make sure I balance their concerns as well as what I think our concern should be about protecting children. So what this bill, it's very modest what it does, and it's subtle, but it lifts a restriction in existing law that says you can only get information about omissions or actions of a state actor, and it substitutes that if any child has been subject of an investigation, report, referral, or complaint received by the state government, then that information should be available to the public. It puts deadlines on the states, the Department of Social Services to review a request for public disclosure. It puts time deadlines on the state's attorney to make a decision. And for once, it offers the option for redaction. So instead of a wholesale denial of information while the incident has recently occurred, it says to the state's attorney, go through and really look at the record, see what you can and cannot disclose that would undermine the investigation, but get some information out to the public. Now, obviously, we still give the state's attorney the right to continue to completely block the information, but this encourages him, because of federal law and other issues that I'll get to in just a moment, to try to push more information out to the affected communities and advocacy groups in the press, because I think as a community in the state, we all care whether children that we put under our protection are being well served or put into grave, sometimes deadly danger. The Department of Health and Department of Human Services both put in letters of information. Both were put in before they saw the amendments, where we took out that the records remain confidential. So the records remain confidential. And we put back in that the state's attorney still has a review and right to block or redact. And those were their primary concerns. But I was really interested because the Department of, I think, Human Services went to great lengths to say, by implication, we don't need this bill because we have all kinds of groups that do reporting. They listed the local Child Fatality Review Commission, the State Council on Child Abuse and Neglect, and the Child Maltreatment Fatality Review Board. I looked at all these reports, and I will tell you what they're like. They're big data and analysis, nothing about specific cases. There's no way that an individual could understand or find out anything about the case. Even these reports come out a year, 2 years later. So even if you were blocked at the time, but told, don't worry, later on, you'll get some information, you will never find an individual case described or discussed in any of these reports. So there's no meaningful way for the public to know what is going on. But I want to direct your attention. You don't have it because I just got it, but I have to read something from the report for the State Council on Child Abuse and Neglect. This is I'm going to read from page 24 briefly and 28, because I think this makes the case for the bill. On page 24, almost 60% of cases reported to Child Protective Services by mandated reporters and concerned citizens go unaddressed, according to the data provided by DHS. Even cases that receive a child welfare response lack accurate tracking and reporting services and outcomes. And on another page, in the same report, no data was provided regarding the number of serious physical injury, another word for near fatality. No data was provided regarding the number of serious physical injury that had an active case or prior child welfare case, which has been closed within the past 12 months. SSA was unable to provide data on the race and ethnicity of child fatalities and children with SPIs, and this is of great concern to the council. This data should be publicly available on a regular basis. This is their reports, the reports that they say should substitute for an improvement of our bill. So I work with the state's attorney, and I also work with a leading expert and person that's deeply involved in this in Georgia, because Georgia's passed a law like this, as of other states, to comply with this federal law. And I would ask you to consider giving it a favorable report.
Excellent. Thank you. Excellent presentation. Thank you, Senator. Questions for the sponsor? That was good. Well researched. Those done. Thank you very much.
Thank you, Mr. Chairman.
All the reports you mentioned, I have no doubt you read each and every one of them. All right, Senator Sidnor has a question, actually.
I tried to follow the presentation. I'm trying to understand. You said it was amended so that confidentiality stands intact. What does your amendment do?
I can't hear you.
What does your amendment do?
What does the bill do?
Your amendment.
Oh, when the bill was, I inherited the bill from a member of the House of Delegates, and under time constraint, I put it in as it was. Then I had time to actually research it and realize that I should work collaboratively with the state's attorney's office. And rather than do the bill as it was originally introduced in the House, which stripped confidentiality and a couple of other things that just didn't seem like we were collaborating with state's attorneys, I basically amended the bill and put back in the provisions that the state's attorneys wanted. And then, just not getting too much into the weeds, because the bill had never been really read and reviewed with the amendments to make it flow better, I took a moment to make it flow better. And I shared this with the state's attorney's office. So basically, we restored their concern about confidentiality and then gave them an opportunity not to wholesale keep the information away from the public, but to redact it. But even under redaction, they could still, if they felt like there was nothing that could be disclosed, not a thing, they would still have that right. But the bill's emphasis is to try to take a harder look and to see if there is some information you can give out contemporaneously. And then at the end of the process, if the state's attorney I was going to get into, if the state's attorney has prosecuted or declined or investigated and then concluded, then the bill also, and I just cleaned that language up just a little bit, says that the information needs to go out to the public.
Thank you.
Thank you.
We could ask more about, I know Steve Kroll's coming up afterwards, so you ask more about just how they go through the exercise of either, because right now they have the ability to just, they don't have to disclose anything. They have full veto power.
Until the end of an investigation or prosecution, of which there's no deadlines at all. And I'm not sure anybody comes back and says,
Hey, can I
"Please
have
give
that?"
me-" Yeah, can I
Yeah.
have the information?
Excellent. All right, see no further questions. Thank you very much, Senator. We're going to bring up Mr. Rawlings, Thomas Rawlings. Is Thomas here? He's in the Zoom room.
I'm here. I guess I can't turn on the video or,
You can hold it.
Oops.
Give us a second. It'll pop up.
okay, thank you.
Joining us from Atlanta, Georgia. We saw you a moment ago. Here you go.
I am. Well, good afternoon, Chair, members of the committee. It was my pleasure to work with her on this bill. My name is Tom Rawlings. I'm a child welfare law specialist attorney and a former juvenile court judge, former child welfare ombudsman, and was for 3 years the director of Georgia's Division of Family and Children's Services. I think important for this, I drafted the 2009 bill in Georgia that will, of course, comply with the Federal Child Abuse and Treatment Act that requires child welfare agencies to release child abuse and neglect information on children who have died or suffered a near fatality. I'm really glad to see this bill for a number of reasons, and they're really similar to what we experienced in Georgia. In addition to, of course, wanting to make sure we continue to get federal captive funding, we had about 3 factors that motivated our putting in this bill and making it part of Georgia law. First of all, of course, all child welfare systems are reviewed by national organizations. We had been reviewed by a national organization on the issue of child welfare transparency and had been found wanting, quite frankly. So no state wants to get a bad report card. Secondly, our agency's position at the time that it could not reveal any information about these cases really caused a lot of public distrust. These cases are usually in the news because a child has died or has been seriously injured, and someone has probably suggested to a reporter that they need to find out what the child welfare agency's involvement was, whether or not they dropped the ball, et cetera. So the child or the parent's name is often already in the media, and you're not protecting anyone by keeping the records confidential. So transparency in these difficult cases is very key. And this is what I think this bill promotes.
Excellent. Thank you very much. Questions from the committee? Sure, Senator James.
Tom, I just want to thank you for all your help and support, and thank you for taking a moment today to testify here virtually in Maryland. I'm so glad the virtual technology we have allows you to be here.
Well, thank goodness for that.
Yeah.
It's been a pleasure to be with y'all.
Thank you.
Excellent. Thanks a lot. Thanks for joining us.
Thank you. Bye.
Thanks. Have a good one. All right. Next, we'll hear from Mr. Kroll.
Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, and Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since 1984. I want to thank Senator James for his support. This was not easy, and we really worked hard. And I just told Senator Carter, when people work together, good things get done, and that's what we didn't hear.
Okay.
Members of the committee, this bill allows us to be in correspondence with the federal law. That's the first thing it does, which entitles us to state funding and federal funding. But more importantly, that it allows us to be, I guess, for lack of better words, if we look at the IID, which you just voted on yesterday, it allows us to disclose things that we can when it comes to things that are not confidential, to make sure that people of all races, creeds, color, religion across the spectrum get their voices heard. What I mean by that is, if it's a case where social services involved, we can disclose certain things, and Senator James and I have gone over things like that. So in other words, we can disclose certain information while protecting confidentiality. This allows us to do it. It keeps us in line with the federal law, which is this federal funding. And more importantly, it allows people to have some sort of confidence in what we're doing as prosecutors. So thank you again, Senator James, for working with us on that. We'd ask for a favorable report with the amendments as to Senate Bill 631. And I'm happy to answer any questions if I can.
No, thank you very much for seeing the questions of the committee. I'll just take a moment to say, look, we always talk about like when we have a bill. I've never heard of this issue before, but this is a good case study of how this should actually work. I always talk about being radically inclusive, but one of the biggest leverage points you have as an elected official is the ability to convene, getting people from across the nation, across the state to come together, address someone that may have a natural pushback or it may be initially in an adversarial position, bringing them into the fold, getting people together, working something out. This is exactly how lawmaking should work. And this is a great case study of being radically inclusive, convening people, taking the time, working stuff out. So awesome. Thank you very much.
Thank you. I just say I hold myself out to this committee, and as we worked here, willing to work with anybody in order to get good things done.
I'm giving
Thank you.
Senator James a credit on this one. Now he's a crawl. I'm kidding.
Thank you.
All right. All right. Seeing no further questions, that'll end the testimony in the hearing for Senate Bill 631. We'll now move on to Senator Carter, Senate Bill 759. Senator Carter, you're up.
Good early afternoon, Chairman Smith and members of the hardest working, longest serving late at night committee in the world, the Judicial Proceedings Committee. I'd like to bring up my panel, Ava Levine, Monica Cooper, Beth Tomasello, and Vanita Taylor. Mr. Chair and members of the committee, those that have been here, you've heard this bill before. I think this is a bill that ideologically we all agree is a very good bill. I think that some of the stumbling blocks in the past were the fact that the Women's Pre-Release Center has not yet been built. But this bill honestly ought to pass even without that center being built, because that center is to be built. And when it is built, then it will be able to house these women and make sure that they bond with their children. And so Senate Bill 759 will establish space at the upcoming pre-release facility for women who give birth while incarcerated to remain with their newborns up to 1 year postpartum. This bill will also establish a Healthy Start bonding program to facilitate relationships between mothers and their children. This bill will house women and their babies at the upcoming pre-release facility. While the pre-release is yet to be built, we are hopeful with the new governor that the Department of Public Service will avoid delaying this process any further. It is critical that we pass this bill now to ensure that space is designated for women and their babies as the construction process occurs. I don't think you really need to hear that much more from me. I think you should hear from the advocates, and you should consider the persons that have lived experience. I think this is such a common sense bill. I have written testimony, but the bottom line is that we know every issue that we deal with when it comes to human beings is that the start of their lives, the initial bonding with their mother, both inside and outside of the womb, that first year of bonding is critical to making sure that we have healthy, happy human beings that are well adjusted and can flourish in society. That is something that is not me saying it, but we all know that's true. And so it defies logic that we would not move to making sure that children born to women that are incarcerated are able to bond with their mothers at least 1 year post-birth. We don't want to have children ripped from their mothers that are incarcerated and put into the foster care system or the social services system. Oftentimes these mothers, when their children are ripped from them, they don't have any place for their children to go. And they are put into the system, and that is never a benefit for the child or for society or for the mother. So for these reasons, I would truly urge a favorable report on this bill. It's not premature. I think that it's long overdue. So with that, I will let the advocates talk. Thank you.
Thank you, Senator Carter. I couldn't agree more. And I know we received a letter from the Department of Corrections, but it would be beneficial to hear from the Department of Corrections, especially on the status of the pre-release center, because we've had money allocated for several years now, and Still no groundbreaking, still no. We actually even had, preliminary hearings in this committee about the status of it. So it would be, it would be nice to hear from them on this, and we'll definitely follow up. But thank you, Senator Carter, for bringing this up. Go ahead. Thanks. Thank you
Okay,
very much.
great.
Welcome.
Thank you, Chair Smith, and all the members of the committee for making the time today. My name is Ava, and I am a senior at Johns Hopkins University. I'm also here with Monica from the Maryland Justice Project, and along with all the other advocates, I'm here to ask that this committee issue a favorable report on this critical bill, SB 759. I know the other advocates here are going to touch on the emotional and biological benefits that this bill will provide in keeping women and their babies together, including skin-to-skin contact, breastfeeding, and mental health benefits for the mother. Simply put, to take babies away from their mothers is inhumane. But more than that, I want to touch on some of the logistical issues surrounding this bill and what I expect might be a point of concern for both the committee and DPSCS. So as Senator Carter has already mentioned, while the pre-release facility has not been built yet, it is currently in progress. Monica and the other advocates in this state have been fighting to get the facility built. In fact, we have a hearing later today to talk about funding. And we are hopeful that with this new administration, action will be taken promptly. It is critical to pass this bill now because as the state builds the pre-release facility, we have an opportunity to include beds for mothers and their babies now instead of adding them on later. In 2020, there were 17 pregnant women sentenced to DPSCS facilities and 11 live births. This is not a problem that can wait for a facility to be built. Babies are being taken away from their mothers as we speak. We must take action now. At least 16 other states operate some variation of a prison nursery program. These programs typically operate in the low hundreds of thousands of dollars annually, from approximately $180,000 in New York to $500,000 in Missouri. I already know that DPSCS has suggested that this bill will present a substantive cost for the state, but let's remember that DPSCS has an operating budget of nearly $1 billion each year. More than that, the money to fund this program can likely be found in existing DPSCS budget surpluses. For example, in fiscal year 2023, DPSCS returned $11 million to the general fund. We could use that money for this program. Finally, I want to emphasize that the benefits of this program, regardless of the cost, will prove well worth it. You cannot attach a price tag to a human life. Thank you for your time.
Wow, give Ava a hand. She did good. She did really good. My name is Monica Cooper, and I'm urging a favorable vote on this bill, the Executive Director of the Maryland Justice Project. As a formerly incarcerated woman, I saw firsthand the devastation caused when a pregnant woman was separated from her child. I also witnessed the successful outcomes of the Tamar program. Tamar's Children was developed in 2001 as a multi-agency collaboration to provide comprehensive inpatient and community-based support for justice-involved pregnant and postpartum women who have co-occurring mental and substance use disorders with trauma histories. One of the program's most successful persons is Annapolis's own Tonia King. Tonia had more than 80 arrests on her record. She was abused by her pimp, suffered a horrific substance abuse disorder, and found herself sleeping under bridges. Her final arrest landed her in the pregnant program for justice-involved women, Tamar. The birth of her child, the opportunity to bond with that child, but more importantly, having access to services such as mental health, substance abuse, psychotherapy, sexual abuse therapy, and more, gave her the opportunity to turn her life around. Adding this program at the new pre-release facility for women will allow the participants to raise healthier, more resilient children and will help to reinvigorate their lives. This bill needs to be passed so the construction of this new facility will incorporate a wing dedicated to children and mother success post-incarceration. For my last 30 seconds, I would like to say that so far we have seen that the Department of Corrections does not have the will to build this facility. They have returned funds. They have failed to implement funds that were already earmarked for this. So we know that they don't have the will. So to receive these hefty price tags for legislation that agencies don't want to pass is something that really needs to stop. It's a one-way street when you hear the Department of Corrections say it's going to cost us $1 trillion to do this and that. I'm hoping that moving forward, that process actually gets changed, because lofty price tags on legislation that folks want to fail should not be allowed, period. Oh, thanks. Drop the mic.
Okay. And drop the mic. Well, good afternoon, Senator Smith, Chairman Smith, and committee members. I'm here from the Public Defender's Office. I'm Benita Taylor, and since 1991, I've been representing parents in child abuse and neglect cases. I'm here to say that this bill is a necessity. You have done. You first did the equity bill regarding equity for women, incarcerated women. Then you did pre-release center for women because there's not one in the state of Maryland. And then the third thing you did was the brick and mortar, which is yet to be built. We don't know why, but yet to be built, even though you did pass funding. Now, the fourth is programming. We now know that without programming being mandated, that it is really up to whoever's running the facility or to the wardens to decide what happens and what doesn't happen. This way, we will ensure that women who have children while they are incarcerated are allowed to bond with their children. In the cases that I'm involved with, the child abuse and neglect cases, a woman could have a baby and be there for no reason. If she has no one to come and get that child will go into the foster care system. And if that child is in that foster care system, 15 out of the most recent 22 months, the Department of Social Services under CAPTA, which was already discussed, has no choice but to file for a termination of parental rights. So we have a woman who, only because she's incarcerated, will permanently, forever lose their child. This type of legislation allows them that 1 year to bond with their child, that 1 year to have a close relationship with their child, and stops termination of parental rights. But it also encourages this bonding that even if a child is placed with a relative, we find that it's difficult for relatives to get to the various facilities in order to bring the children to visit with the parent. We requested this bill be passed, and that is common sense legislation.
Good afternoon, Chair Smith and members of the committee. I'm Beth Tomasello, past president of the Montgomery County Women's Democratic Club, and we're here in support of the Maryland Justice Project and all incarcerated women whose babies have been taken from them. As a mother, I find this absolutely horrifying, as do the rest of us at the Women's Democratic Club. Far too often, this state willingly spends taxpayer money on carceral practices that data clearly identify as having negative outcomes. And one of those practices is the unjustifiable separation of incarcerated women and their infants. WDC's written testimony includes citations to research and data on the uniformly harmful consequences to women and their infants that result from forced separation. Forced infant separation causes stress, depression, and anxiety in the mothers, and this cruel practice also leads to the continuation of intergenerational stress, mental health problems, and low academic achievement in the children, particularly those who end up in the foster care system, which is costly in many, many ways to the state. It is also one more way that incarcerated women are treated unequally and their needs are unmet by the Department of Public Safety and Correctional Services. Our only concern with this bill is that we think it doesn't go far enough. We would love for this bill to be amended to say that all women convicted of nonviolent crimes, not just those in pre-release, can remain with their infants for the first year postpartum, regardless of the time left on their sentences. We also would recommend amending the bill to require DPSCS to find temporary community-based housing for incarcerated mothers and their infants until the department finally fulfills its statutory obligation to build the Women's Pre-Release Center. The DLS analysis of the DPSCS capital budget indicates that DPSCS will not complete the Women's Pre-Release Center until 2027 at the earliest. The damaging practice of separating incarcerated women and babies must not go on for 4 more years. Thank you very much.
Thank you very much. Good to see you, Beth. Yeah, see you. All right. Questions from the committee, the panel? All right, seeing none, thank you all very much. Good to see you all. All right. Is Jason Billingsby here? Kiana Johnson? And we have 2, if not, we have 2 virtual participants, Alexa Richardson and Carolyn Mast. Kiana Johnson. If you could, just before you pipe in, if you could if you have the YouTube feed open on a different tab, if you can mute it or close it down, that'll prevent the feedback through the system. All right, Alexa Richardson, you're up first. Welcome.
Great. Thank you, Mr. Chairman, members of the committee. My name is Alexa Richardson. I'm an attorney with the Parental Defense Division of the Office of the Public Defender and a midwife. OPD urges a favorable report on SB 759. Forcibly separating newborn babies from their mothers just days after birth harms babies, mothers, and the state. In the first hours after birth, babies learn and attach to the sound of their mother's heartbeat and voice and to her smell. The documented results of separating babies from their mothers include developmental regression, difficulty sleeping, depression, and acute stress for babies. Babies separated for more than a week in the first 2 years of life exhibit higher levels of aggression and negativity by ages 3 and 5. Early separation may lead to long-term chronic medical conditions like cardiovascular disease, hypertension, obesity, and decreased longevity when compared to babies kept with their parents. Babies separated from their parents in the first 2 years of life score significantly lower on IQ tests. They're nearly twice as likely to be arrested or criminally charged and more likely to have alcohol and substance abuse disorders. These children also experience higher rates of depression and suicide attempts and poorer educational and behavioral outcomes. Conversely, strong data shows that keeping new babies with their mothers, even while incarcerated, has significant rehabilitative effects for the mother and resulting in secure bonds for babies with their mothers and lowering rates of recidivism down the line. No one wins when new babies are forcibly separated from their mothers who want to care for them. OPD urges the committee to make a favorable report on this bill and join the growing number of states that keep mothers and babies together in the prison setting. Thank you for your time.
All right, thank you very much. Now we'll move on to Carolyn Mast.
Hi, good afternoon. Thank you, members of the committee. My name is Carlin Mast. I'm a licensed clinical social worker and current social work supervisor at the Maryland Office of the Public Defender's Parental Defense Division. Prior to my position with this agency, I was the inpatient perinatal social worker at a hospital where incarcerated pregnant people gave birth. OPD strongly urges the committee to pass SB 079. The devastating impact of early disruption in the maternal-infant bond is well documented and readily available. Children are collateral in the system. Today, I'm not here to discuss the impact of this horrific separation solely on infants and children. I'm here to tell you firsthand what that separation looks like on a human level. For a newly postpartum and incarcerated mom, the bliss and magical moments of the immediate postpartum time often have an undercurrent of grief. Parents know that when the discharge papers are signed, they face the horror of leaving the hospital in shackles without their newborn. Can't begin to describe to you the sound of a newly postpartum person being forcibly separated from their infant. It's a sound that stays with you forever. It's guttural and jarring as it should be. It's unnatural to separate a new mother from their child. When I worked with incarcerated postpartum people leaving the hospital, I would often have to beg correctional officers to allow them to take a photo of their baby back to prison. These mothers are left with nothing as they discharge from the hospital after birth. They leave the hospital to go back to an empty prison or jail cell. They leave only to endure the postpartum time, the leaking of new milk coming in or managing of a C-section wound with nothing to show for the grueling work of pregnancy and birth. It's demoralizing and quite frankly, a human rights violation by many standards. Simply put, it's cruel and we look away. This act would attempt to address this horrific reality. It's not a cure-all, but a necessary step in the right direction that a growing number of states are adopting. It would facilitate preserving the bond between a newborn and its mother. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you all very much. Thanks for joining us virtually. With that, that'll conclude the testimony and the hearing for Senate Bill 759. We'll now move on to Senate Bill 760. Senator Carter. Senator Carter, you're up.
Good afternoon again, Committee Chairman Smith and members that have joined us and new members. I'd like to bring up my panel, which consists of Nicholas Peros, Steve Amate, Dr. Keith Williams, and John Pica. If you're here, you can come up and have a seat at the table. Thank you. So while they're coming, Mr. Chair, I want to make this clear because we know that there's a reticence with the idea that there's a new idea or an exotic idea. We're slow sometimes to move on something that's a brand new concept. I was reminded by an article on March 7th yesterday in the Baltimore Sun that goes into details about the importance of this bill, that it was first 2005, when I was in the House of Delegates, that I first sponsored a version of this bill. I abandoned the idea for many years because I didn't feel that the General Assembly was ready for it. But I do think that this is time now because we've now dealt with massive police reform. We know that security guards in many instances are first responders to important it's a public safety measure. And so basically there's no consistency right now in Maryland for security guard certification. With that, I'm going to go briefly into my testimony, and then I'm going to, of course, try to be brief so you can hear from the persons that I think are more expert in this area and why we need this bill. Senate Bill 760 requires an individual who provides security guard services to be certified as a security guard. It regulates certain security guard employers, and it alters certification and renewal standards for security guards. In Maryland, if an establishment employs security guards, they are most likely unlicensed and unregulated. If the establishment contracts with the private security agency, if an establishment contracts with private security agencies to provide security services, security guards are required to have a Maryland State Police issued license. There is no training requirement in either situation unless a security guard applies for a handgun. There is also no tracking requirement regarding a security guard's use of force. Senate Bill 760 will change existing Maryland law by establishing minimal standards for oversight of private security. It will require all security guards to be licensed, and it would establish minimum training standards, a curriculum that teaches appropriate use of force, de-escalation tactics, and basic criminal law. It will also require security guards and security agencies to report to the Maryland State Police when force is used against an individual. In the past 2 years, 3 people have been killed that we know of by security guards in Baltimore City alone. Of those security guards have been charged with murder. There are other uses of force that did not result in the death of an individual, but otherwise resulted in harm to the public. For example, a stun gun was deployed on a woman in a wheelchair. Perhaps those uses of force would not have occurred if security guards had been subject to minimum training standards, a curriculum that teaches appropriate uses of force, de-escalation tactics, and basic criminal law. None of these uses of force were required to be reported to anyone. And so absent some type of media report, we simply are unaware of these kinds of incidents. There is currently no accountability when a security guard uses force against someone other than possible criminal charges when the force used is grossly excessive. Being a security guard or officer is a very public-facing job that will necessitate all types of interaction with the public. Sometimes it's a friendly hello, an ID check at an entrance to an office building, but other times it can be more tense interaction. For these reasons, a trained security professional should be the minimum requirement for safety to the public. Last year, in one of the incidents in my district at Reisterstown Road Plaza Giant, there was a security guard that wound up shooting and killing a young man because he didn't have on a shirt, because he was shirtless in the Giant. He was also with his girlfriend, or reported his girlfriend, a woman who was shot in the hand and not killed. Whatever resistance this young man did, he was unarmed, and a security guard shot him and killed him. I believe very strongly that we have to create uniform standards for security guards. We have to give them training. This is only common sense. especially as many of the people in this committee have liked to talk about the lack of law enforcement. Security guards are often first responders, and they ought to be professional, they ought to be trained, and they ought to be certified. And so for those reasons, I would urge a favorable report. Thank you very much.
Excellent. Thank you very much, Senator Carter.
Good afternoon, Mr. Chairman, members of the committee. John Pica on behalf of the National Association of Security Companies. We had a hearing yesterday in the House. I thought it went fairly well. Right now in this country, 43 states regulate security guards, 26 states require training, and 6 states require the training of proprietary guards, those who work for large companies. I was surprised to learn that not all security companies are required to carry insurance, and some actually resist and don't have insurance. So if you have less than 4 security guards, there's no requirement under Maryland law that you need insurance or that you're required to obtain insurance. These companies are here are the largest in the country. One is the largest in the world. They all have to carry an insurance policy of $1 million. We also heard had some interesting questions in the House, like we expected, and we're open to working with the committee and working with amendments. So I submitted 7 amendments, and for the benefit of council and Ms. Pop, I created a reprint with the amendments in them. So I'll hand those over to Ms. Pop after the committee. If you have any questions, I'm happy to answer them.
Excellent. Thank you very much, Mr. Pica.
Thank you.
Thanks.
Chairman Smith, members of the committee, my name is Steve Amate, and I'm the Executive Director of the National Association of Security Companies, NASCO. NASCO is the largest contract private security association in the country, and in the state of Maryland, NASCO companies employ over 6,000 licensed and trained security officers. For decades, NASCO has worked with state legislators and regulators around the country to put in place effective laws and regulations for licensing and training of security officers, and that is what brings me here today. NASCO is very supportive of the 3 underlying common sense public safety first premises in Senator Carter's SB 760. 1, all employees performing security services anywhere in Maryland, whether through working for a contract security company or working directly for an establishment or business, should be required to be licensed and vetted by the state. 2, all employees performing security services in Maryland should be required to complete appropriate security service related training, including use of force training. 3, all employers of security officers should be required to have insurance to cover any harm or damages that may result from the actions of their security officers while performing security services for that employer. There's no doubt that working as a private security officer is a very public-facing job that will involve all types of interactions with Maryland residents. Sometimes they are friendly interactions, as the senator said. Other times they can be a lot more tense. Simply put then, if the goal is to put in place measures that can both decrease use of force incidents by security officers and create more transparency and accountability related to such incidents, then what better way to attain that goal than to require all security officers in Maryland to be licensed, vetted, trained, and insured? And there's no doubt Maryland residents will benefit from there being more better trained security officers in the state. There's still some language in SB 760 that needs to be modified in order to effectively and implement its fundamental provisions, and NASCO looks forward to working with the senator and others to make these improvements and pass this common sense bill that will lead to greater public safety and the welfare of Maryland residents. Thank you.
Good afternoon. I'm Leon Beresford. I'm employed by Admiral Security Services as the Senior Vice President in charge of operations throughout the United States. Admiral Security Services is the 9th largest security company in the U.S., and we're privately and family owned and headquartered in Montgomery County, Maryland, with our Mid-Atlantic Division office in Baltimore, Maryland. In addition to my position at Admiral, I represent the security industry as a board member of NASCO, and I'm also the chairperson for the ASIS International Security Services Council, which focuses on issues related to security providers, particularly security guard companies. ASIS International is the preeminent professional association for security companies and practitioners in the United States and around the world. I have 35 years of experience in the security industry and 3 separate industry board certifications. Admiral Security and the security industry supports common sense legislation to ensure professionalism and accountability in the industry. We've advocated and provided training for many years. It's incredulous that currently security guard companies and the proprietary employers of security guards are not required to provide any training to their unarmed security personnel in Maryland. Many companies will not provide training unless they're required to. We believe training is imperative. It's the reason why I've hired individuals like Dr. Keith Williams and his team to lead our training department. We also understand the importance of being properly insured if you're engaged in providing security services. Responsible companies embrace maintaining appropriate insurance. Unfortunately, not everyone and not every company shares the mindset and commitment of my company and fellow NASCO members, which leads to the degradation of the profession, the industry, and service provided to the end users. We need minimum standards, accountability, training, and insurance for all entities that provide security guard services to safeguard end users, the general public, and others. We support Senator Carter's SB 760 with the slight modifications as articulated by Steve Amate. Thank you very much.
Good afternoon, Chair Smith and committee. Thank you for the opportunity to speak in support of Senate Bill 760 by Senator Carter. I'm Dr. Keith Williams. I'm currently the Vice President of Support Services for Admiral Security Services. As Mr. Beresford said, Admiral Security is family-owned and Maryland-based. Prior to coming to Admiral Security, I was a 27-year member of the Metropolitan Police Department in Washington, D.C., where I retired as a commander. One of the assignments that I had was as the commander of the Police Training Academy and the Office of Risk Management in the Office of the Chief of Police. I received my doctorate from American University, and I instruct classes at George Washington, Catholic, and American universities. Most importantly, I'm a lifelong Marylander. I grew up in Prince George's County and Calvert County. I currently reside in Anne Arundel County. This bill, thus, it's very vested in me, both professionally and personally, to have security officers be trained and vetted. We come here in support of this common sense approach to the bill, in part. In my current role, I oversee training and quality assurance component at Admiral. We understand the importance of training, and our basic training for all of our security officers is part of our corporate culture. We ensure that all our new officers receive training on such topics as uniform and appearance, laws and regulation, conflict management, and customer service. The basic level training ensures that the security officers are prepared for their role in security. It is then followed with mandatory on-the-job training at the respective sites. This is currently not required by the state, thus not implemented by many companies, which was a shock to me when I changed from policing to private security. We then use our quality assurance management program to inform training of any trends or issues encountered by our operational personnel. Many companies do not take this step, and this bill will help ensure that all security agencies take this training responsibility seriously. The reporting of uses of force by security officers is a positive undertaking. With no current mechanism to report or investigate uses of force, citizens, businesses, and security agencies are in the blind of what's going on with uses of force in private security. We thank you for your support, and Senator Carter, thank you.
Mr. Chairman, good afternoon. Senator Carter, good to see you again. And my senator, Mary Delaney James, good to see you again. So I want to kind of personalize this a little bit because my colleagues have laid this story out pretty well. I'm a regional vice president for Allied Universal. We're the largest security company in the entire world, 850,000 employees worldwide. In my stead in the Mid-Atlantic, I have 5,000 security officers on the street every day, 100,000 hours a week of service. With that, 3,500 are Marylanders who live and work in the state, and we provide extensive training, just like my colleagues at Admiral and several others. Our concern is very much like the senators and others. If you would ask people in your district if they can believe that a security officer in the state of Maryland is required to have zero training, with the exception of some firearms training if they're armed, I don't think you could get 10 out of 10 to agree that there's no standards in place at the time. We already do this. But we're looking out for our reputation as companies as well, as stated before. We're good people. We employ a lot of people, but we want them to be professionally trained. And when we get somebody from another company, we want to ensure that at the least the minimum they've had is the minimum state training, which right now we don't have that. So when they come to us, we have to start fresh right from the beginning, as though they were never trained or never employed here in the state. So that I came from the Maryland State Police. I was a major. I was in charge of licensing for a period as a lieutenant. I did all the licensing for security guards, private detectives, and handgun permits. So if the committee has any questions about the backside of that, I'm certainly available to answer those as well. Thank you for your time today.
Thank you all very much. We have a couple questions from the committee. Senator West is up first.
Thank you, Mr. Chair. This seems to be an incredibly well-prepared, well-presented bill. And it appears to me that the entire industry is at the table. Is there any key player in the security industry that is not at the table and not prepared to support this bill?
Can we answer from the table, or do you want to say first?
You gotta go to the podium.
There's over 1,000 security guard agencies in the state of Maryland.
Right.
When I left, it could be many more now. So yes, there's going to be some players that are not here, but the National Association is here.
Well, that's my point.
And two of the biggest players.
The organizations that represent the industry are here and they're supporting the bill. And I'm a little surprised that the retailers are not here, but I guess their absence suggests that they're not opposed to the bill. So I want to congratulate the sponsor. I think this is a fine bill. Thank you.
I was actually going to say the same thing. We've got two today that have been really well prepared and we researched and kind of fleshed out. So I know we've got some forthcoming amendments that the sponsors worked with some of the stakeholders with. So good stuff. Further questions from the committee? Senator Carter.
I apologize for making a comment. It's not my question. I can make it a question if it needs to be. So I had mentioned that I had sponsored this bill in 2005, and often when you see a bill like this and you see industry people, the question arises, how does this affect minority businesses and the ability of young people that are not necessarily college graduates or whatever to get into the industry? But what I think is significant is that when I first brought this bill in 2005, it was brought by a minority-owned security company that employed young Black men in Baltimore City. And he felt very strongly that it was critical that security guards, even in his business, would have this training. He felt that it would be better also for his status in terms of liability to have trained individuals. And so I want to make it clear that I think this is good for everybody, not big business, small business, but the public at large. Thank you. Isn't that so?
Yes, it is.
Yes, it is, Senator.
If I could just make one more statement. So speaking to your point, I've been in this industry for over 35 years. I know that my first paycheck was $3.85 an hour. So that tells you how long. And I've worked for a variety of different companies here. And I'm saying I worked for some companies that did not have these standards, and it was not a pleasant experience. So I don't look at this just for the end users and for the companies. We want young African-American men and women that are entering into this industry as I did, living in an impoverished area, single mom. We want them to get good training. We want them to be treated properly as well. So I think we need to look at that constituency as well when we look at this bill. So thank you.
This is excellent. Thank you very much. This is great. 2005, did you say? That's persistence right there. All right. All right. Let's hear from, we have one virtual witness. Are they here? Yep. All right. Mr. Avnet, you're up. Welcome.
Hey, thank you. I appreciate it. And thanks for taking the time to listen to me. I've been in security for about 25 years. I have 15 years prior policing, and I own a smaller licensed security company in Maryland. I do support this bill. I just want to talk about the practicality of it. Although I fully support the training requirements and insurance set forth in this bill, there are some issues that I'm concerned with. We provide security officers with hours and hours of training because it reduces liability and increases professionalism. This bill, I believe, requires all security officers must be licensed prior to starting work, not just training. So this is somewhat problematic because currently it can take anywhere from 2 weeks to 3 months to get a security clearance card back. Although this is no fault of MSP because they only have 2 or 3 troopers working in their section, this brings into consideration how enforcement is going to work. Currently, we get many security guards who come from other agencies, some of them very, very large, that are not licensed. Currently, there's almost no enforcement with security agencies, which brings in the question of how MSP will enforce licensing for all businesses that use in-house security guards or bouncers. The implementation concern on how MPTCT will deal with this large influx of training requirements on each security guard is also concerning. Although this bill does not, additionally, this bill does not grandfather in the thousands of currently licensed security guards into certification. So if all of them require this new certification, it's going to create a logjam in licensing. This bill also does not designate the difference between armed and unarmed security guards as far as training requirements, and there probably should be additional training requirements for armed security officers. I also feel that this bill probably should exclude prior policemen that have left in good standing. They go through 6 months of service and years on the street, included in-service training, so they're very familiar with the laws. So for these reasons, I ask you to consider these types of amendments, please.
All right, thank you very much. Questions from the committee? All right, seeing no questions from the committee, that'll end the testimony and the hearing for Senate Bill 760. We'll now move on to Senator Waldstreicher with Senate Bill, what? 676.
Thank you, Mr. Chairman. Members of the committee, as you know, at this very moment in another committee, the General Assembly is working to legalize adult use recreational cannabis. We are on track to join 21 states in the District of Columbia in doing so. One of the obvious issues being considered is how to avoid a potential deluge of drugged driving following legalization. Yet there's currently no nationwide consensus on how to accurately determine whether drivers are under the influence of cannabis. Unlike alcohol, cannabis, alcohol is water soluble and dissipates as you sober up, but THC is fat soluble, meaning it can linger in the body for weeks after the psychoactive effects have faded. Simply put, there is currently no such thing as a cannabis breathalyzer, since there's no precise biological factor indicating whether someone is impaired by cannabis at the moment that they are tested. This has led to a hodgepodge of legal thresholds and procedures for prosecuting drug drivers nationwide. However, there are some cutting-edge technologies being developed to solve this problem. For instance, some firms are developing a device that would test the individual rather than a biological sample. The allegedly impaired driver would take a short cognitive test on a device about the size of a laptop that measures impairment. This technology has already been cleared by the FDA to test impairment in other circumstances, like looking for signs of dementia or Alzheimer's in patients, but has not yet been approved for purposes of roadside testing for impairment due to intoxicating substances. More testing is needed on these potentially promising technologies, and that's why I've introduced Senate Bill 676. This legislation would establish a pilot program to conduct further testing of the cognitive device, as well as any other promising technologies that can help make Maryland's roads safer. Under this pilot program, local jurisdictions can voluntarily participate and receive training on the use of cannabis impaired driving tests. Once trained, these officers can request that individuals suspected of cannabis impaired driving take a roadside cognitive test. Crucially, these tests would be entirely voluntary, and the results or refusal to take the test would not be admissible in any court proceeding.
The anonymized data from these tests would then be compiled and submitted as a report to the General Assembly by 2025. With adult use recreational cannabis on the horizon, we must act now to ensure safety and accountability on Maryland's roads. Consumers, law enforcement, the cannabis industry, and other stakeholders are currently in a state of legal limbo. Senate Bill 676 would be a huge step towards modernizing our state's drug driving policy. I respectfully urge a favorable report.
Thank you very much, Mr. Chairman, members of the committee, and the Vice Chair for this opportunity to testify today. I'm here in support of SB 676, which, as the Senator said, is designed to help make Maryland's roads safer by helping local police better screen for intoxicated driving or impaired driving. I'm currently Vice President of VS Strategies, and before that, I was a longtime state Senate staffer in Massachusetts, and overall, I've been very involved in cannabis policy for about 6 years now. And maybe the hardest question that comes up time and time again is, what are we supposed to do about impaired driving after a state turns to adult use? And why this is such a difficult question is, as the Senator just hinted at, scientifically, there's a bunch of reasons why blood, breath, or other biological tests don't work the same way for cannabis as they do for alcohol. THC affects different people differently. It stays in the system for a long time. It is consumed in many different ways. So the unfortunate reality is that THC levels in a person and actual impairment of that person are not perfectly correlated. A long time there weren't great answers to these questions, but thankfully technology is starting to catch up. And that's why we're here in support of SB 676. There's excellent tests that are being developed, including by Kristen's company, who's going to be speaking next, CogniView, that tests for impairment of the driver rather than a specific level of cannabis in a person's system. So she's going to talk a lot about who they are and what sort of things that they do. But we definitely think that this is the way to help keep Maryland's roads safe going forward, because the important thing is to make sure that we are able to identify who's impaired and get those people off of the roads. And this is I see my time's running out, but probably the best way of doing that going forward. So I'll turn it over to Kristen and let her talk a little bit more about the CogniView machine and how it will work going forward.
Thank you. Thank you, Mr. Chairman, members of the committee and Vice Chair. As I was introduced, Kristen Weber. I am the Director of Strategic Accounts for CogniView, the company that Dan was referring to. We are a cutting edge medical device company driven by state-of-the-art technology and research and software. We've been working since 2005 in hospital systems, physicians' offices, research, and other medical environments as the world's first FDA cleared and only FDA cleared computerized test for cognitive function. Simply put, our test was designed for one and only one measure, and that is to measure cognitive function and whether a person is impaired. The technology is based on 15 years of research and a grant from the National Institute of Health. And we received our FDA clearance in 2015. As mentioned, it's a computerized device where the subject is taken through a 5-minute series of cognitive exercises versus question and answer. And that will measure their cognition. Over the past 18 months, we've been testing and fine tuning our device to understand its application in this environment of drug impaired driving. We know that THC can't be measured like alcohol. It's not about recent use. It's about, is that driver impaired? CogniView is the first technology solution that tests for impairment in a driver while in addressing public safety, but also balancing fundamental fairness for those who may be using marijuana responsibly and legally. In addition to our clinical research and our internal development, we want to further be able to partner with law enforcement agencies and government agencies to further validate the application of our technology within real world settings.
and to adapt to the needs of the Maryland residents. Thank you.
Thank you very much. We've got a question from Senator West, but also, do you have the device here? It's a laptop sized.
The clinical version, so the website version is smaller, but the technology, if anyone wants to test it, will be the same. So this is what's in hospitals and doctors' offices.
Well, you're not going to get anyone here to test it now, but no, I'm kidding. I'm kidding. Right after lunch, I don't know. No, I'm kidding. Kidding. All right, Senator West will has a question, but then I'd love to, if you could show us just a little bit, show us the device, that'd be great. All right, Senator West.
Thank you, Mr. Chairman. So I think it was 2 years ago, Senator Kagan and I both went down to Montgomery County to the police training center. And we spent the better part of a day there observing, they had recruits who frankly liked smoking marijuana. And they were in a tent out back and they were given all the marijuana they wanted. And as the day went on, they got happier and happier, let's say. So what we were there to observe was how the policemen were trying to tell them to put your head back and touch your nose and things like that. Frankly, I was totally unimpressed that any policeman really, if I were the judge, there's no way I could find beyond a reasonable doubt based on the testimony of a policeman who'd done that kind of stuff, that the person had indeed been under the influence of marijuana. I just didn't think it worked. But the point I'm trying to make is this was all done in a controlled setting. It wasn't done out on the highways. This bill seems to suggest that you want to do these pilot projects by stopping people out on the roads and asking them if they'll participate. Why do you want to do it on the roads as opposed to in a controlled setting like that?
And I'll let Kristen jump in at points, but we have been doing it in controlled settings as well. There've already been a number of studies. They've been working in green labs. Kind of the next step in testing this is trying to work with our law enforcement partners to make sure that there's things that, make sure that it works for them, trying to get it involved in, things that might pop up in a real world setting that you wouldn't think of in a controlled setting.
There might be some danger in doing it out on the highways and pulling people over on the side of the road and say, we want you to be part of a pilot project to test this. And don't worry, it's never going to be used against you in court. Wouldn't it be easier to have people who volunteer to participate, who sort of like taking marijuana and wouldn't mind spending a day getting high?
And I guess we're trying to do both things simultaneously because there are, one of the things that, isn't thought of first when, if you're not involved in law enforcement at all, but you're going to have this tablet. This is the clinical version, obviously wasn't built for size to be on the side of the road, but the tablet's going to have to be built into the, built to the car so that it can't be, used as a
By the
weapon.
way, I did get tested in the lobby. They had some device that looks sort of like that. And we sort of spit onto it and then they put it in and it did its thing and then it spit out some results.
So this is actually drug agnostic. It actually just does impairment. Why I think, and under the pilot program, other technologies would also probably be eligible. Why CogniView is one that we're highlighting and thinks it may be the most promising is it's actually an FDA cleared device that's in hospitals and doctors' offices right now to test for dementia. But the things that it tests for are, it's like.
So if I can just address the senator, so.
Come up to the podium.
Sorry.
Yeah, I just wanted to address your points are very, very good points. So there's two parts to it. And we're doing clinical research in green labs that are doing exactly what you're saying. We've done it where we do baselines, we get people high, we do blood testing, the cognitive testing, and DRE evaluations, which is what you're talking about, the 12-step DRE evaluation.
Right.
And measure these subjects over time, multiple times, to see how THC goes through their system and how they go from non-impairment to impairment and then recovery. What I think we're really talking about here is there's also the practical application. We get a lot of questions from law enforcement officers about the application in the field. So we're doing IRB. IRB is a regulatory agency that oversees clinical trials. We're doing another one. We're participating in one just in the next couple months in Colorado, working with CDOT. on a legislation that they had passed. And that is an IRB regulated study doing exactly what you're talking about. But there's a next step, which is, can the law enforcement officers use it in the field? It can work in a lab. And then the next step is, but is it practical for the law enforcement officers to use in the field? And what do we need to do? Like Dan had mentioned, some of the concern was anything that a subject can hold onto can be used as a weapon, right? So how can we make it safe for the law enforcement officers as well? Meaning, does it need to be actually mounted somewhere in the car so that they can't get their hands on it?
Got you. Thank you very much.
Very much, Mr. Chairman, and thank you all for being here today. I think of one of my friends now, Senator Kramer. I wish he were here because that has been one of his issues, and it's been an issue for me. One, how do you know the difference? I can blow an 08 and how do we protect people? And that was our problems with sometimes voting for and sometimes not voting for marijuana in terms of our recreational blah, 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 because of the public safety side. I did support it because the other side outweighed it. If you were to go on with this project, would it be a way of knowing where you actually perform these tests, which neighborhood, what you will hear most? Let me just be right out what you'll hear most of. As long as it's not in all black people's neighborhood and brown people's neighborhood, make sure that it is equity, because some places where you're going to try and stop people, they're just not going to stop. But secondly, nothing to come out of this, say this started as a test, but then they were belligerent and on and on and on, because I want to support our police officers too. And I'll tell you why, because I want to make sure that whether they are doing the test or the one being tested, that everyone's safe in this. And that, so I would I think I'll pass it. I mean, I'm sure I will. I might take the test too, I will. But my point is, yeah. Right. Yeah, this I can see if it works, but I wouldn't really know, right? But I support this 100%. I want to make sure it's equitable and it's fair, because we have nothing. And I'm seeing more horrific accidents than I've ever seen, ever, where people have got to be going more and more 80, 90, 100 miles an hour. And you didn't do that off from alcohol. Something else happened. And these have been statistics that we have traced since we've legalized. We got around one problem, but developed another. And I think this could very well be the answer to make us feel good about what we do, knowing that people who take advantage of it, it's not that we didn't contribute to that. So in asking that, does this measure, what does this actually measure again?
So this, or I don't know if you want to take this, but first to your point, I had this up in Senator Kramer's office yesterday.
Oh, good,
So
good.
so his staff got to play
That's a
around
good
with it.
office to be in.
Yeah. And yeah, so this doesn't measure any, and I guess, and to your other question about where this will be rolled out, the bill is big. We just want to work with law enforcement partners that want to work with us. Like this is at this, so it's all voluntary. So if there's a certain county or municipality that wants to, try this out, or whose police officers are interested, we will partner with them. And then for your last question of what this measures, it doesn't actually measure anything it doesn't measure what's in your body. It's a screening to whether or not you're able to be driving or not, based on your cognitive functions. So it kind of goes at the front level, because one of the things that I wasn't thinking about before, but if you set per se limits for all these different substances, but somebody takes a small amount of a lot of them, they may actually be below the levels for all of them, but very intoxicated. So if you were someone who has a 0.07 alcohol, but also consumed cannabis and took prescription medicine, they might not be able to be driving, and they would probably fail this test. And we'll say, hey, there's something in their system that we need to look at because they're impaired. But it kind of gets around being totally reliant on just testing to see when this is, because as I think everyone's mentioned, it's been hard to find that for cannabis and for other
Mhm.
drugs other than alcohol, because it matters when you're, if you're a patient who's using every day, you might have low levels of THC in your system all the time, but you may not be impaired. If you're a first-time user, you may have only a low level, but you'll be very impaired. And so this helps try to screen for that. So I don't know if you had anything else to add on that, Kristen. Or what
Yeah,
else
it,
you test
it
for
measures things like reaction time, processing speed, decision-making, executive function, even inhibitions that are impacted by that. So different domains of the brain, and then the speed parameters are not measured by other cognitive testing, which is one of the advantages.
It's
that
not
we
the
have.
first time we've done testing, in terms of them. If you don't have a breathalyzer, you have to walk straight, you have to see what your balance is, and that's been enough for us. So I understand now how.
And the beauty of it is, I think, to your point about the evaluation of a human being administering a test to another human
Right.
being. It removes that bias because it's a self-administered test. They sit, they take it. So that interaction of a human asking questions and getting an answer or asking them to do something is not in the picture.
Thank you for hearing my long explanation and for answering my question, but I needed that. Thank you very much. And thank you, Ms. Chairman. Okay. Great.
Mr. Chairman, very interesting. And one of my staff did take the test, and I wanted to, but I didn't have time. I sort of have three areas of inquiry. One has been touched on by Senator West and a little bit by Senator Muse, which is the whole idea of pulling somebody over, which I think is always a risky endeavor. Not only risky because you're on the highway and you're asking someone to come over, and there are a lot of accidents that occur on the side of the road. So putting somebody on the side of a road, you should have a good reason. So I guess one thing I need to understand is the way this is going to be set up, the police will have to have a reason to pull you over. And the reason has to be a concern that you are you're impaired. Although I don't see it in the bill. I assume that's the assumption in the bill.
Yeah, let me clarify. I think it may be in the bill. It's page 2, line 10 through 14. So just, I wasn't sure if Senator West was saying this, but just for clarity, there's no random pullovers like, hey, pull over. I'd like to voluntarily have you take this test. As line 10 on page 2 says, a police officer in a participating jurisdiction who has reasonable grounds to believe that an individual is or has been driving or attempting to drive a motor vehicle while the individual is impaired by cannabis may request that the individual complete a cannabis impaired
So
driving.
may I stop you? Before you go on?
Yeah.
So we currently have a criteria for police officers to pull over somebody specifically suspected of consuming cannabis.
Well, I think you would see some, I'll defer to Senator Fulton on.
Because
how
I
this
think
works in
we don't.
practice.
To be honest with you, I think it's whether a person is driving erratically, you might suspect they're under impairment, but I don't know if we have trained police officers or even could ask a police officer to make a predetermination. I'm pulling that individual over because I believe they're impaired by cannabis, and this law
see.
requires that they have that
Right.
belief.
I see the distinction you're making. We can kind of take this offline, but yes, I think you're right that an officer would not be able to tell why that person is impaired, only have reasonable suspicion that the person is impaired.
Right,
and
so
that-
I would suggest that that has to be changed.
I think that makes perfect sense.
And then I guess the other line of questioning I sort of have is also sort of alluded to by my two colleagues, which is about setting up this pilot, which is really sort of a data collection experiment in the field. And in the bill, I don't see any criteria for how data is going to be collected, any continuity there, any training required, not just for administering the test, but for what you are learning. I don't want to get into it a lot, but you all know about how to do a controlled experiment. And I don't know how you're going to capture data that is useful to you in terms of when somebody consumed, if they consumed, what they consumed, what dosage or strength it was, and then tying all that into the efficacy and accuracy of this test. So it seems to me that you could say, well, we'll work that all out, but I would suggest the bill at least requires a provision that says the parameters and all the requirements for quality data collection that will be useful, because we will be empowering you to do something. The government's going to empower you all to put a test in the field. And it seems to me we should benefit from an enormous amount of information, and we should require that we get it in the way that we think would best help us and is scientifically credible. And whether you want to say that that has to be in the bill, that you need to lay all that out so that it's everyone knows what you're put into the field and that there's some approval process. I think the way it's written now, it could be a useless endeavor, a ambiguous endeavor. You could get all kinds of not useful information, ambiguous, contradictory, and so forth. I won't belabor the point, but I think you're following my thinking there, right?
If I can just share, so some of the things we've done with the trials, first of all, our technology, we have a cloud-based portal that any data that we want to extract, we can pull from that portal, and it can also be tracked. So from a law enforcement perspective and studying perspective, over time, you can actually watch and measure the people that have been put through this process. And typically, now let's be clear, this test does not tell us that someone has a chemical in their system. It says that they're impaired. That would be cause for the more invasive blood test, which has been controversial because it's just you're randomly doing a blood test. But for what you're saying is you need that data because you want to compare, did they pass this test and how much THC, alcohol, whatever they have in their system is based on the blood test. So I think you'd want to correlate those things. That's what we did. We did the cognitive screener, we did the DRE evaluation, and we did blood testing. So that when someone was impaired, we knew what substances they had in their system.
All I'm telling you is I think this bill is lacking in this area, and I think it'd behoove all of us that we work through that, whether it's through a requirement that it be worked out in regulation, but also some approval by us as to whether we think you've done or created the experiment in the right way that will get useful information, not only for you, which you certainly have an economic incentive, but we have a public safety incentive and a good government and good policy incentives. And none of that is in the bill so far. So I understand that it's impairment, and we won't know the nature of the impairment and whether to tie it to cannabis without people providing you voluntary information, unless a law enforcement officer decides to take it to the next level and do some other physical tests. And maybe you wouldn't be able to determine cannabis, but you could rule out other substances perhaps. But all of this is not well communicated in the bill, and I think it would need to be. And then my third area is really sort of like, what is the training protocol for law enforcement? Well, I have one other point. Impairment can be through, you might be nervous, you might have a mental or physical disability that's not readily obvious. I can think of a lot of other things. That's enough. How have you thought through how you're going to determine, and the person who takes the test may not disclose that to you. So again, I guess that's just another way to say that we haven't vetted and thought through how we would be able to collect valuable information. You might find out it's good at getting impairment, but it's good at getting cognitive impairment that has nothing to do with cannabis or something.
Yeah, so I think these are all really good points, and I agree that we could flesh out more of this bill, especially in all the parts that you talked about. It's left vague somewhat intentionally we were planning on trying to partner with a law enforcement agency, and we would want to, the thought was that depending on what they wanted, how they wanted this program, like the pilot program to run, that we would flesh out the details then. But I think it makes total sense to add something to the bill that, lays out, the pilot program will involve regulations on blah, blah, blah to cover what this stuff is.
And that kind of leads just
And
to my last,
Oh, yeah.
I'm sorry, go ahead.
Oh, no.
No.
If you have another thing, because I was going to bring in Chrissy, because the technology, I think the big benefit to this technology over some of the other ones that are trying to come on the market at the same time is that this one's based on FDA cleared technology that's already being used in hospitals. And a lot of the things that you mentioned about screening out for other reasons why somebody may not do well on the test or maybe like struggle with certain aspects of the test are already kind of built in, and I can let Kristen talk a little bit about it. But if we, as you demonstrated, it kind of changes how it operates as you go through it. And like there's special, right now it's mostly used for seniors as they're looking at dementia and stuff like that. So there's a part where it takes in their like baseline motor skills and then adjusts for it, so that if somebody has like arthritis or something else that would affect their ability to use the machine, it doesn't hold that against them on the test, and they would still score just as well. Like it adjusts like that. So there's a lot of like smart things built into the technology, but I can let Kristen if she has any other.
Yeah, I just a couple things. So ultimately, impairment is impairment, and that's what we're measuring, right? Regardless of why. Ultimately, if you're trying to look if it's drug impairment, then there needs to be that ultimate blood test. Like you're not going to know it. This is a way to rule out this person is not impaired and they can go on their way, versus because it's a process. Then they have to take the person to a police station. They have to call in a DRE, do the 12-step evaluation, do blood testing after that. But blood testing a lot of times has to be done at the hospital. And by that time, their peak of impairment is gone. And that's what we learned. We originally wanted to use this at the station. We thought it would be safer for the police officer to not be on the side of the road. But what happened was in our clinical trials is that by the time that subject went through getting transported, this is what we learned from the way that that THC works through the system. By the time they got transported, by the time they went through a 45-minute DRE evaluation and then took the cognitive test, a lot of the THC have gone through their system, and it's not that same state that they were at when they were stopped. So it was scientifically through our research determined that it needs to be tested roadside. And we got feedback from law enforcement agencies too, saying it needs to be roadside. Because what they have a shortage of DREs, and they want patrol officers to be able to start that elimination process. If the person fails this test, they are then taken for further testing, which would include the blood test.
Well, that's not in this bill though. Right.
Right. Yeah.
So you're never going to get any of that here in this bill.
No, because this bill isn't designed to be used as evidence. It's like part of the data that we want to collect or help collect is comparing how this technology works with all of the other roadside tests that are going to be there. So if there was anyone, if there's a department that could look at this and say, hey, this might be a good screening tool that we could use for impairment, that all of our officers, whether or not they're trained as DREs, can use, like this might be a helpful tool that we should use, like they can use it and they can use it.
You mean you're not even trying to figure out if this is good as assessing impairment? You just want to see if a law enforcement officer can use this on the side of the road?
No, I think we're pretty confident that it measures impairment because it's been used to measure impairment in hospitals for a long time. So like we've done, or Kristen has done, and Kristen's company has done a lot of these studies. So like it's pretty confident that the technology measures impairment. The new move is right now it measures impairment in a doctor's office or in a hospital setting. The difficulty with anything that's happening here is transferring a technology that works in a clinical setting and trying to make it work in the field.
I think that's what I just asked you. I said, you're not trying to measure whether it assesses impairment, but whether it's a technology you can use, I guess, effectively on the side of the road. That's what you're trying to measure.
Yeah, sorry, I missed.
And has there been any collaboration with the state police or and law enforcement to get their feedback on this, or whether they, does any collaboration pre this bill?
I mean, we relatively new and starting here. We've started reaching out to law enforcement. We've talked to a few people, and we're continuing that effort to move forward with all of that. We have been talking to law enforcement in other states. As mentioned, where there's a Colorado study that's happening now. Colorado passed a bill on the same topic last session, so that's in the process. And now we're, looking here in a couple of other states to try to, find other partners that want to collaborate.
I'm sorry, so you're saying Colorado has this exact same bill and is
It's not
doing
the
it
exact
right
same
now?
bill. But it's a similar study bill that passed last session.
Thank
And they're in the.
It's actually a bill that does it for a clinical trial. It's not roadside. It's a clinic. It's a clinic.
Big difference. I was asking about roadside. right, thank you.
Senator Fulton. Thank you, Mr. Chairman. Thanks for bringing the bill forward, Senator, and thank you all for testifying. So I'm just going to ask, and I know that my good friend here from Harvard has been very diligent in her questioning, but so it doesn't measure any type of standard process. It measures the person's perception reaction time. It measures these other standards, I guess, that are input into this system ahead of time. Is that right?
It measures cognitive function.
Cognitive function, but somebody made a mention that there was measured perception reaction time and things of that nature. So there's got to be a measurable standard that's been input into this system to know what would be a reasonable perception reaction time for a standard human being versus an elderly human being who operates a motor vehicle versus a younger person, because a young person might be 1.2 seconds, a standard human being might be 1.5, and an elderly person might be closer to 2 seconds.
Correct. It's an algorithm based on that measures the different domains of the brain and then those speed parameters. And we've done, our FDA clearance, and a lot of our research that we've done sets normative ranges for ages. It looks at retest reliability. We just finished a 2,000 patient study that again looked at is making sure there's no learned effect, making sure that the normative ranges are all set for all ages.
Okay. And then is there any movement? So the problem with this whole issue is we've been so happy that Colorado has had a spiked number of increased motor vehicle related deaths from drug impairment. We went ahead and put this out and decided we were going to pass this legislation and allow people to legally smoke marijuana in Maryland. So that's great. But now we have no measurable standard. And this is what you're saying is the best thing we have. There's no measurable standard in this system or anything that I'm hearing that is going to reference the THC is being measured in the body, because THC on a blood test just says it's present or not, right?
Correct. But what we found in our studies is that as Dan was saying, every person is different, and it's not like alcohol. If I'm 0.08, you're 0.08, you're 0.08, we know that you're impaired for driving. And
yes, it's a measurable standard.
Right. But per se limits don't necessarily apply to THC, because a person can be a regular user and not have smoked in the last couple of days, and yet they are still going to register 5 nanograms.
Yeah, but now we're talking about nanograms, which is the only measurable standard that anybody has, which Colorado still uses. Correct?
Correct. They're looking to move away from that, but yes. Part of our study is for that reason, is to stop measuring use and presence of a drug in someone's system and move towards, looking at impairment. And as I said, there would be a blood test again following this test to actually rule out just impairment by some other cause that's not drug related or alcohol related.
Okay.
Yeah, it's still probably, not where the breathalyzer is. Like, the idea is hopefully that you have a screening tool, and if they show impairment and then they also show that they have THC in their system, you're starting to put together that there's a decent chance that they're impaired from THC. Whereas it's been hard. Maybe the science will.
And there's nothing that requires them to submit to this though, right?
No, not.
So on this, you could just be like, you know what, I don't want to take it.
Yeah, I mean,
and then what's the recourse? I'm just asking, if this becomes, they're moving away from nanograms because it's a standard measurable or a measurable standard issue because it stays in the body longer after usage. You have a program like this, the person doesn't want to take it, there's still no measurable standard. So
you were talking about the being able to refuse in the pilot,
Yeah.
not.
That's just for the pilot. Like, eventually, if everything.
So you're saying
turns
that
out
this
well,
would become a part of a standardized testing practice if the pilot went on, that if they refused, it would be considered a refusal, like refusing a breath test, even though it's subjective to the data inputs, not anything out of the human body from the inputs to the body.
So Yeah, I mean, I think that would be another piece of legislation that would be down the road. I think this is just a pilot program.
Okay.
That wouldn't be used as evidence, wouldn't be used, like, it's not solving the problem. It's just hopefully a tool that will.
Oh,
push
there's
the
no solve
solution-
anytime soon.
Push the solution.
There's no
closer,
solution.
Yeah.
Okay, thank you.
And just to your point, this is also a way to gather that information, look at who is impaired, who is not impaired. And if they are impaired, getting that blood test, and we can actually track and measure that failing that test and the nanograms to even support the idea that per se limits may not necessarily be the right method.
Thank you.
Senator Meese. Thank you. Just the scope of this, this legislation is limited, and that's a good thing, in that it only gives you the permission to conduct the test. Is that right? Anything else that comes after that is not on you. It's whether or not we as a state determine that your data is enough for us to want to move ahead with something, because right now we have nothing. So I want to make sure that I have the scope of it right, so that my questions were right. This does not go beyond you're having decisions. Yes, we'll choose this company or not. You're simply saying we have something that will help. Will you all at least let us do the test? Beyond the test, you're not responsible for anything else unless we come back and say, this is great, we can use it. What's the next step? So I want to make sure that my questions were relevant, and two were not, as I understand this information as being, for testing purposes only, so that we can have some alternatives to choose from.
And this does not rule out clinical trials. We're doing the controlled clinical trials. The theory is that roadside is not a controlled environment, and that's where eventually it would be used. So you have to do both.
You can't use without legislation
Right.
from us because of what it entails to pull someone over and be able to do that. Great, this is great legislation. It's a start. It's a first start. I don't know where we're going with it, but I know we need to go someplace in order to reduce the number of deaths and all else that we have. So thank you. Now that we know the scope of it, we know what to do. Thank you. Thank you, Ms.
Thank you. No other questions. Thank you very much. This ends this bill hearing. Next, we shall have Senate Bill 569, Senator Folden.
Sure. I thought I had a panel coming up here. We'll just move on. You guys are gonna kill it anyways. It's from the wrong side of the aisle. Yeah. All right, well, I'm gonna go ahead and. You want to just go ahead and go do yours and I'll check? Okay, all right. Mr. Chair, members of the committee, for the record, Senator Folden, Frederick County District 4. Before you today is Senate Bill 569, dealing with correctional services, murder diminution credits. Currently in the Maryland law, if you're convicted of second-degree murder, you are ineligible for diminution credits. You were required to serve half of your sentence, which is 20 years. Under our current law, if you are convicted of first-degree murder, you are given a sentencing guideline of 30 years, which you are eligible to have a hearing for parole at halftime, which would make it 15. And under first-degree murder, you are currently able to accumulate diminution credits, which means you could be eligible for parole for first-degree murder in about 10 and a half years. I will tell you, I will repeat that again. If you are convicted of second-degree murder in the state of Maryland, you have to serve half your sentence. You are not eligible for diminution credits, which means you have to serve 20 years. If you are convicted of first-degree murder, you are eligible for diminution credits, only serve half, which is currently at a 30-year frame. So you serve 15, you're eligible for parole with diminution credits around 10 and a half years. This is a problem. This is not the way the law is designed to be. And this bill puts in the idea that we will remedy this issue and not allow anyone convicted of first-degree murder. It would give it parity with second degree, that you would not be eligible for diminution credits after a conviction of first-degree murder. That's it. That's how simple this bill is. And I can't make it any more simple for you. So I think it's the simplest bill of the session, but I'm sure somebody's got a question. And with that, I would ask for your favorable report on Senate Bill 569.
Senator James, it's not coming on?
The difference
Yes,
is,
it was through when we did the initial part of, I guess, I don't know, the Redeem Act version 1 point something, where we did something to alter the sentencing guidelines, and there was an oversight that allowed persons to be eligible for diminution credits that were convicted of first-degree murder. And in the guidelines, in my opinion, it was meant that both were not to be eligible for diminution credits, because I don't believe that anyone that if you murder someone and take their life, you should at least have to serve half your sentence. And there was an oversight in that, and it got through. And this was brought forward by members of the state's attorney's office, the Maryland State's Attorney Association, who were concerned about this. And this is an effort to resolve that and give parity to first and second degree murder, to not make second degree murder a harsher penalty, but to have them both have the same parameters.
I get it. I'm sorry, just because I wasn't here, when do you think that, I just wanted to look it up. When do you think this?
It was
done?
after I'm gonna guess it would be somewhere between 2019 and 2022.
And
One
it was
of
a
those.
bill? Is it a bill?
I wasn't here. I got fired during that window of time.
Me too. All right, I'll try to look it up. Thank you.
You got it.
But I got reinstated.
You got it. I was
All right.
fired.
Any other questions for the sponsor of the legislation?
Second chance.
All right. And were your witnesses? None?
We're good to go. We'll just move on, Mr. Chairman. I'm sure we'll get a favorable committee vote on this.
Let's hear from the opposition. All right, Christopher Dews, Jason Billingsley, Adrian Muldrow, and Judith Lichtenberg.
Maybe this one tells me.
You can come on up and if I called your name and have a seat and testify in the order that I called your names. You can go ahead and just go ahead and stand at the podium.
Oh, good afternoon, and thank you for allowing me to testify. I had a chance to talk to the senator in the hallway.
And for the record, would you please state your name?
I'm sorry. Good afternoon again. My name is Adrian Muldrow. I represent Tame Advocacy. Had a chance to talk to the senator in the hallway, but even after thinking about it, when you look at diminution credits, even if you don't have diminution credits, when you come out on parole and probation, you're still going to have parole and probation based on diminution credits. So in my opinion, I just believe that if a person gets convicted for first degree and doesn't get a life sentence, still should have an opportunity to earn diminution credits, because, you know, at the end of the day, when they go in an institution, they're gonna have nothing to lose. So that's going to be the worst inmate in the institution, because, you know, anything they do, they can't earn no good time at all. So if you get a situation where there are culpability issues, and you get a first degree sentence and it's not a life sentence, and someone gets 50 years, that's 50 flat years. And think about this, diminution credits, at the end of the day, even if you get them or you don't get them, that's a part of how parole and probation, that's what they guide and use to determine how long you're going to be on parole and probation based on the diminution credits.
Thanks. My name is Judith Lichtenberg. I'm Professor Emerita of Philosophy at Georgetown, and I'm on the Executive Committee of the Maryland Alliance for Justice Reform, and I'm a constituent of Senator Alonzo Washington. Most relevant, though, is that for the last 7 years, I've been teaching, tutoring, and mentoring at Jessup Correctional Institution and at the DC Jail. I teach college courses in philosophy, mostly for credit under the Second Chance Pell Grant program. And I've taught many students with first and second degree murder convictions. Based on my experience, I strongly oppose this bill. And, the senator, if I understood him correctly, and I didn't realize this till I heard him, the problem is that there's this disparity. Second degree murder people can get diminution credits, but first degree, no, the other way around. Well, there are two responses to that. One is to say that neither should get them, and the other is to say that both should get them. And I think that's what we should do. We know that prison education reduces recidivism rates. The idea that students who are getting GEDs do not get diminution credits doesn't make any sense. The idea that people who have jobs in prison don't get diminution credits makes no sense. As the previous witness just said, refusing people diminution credits reduces their incentive to change and their hope of ever going home. And just last week, a longtime resident of Jessup told me that without such hope, prisons could become more dangerous for staff and residents. So I think it's we want to prepare people for the community and do whatever we can to make them more likely to be different. So I think both first and second degree, those who serving both those sentences should be allowed those credits. Thanks.
Senator Folden, did you have a question?
Yeah, I just had a quick question. Well, I just wanted to say thank you for coming out, Mr. Muldrow. I wanted to ask you, sir. So, but Ms. Lichtenberg, is it Lichtenberg?
Yes.
I appreciate you coming out, and I appreciate, obviously, we have a differing lens on that matter, but I am looking for that parity. So I appreciate you coming out, ma'am. Mr. Muldrow.
Yes, sir.
I appreciate the dialogue outside, and I have to ask a question at some point here, so I'm going to close out with that. But I wanted to let everybody know that through our dialogue, I believe that you and I have a good understanding that we might be able to probably try to spearhead some type of effort in Baltimore.
Yes.
To try to find some other solutions.
I get your, the idea is obviously, if someone commits a crime,
it's accountability and
responsibility, but at the same time, just as the young lady just talked about that was just up at the podium, when a person goes into the institution and can't earn any good days whatsoever or on anything, you're talking about a person that's going to create some problems, right? Not only for themselves, but for the staff, right? And when you look at parole and probation, you only are on parole and probation based on your diminution credits. Because if you serve a sentence flat out, there's no need for parole and probation.
Well, this doesn't require you're still incentive because you're only required to serve half your sentence before you're eligible for parole.
But my question is, if we attack diminution credits now on this level, are diminution credits in the future going to be an issue?
You know what state we're in.
So I
you
but
think
at
that's
the end
going to
of the
happen,
day, I mean,
Mr. Muldrow?
I serve time, so I know how those diminution credits, that they mean a lot to people.
Okay.
And folks right to get those diminution credits from through Comar. They need them to go to camp, to go. So if I can't get my security status lowered, how do you think I'm gonna be a friendly person?
Well, and I would respond to that by saying there's a reason, if you're in there for a first degree murder charge, there's a reason that you're in and convicted of that charge. So I have a concern, and I have my perception on how things from my law enforcement background that says, you know, past behavior is a predictor of future performance. I would like to think, like we spoke about outside, that through education, like Ms. Lichtenberg was talking about, other trade programs, the skills that we try to put into the prison system would help bring a better product back out into
That
society.
person wouldn't even be eligible because.
Well, that's the bigger discussion though. That's the bigger discussion, is make them eligible. That incentivizes good behavior. Education, mentoring, coaching, all those things are important for brain development and responsibility and taking ownership. And then we create a better product at the exit. That's what we're talking about.
I agree.
Re-entry. So I look forward to talking to you and working with you, Mr. Muldrow. I really
Thank you.
appreciate you
Yes, sir.
reaching out to me out there.
Thanks for the time.
Thank
you.
All right, is Ms. Hilliard, is she, all right, there we are.
I know you weren't getting out of this without me testifying. It's International Women's Day. You have to be nice to me. Good afternoon, committee, acting chairperson, vice chair, members of the committee, Elizabeth Hilliard, on behalf of the Maryland Office of the Public Defender. I'm going to start by saying that we slightly disagree about the current state of the law. And I'm going to direct you to Correctional Services Article 7301 C or D. Sure. Correctional Services Article 7301 C or D, which currently requires that an incarcerated person convicted of a violent crime, which confusingly includes crimes of violence listed under 14101 and burglary first, second, and third degree, committed on or after October 1st, 2009, is not eligible for mandatory release until after that person becomes eligible for parole. And that currently impacts second-degree murder only. So it's not that people who are serving sentences on second-degree murder are ineligible to earn diminution credits. They can just not use those diminution credits until they're parole eligible, which is 50% of a violent crime. Yeah. The piece that impacts first-degree murder right now, because that is a mandatory life sentence under 2201, you must impose a life sentence. The same article, Correctional Services 7301, mandates that a person is not eligible for parole consideration until the person has served 20 years or the equivalent of 20 years, considering the allowance for diminution credits. So both parties are permitted to earn diminution credits. It's just that the person serving life is dictated specifically to 20 minus DIMS, whereas the person serving second-degree murder is dictated to whatever their sentence is, minus diminution credits. I didn't even get to talk about my points because I was explaining the law, but I will just quickly say that if you look to Correctional Services Article 3704, it articulates the 4 types of diminution credits that you may earn, and that we agree with the Office of the Public Defender agrees with the prior people who testified that it is very important to encourage rehabilitative, educational, and other positive behavior during an incarcerated period.
Thank you very much. Seeing no questions, that ends the hearing. We'll next move to Senate Bill 528, Senator Wallstriker.
Thank you, Mr. Chairman. And if I could have my first panel for this bill come up on Senate Bill 528 related to ignition interlocks. And in fact, I think we have an interlock device here. And if we have it, I'd love to see it so I can show the committee. Mr. Chairman, members of the committee, several years ago, this General Assembly passed the Drunk Driving Reduction Act of 2016. But those of us who were here know it better as Noah's Law, and it requires all individuals convicted of drunk driving to participate in the interlock program. This law was named after 24-year-old Noah Liotta. Noah's father is joining us here, who was struck and killed by a repeat drunk driver at a sobriety checkpoint. Since the passage of Noah's Law, we have prevented thousands of drunk drivers from getting behind the wheel. But unfortunately, the number of Marylanders killed by drunk drivers has remained stubbornly high. And this is likely due to a glaring loophole in Noah's Law. Almost 2/3 of Marylanders who go before a judge on a first-time drunken driving charge receive probation before judgment, what we call PBJs. Under Noah's Law, judges are not required to order an ignition interlock in such cases. That's bad policy, and here's why. Drunk drivers who have ignition interlocks installed after their first arrest are 75% less likely to have a repeat drunk driving offense. That's a huge number. I've introduced Senate Bill 528 in partnership with Mothers Against Drunk Driving to close this loophole. This bill will require all offenders to have an ignition interlock installed on their vehicles, including those granted PBJs. I've talked about this before, but when we started this process, when ignition interlocks were first becoming a tool in the toolbox to prevent drunk driving, they were really big and bulky. This is about the size of my phone. This is very small and very discreet. Yeah, this is very different than what they looked like when we started working on this issue more than 10 years ago. Currently, 34 states and the District of Columbia require all drunken driving offenders, to install ignition interlock devices on their vehicles. We're going to hear some powerful testimony today, and I hope you'll listen closely to the stories and experience of these victims, survivors, and family members. And if you do, I have no doubt that ours will become the 35th state to pass this important law. I ask for a favorable report. Thank you, Mr. Chair.
Mr. Chairman, members of the committee, my name is Kurt Erickson. I'm president of the Maryland nonprofit Washington Regional Alcohol Program. We're part of a large coalition that you're going to hear from today, all in support of this bill. There's a number of those that, however, couldn't be here, including AAA, Advocates for Highway Safety, National Safety Council, all in support of Senate Bill 528. You have my written testimony, so allow me to make just 4 quick points regarding said unequivocal support. One, and succinctly, as you already heard, SB 528 seeks to expand the universe of persons subject to Maryland's ignition interlock program to include persons put on probation for either driving under the influence of alcohol or driving while impaired by alcohol violation. 2, and according to the Maryland Motor Vehicle Administration, more than half of persons adjudicated for either DUI or DWI in Maryland in 2021 were granted probation in the form of probation before judgment, and therefore not subject to the full universe of public protections, namely participation in Maryland's proven effective interlock program. 3, and with National Highway Traffic Safety Administration data showing that interlocks typically are used as a condition of probation for DWI offenders to prevent them from driving while impaired by alcohol after their driver's license have been reinstated. And US CDC data additionally showing that interlocks reduce repeat offenses for driving while intoxicated by nearly 70%, 70. Senate Bill 528 looks to simply ensure public safety along that route used by half of persons arrested for drunk driving in Maryland by subjecting all 21902A and 21902B offenders to Maryland's interlock program as a condition of probation. In fact, 2020, and I don't want to steal from the administrator here, her point that she might likely make, but in 2020, MVA interlock program data showed that more than 6,000 drivers were prevented from driving after consuming alcohol just that year. 4th, and lastly, in a state where nearly 1/3 of traffic fatalities still involve drunk drivers, not using Maryland's existing and offender-paid interlock program for the full universe of DUI and DUI offenders, and the state is at best not using every tool in Maryland's toolbox to prevent drunk driving. To that end, we thank you for your consideration of favorably reporting this bill. Thank you.
Good afternoon, Mr. Chairman and members of the committee. For the record, Chrissy Nizer, MDOT Administrator and Governor's Highway Safety Representative. At MDOT we're very focused on reaching the legislatively mandated goal of 0 fatalities. And certainly we know that that includes education, it includes new technology, but it also includes looking at our laws to ensure that they are as appropriate and address any potential loopholes. We know each year in Maryland, there are on average more than 6,600 impaired driving crashes, resulting in nearly 3,000 injuries and 170 fatalities. Numbers are one thing, you're going to hear from the victims, and truly Vice Chair Waldstreicher said it best. I mean, they are the ones who can tell the story of the impact that lives for years to come. We know the legislation can save lives. We know ignition interlock can stop people from driving impaired. We also know that somebody arrested for PBJ has likely been driving many, many times impaired before having that arrest. I know MAD has a statistic, and I don't want to take that thunder, but 80 times potentially driving before that PBJ arrest. And we also know that MAD has given Maryland a scorecard of a C+. We're very high in many areas related to impaired driving, but this was this particular issue was rated as the largest loophole in the country, frankly, in terms of our law. We know, again, ignition interlock works when it's installed. For 2022, there were 3,650 attempts to drive while somebody was over a 0.08, but they had that device on their vehicle, and so it didn't start. There were other individuals who tried to start that vehicle 6,000 times when they had alcohol in their system. So again, the device works when it's installed. I just want to say that really this is about correcting behavior and trying to get somebody back on the right path. It is not punishment at all. It really is about how you get somebody back to being a safe driver. We know that 70% of participants are able to meet their requirements and finish participation within 1 year. And I think that tells that story of success. I just want to wrap up and say that I know there's some individuals from the deaf and hard of hearing community are here today. We've been having conversations with them in the last few months about ensuring that the program is as inclusive as it could possibly be. And I just want to publicly state my commitment to that and making sure that we continue to work collaboratively together to make sure the program meets the needs of all Maryland residents. With that, I ask for your support of the bill. Thank you. Did you want to do questions at the end?
We'll ask once everyone's had an opportunity to testify.
Hi, Mr. Chairman and distinguished members of the committee. Thank you for the opportunity to testify in support of Maryland Senate Bill 528. My name is Chris Swanger. I'm the president and CEO of the Distilled Spirits Council of the United States and the Foundation for Advancing Alcohol Responsibility, known as responsibility.org. Responsibility.org is a national not-for-profit organization funded by many of the nation's leading distillers and dedicated to eliminating drunk and impaired driving and underage drinking. For over 30 years, Responsibility.org has played a leading role to transform lives through programs that brings individuals and families and communities together to guide a lifetime of conversations around alcohol responsibility and offering proven strategies to stop impaired driving. Currently, as you've heard, 34 states and DC require ignition interlocks for all DUI offenders. We applaud Maryland's leadership for having one of the best ignition interlock programs in the country, but it does contain a very, very dangerous loophole that must be closed. A first-time arrest for a DUI doesn't mean it's the first time someone's driven drunk. You've heard that. It's usually the first time they've just been caught. Most first-time offenders meet the criteria for substance abuse or dependence. Unless and until these issues are addressed, they pose a public safety for our roadways. Responsibility.org supported Noah's Law in 2016, and we applaud the Maryland legislature for passing it and mandate that the use of ignition interlocks for convicted DUI offenders. Interlocks are the most effective countermeasure to stop drunk driving. It's time to ensure that every drunk driver, including those that receive a probation before judgment, receive an interlock. please support passage of SB 528. This bill is going to save lives. It's automatic. So on behalf of our industry and on behalf of the community, we're begging you. It's going to save lives. It could save a family member of yours lives. So please reflect and please pass this bill.
Good afternoon, Chairman and Committee. My name is Victoria Brown. Most people call me Vicky. I am with Mothers Against Drunk Driving. And I am here to ask for you all to close this loophole. My purpose for being here is something totally different because on May 30th, 2004, my life changed. On May 30th, 2004, a drunk driver hit my family and I doing approximately 125 miles per hour. That said drunk driver split our car in half. That said drunk driver killed my 12-year-old son. I like to say 125 miles per hour again, simply because it's something that shouldn't have happened, because this is something that's so preventable. My son was the sweetest kid you would ever meet. He was the son that was protective of not just his sister, but his mommy too. He was kind, he was giving, and he was loving. He was the kid that had the most big, beautiful, bright smile that you would ever see. He's the kid that I will never get to see again, though. I'll never get to hold him. I'll never get to talk to him. I'll never get to smell him. It's these simple things that I'll never have again because a drunk driver took my baby away from me. I am here to fight this fight, and I will continue to fight this fight. I ask for your support because if I don't tell the world who Darius Javon Brown is, then you'll never know, because a drunk driver took his voice because he took his life. Thank you, and I appreciate your support.
Thank you for your testimony. First, we'll go to Senator Folden, then Senator Muse.
Are we done with the panel? Okay, thank you. Ma'am, I want to thank you for coming forward today. It takes a tremendous amount of courage, and I know it's a way of honoring your son, and I'm extremely grateful that you're willing to take that, champion that on his behalf, Mr. Leota. For your son, as a police officer, I thank him for going into the rank and file, and I'm sorry, obviously, every day that we have had these type of terrible tragedies. So I do thank you all for coming forward today and representing your children that were lost. I just have one question. I don't know who can answer it. It might be the bill sponsor. Does Montgomery County still have the redo program for DUIs?
I don't know the answer to that question.
So I'm just going to put this out there because it's a program I've had a lot of issues with over my years in police work. And they used to, and I'm pretty sure, I think they still do. They had what's called a redo program where the first person, your first offense, if you went and did this little program or with them after your conviction, it would be wiped off your record. I've always advocated, as doing fatal crash reconstruction for over 20 years. I've seen and made these unfortunate notifications, and it's horrendous. And that program, I would like to see, it's in your county, Senator, taking the steps. This is a great step, and I fully support this measure.
Senator Folden, we have Robert Hill in the waiting room from Montgomery County who should be able to respond.
Okay, great. Thank you. But that would be a step as well that I would like to see us take effective steps to eliminate those type of programs, because they don't do a redo. They just give somebody a clean slate to go out and redo it again.
That's completely fair. This is the first I'm hearing of it.
Okay.
As you know, under state law, you cannot expunge a DUI. You can't even expunge a PBJ of a DUI.
This was a program that was put in place prior to, it was pled out in the courts, and then if they attended that program, it was gone.
Huh, okay. We'll ask
So,
Mr.
thank
Hill.
you.
Good question.
Senator Muse.
Thank you very much. I just want to say on behalf of this entire committee, not a question, but on behalf of the entire committee, we pray for you. We ask for strength for you. I know it's been a long journey, and any good that comes out of it will help to redeem
in a sense, not fully, but just to say on behalf of this committee, it's not falling on deaf ears nor hearts. We feel, we pray for you. We hope that we're guided to do the best that we can to make sure it doesn't happen. And that's why we work together to make sure, no matter what side of the aisle we're on, we're making sure that things like this won't happen again. God bless you and God be with you. And thank you for allowing me to say that.
Senator Kelly.
Thank you, Mr. Chairman, and thanks also to the panel for being here. I found your testimony very compelling and moving. I do have a question for the sponsor. If you can come back up, because I'm looking at my bill file. My heart is with this bill. My brain is with this bill. I'm a mom. I'm reading the opposition testimony from the Maryland Criminal Defense Attorneys Association, and they have some things highlighted. And I imagine, because I know you're good at this, that you can respond to their concerns. So they said that they oppose this. One major issue with the legislation is inconsistencies with penalty fulfillment under TR 16205. I don't know what that means, but they go on to say drivers who are unable to enroll in the interlock program will lose their right to drive forever. Further, this legislation creates an environment whereby all commercial truck drivers will lose their license and jobs after the case. Can you respond to any of that? I'm sure we'll be discussing that.
Yeah, I think the first is as to the fees. And Ms. Neiser can talk about this, but the MVA has done a fantastic job making sure that the fee reduction program, which waives the MVA fee for indigent Marylanders and reduces the charges by half that are the monthly charges associated with the interlock, are fulfilled. That program has always existed, but has been difficult to find through the website, through the physical MVA locations. And credit to Ms. Neiser, and she's welcome to speak on this if she wishes, for leading the department to say this is here, this is available. Those who are eligible for it should utilize it. As to the CDL impacts of this, I do not know the answer to that question. It sounds like Ms. Neiser can speak to that, but I know that if that is an issue, then 35 other states already have this. And so it sounds like there may be a solution to that. So.
Thank you for the question. I think there's been some confusion about this in the past. So just to be clear, an alcohol violation for a CDL driver, a commercial driver, has always been an offense under federal law, not state law, but a federal requirement that would take away a driver's license. So those requirements are already something that is pre-existing, not something that would be created by this bill. And I just want to add to Vice Chair Waldstreicher's comments that in addition to the indigent program, if somebody doesn't have a vehicle, because obviously that's part of the requirement being in the program, we do have a mechanism through which we mark their record. And then whenever they do acquire a vehicle, then the requirements of the program come into place. And so we have kind of looked at various circumstances, and we, again, want to make sure the programs is accessible as it can, because if it is a mandatory requirement, we need to ensure that people are eligible to get in.
Thank you, Mr. Chair. My question is also for the bill sponsor, and I may have to continue it if we have oral testimony later from Mr. Stam, because I'm interested in hearing him, because he's an expert in the DUI field in Maryland for law. But the 35 other states, do they have specifically, as Maryland has, which is the striking of a guilty finding with their probation before judgment, or is it just a first time probation? Do they literally have the equivalent of a probation before judgment for a first time?
We can certainly take a look. We know because of Senator West's bill that Virginia has a similar kind of PBJ structure, because we've discussed that in reference to his bill and immigration consequences. We will always have a debate in this committee about whether a PBJ is or is not a conviction, and its kind of strange existence in a legal limbo. But whether you believe PBJ to be a conviction or not a conviction, PBJs always have allowed conditions, and this is simply a condition.
I understand.
It's not a punishment.
I practice some in the area as well, and so the kind of standard protocol for a first time offense that where there's a PBJ, the conditions are usually kind of standard. Usually there's a period of probation. There may be, if it's supervised, there's a period where a person has to submit regular urine tests to show that they aren't drinking alcohol or abusing alcohol. They have to often do a victim impact panel. And, depending on the circumstances, some other things. But I think that, definitely, first of all, I want to be clear. I started off with you, Jeff, but Chairman, Vice Chair, but I definitely have empathy. I'm not trying to be without empathy, but I also feel like the most terrible circumstances, as we all know, sometimes can result in terrible law. And I am a big believer in discretion and judicial discretion in every single bill that we have. I believe in judicial discretion because I believe in individual circumstances, and they warrant an individualized response from a court. And so I did want to know the 35 other states. I want to clarify, do they have the equivalent of a PBJ, or is it just a first time and they do the probation? Because that matters, because if we're now saying this is mandatory on a PBJ, we are to some extent modifying the meaning of a PBJ. The second thing I wanted to address is when you talk about the statistics, is there data, and if it's in here, I apologize, but is there data regarding the amount of PBJs, specifically PBJs, that result in fatalities or a subsequent offense that results in harm to anyone other than the actual driver who usually harms himself or herself for driving?
We can see if we can get that data to
Thank
you from
you.
the Sentencing Commission or other source.
All right, thank you, Mr. Vice Chair. Additional questions for the panel? Seeing none, thank you all very much. All right, we hear from Nicholas Augustine, Jamie Derbyshire, Helen Morales, and Richard Leota.
Good afternoon, committee. I'm Assistant Chief Nicholas Augustine, representing Montgomery County Police Department. Thank you for the opportunity to testify in support of Senate Bill 528. In prior positions, I was a detective assigned to investigate fatal motor vehicle collisions. Far too often, it was my responsibility to notify families of the death of their loved one. The script is still etched into my mind today. I still recall the emotional response from each notification I handled, including a mother. This was her second child killed in a motor vehicle crash. Many of these notifications could have been avoided as the death was a result of impaired driving. In 2022, 32% of fatal motor vehicle collisions within Montgomery County involved impaired driving. So far in 2023, the fatal motor vehicle crashes in Montgomery County, the majority are related to alcohol impairment. We have the technology to ensure drivers that have received a PBJ do not get behind the wheel after consuming alcohol and risk the safety of the community and themselves. A CDC and NHTSA study found that laws requiring ignition interlock for all offenders were associated with a 26% fewer alcohol impaired drivers in fatal crashes compared to states with no interlock laws. I ask for your favorable report to help us ensure the safety of the community. Thank you.
Good afternoon, Chairman, Vice Chair, and members of the committee. I'm Jamie Derbyshire, a police officer with Montgomery County Department of Police. I've been fortunate enough to speak before many of you in years past regarding impaired driving issues. Realizing that many on the panel would discuss the statistics, proven reduction in recidivism, and benefits of ignition interlock, I was hoping to bring a more personal story to you. A good friend of mine has struggled with alcohol addiction for the majority of her life. She's been sober for a number of years now, but I distinctly remember that she was required to get an ignition interlock device on her vehicle. I was grateful at the time that there was protection for her and equally important protection for the general community. It wasn't until the other day that I actually asked her what she thought about the ignition interlock. She said that it was a very important aspect of her recovery, perhaps the most important. When I first asked her if it helped her, she told me that it did. I followed by asking her, do you think it helped the general community? She was puzzled, and I clarified and said, were there times where you attempted to drive and the interlock stopped you? Times when you knew you could have compromised your self-safety or the safety of others? And she admitted that it happened often. It wasn't until the end of our conversation that she shared with me that despite the embarrassment and the inconvenience of the device, that she in fact left the interlock in place for a year longer than what was required. To her, it was a safety blanket, a reassurance to herself that she would choose sobriety and a normal life, and a commitment to herself and others that she would not drink and drive again. She informed me that her only regret was that shit was not required of her earlier. In life and in my profession, I have seen these devices work. I've seen them not falter when logic and common sense have. I've seen them hold people accountable when judicial systems and law enforcement have been unable to do so. After 20 years in law enforcement, I know that we need to be asking one another what actions most help the community. As someone with an addiction, my friend never thought about the community. It's my job and yours to think about these things when others can't or won't or are unable to. Interlocks change lives for the better. They are a commitment to our community that we can offer protection that we all deserve. I respectfully request that you provide this bill with a favorable report. Thank you for your time.
Good afternoon, Chairman Smith, Vice Chairman Wallstreicher, and distinguished members of the committee. My name is Alan Morales, and I'm a sophomore at Eleanor Roosevelt High School in Greenbelt, Maryland. On behalf of Students Against Destructive Decisions and the 23,856 members of SAD across the state of Maryland, I rise to urge swift passage of Senate Bill 528. My fellow students and members wish me to convey their desire to see this measure advance as a sensible and necessary countermeasure to curb impaired driving. For over 40 years, our organization has worked with a broad coalition of stakeholders to end impaired driving. Mr. Chairman, this committee has heard and will hear from individuals who have been affected by this preventable and insensible crime that's affected our communities, our families, and our society of incredible individuals taken from us at the hands of an impaired driver. You've heard from prosecutors, law enforcement, and legal experts who have foretold why Maryland will benefit from this bill. I add yet another powerful voice to that chorus, the voices of the future, we as students of the great state of Maryland. As the future leaders of Maryland, we want Senate Bill 528 to become law, to be assured of the bright futures that we deserve, protecting ourselves, our friends, and our communities. This measure makes critical enhancements to the existing law. Ignition interlocks work, period. When a young person makes a deadly choice to drive impaired, they do so from a place of need. At SAD, we empower teens to make positive choices, one decision at a time. We understand the value of a personal choice. When one chooses to put others in harm's way, there's a need to rise up and protect the public good. I'm tired of parents losing their teens to something completely preventable, and I'm sickened by the amount of lives lost to impairment. I know you all join me in grieving with each mother, father, brother, sister, teacher, or community member who wakes up with that pain. Senate Bill 528 has the power to prevent that pain and continue to make our roadways safer for us all. I urge you to vote yes in advancing this measure. I thank you for your time and consideration. Thank you.
Seems like Groundhog Day for me. I've been here many, many years talking about this measure. I'm Rich Liotta, and I'm the father of Officer Noah Liotta, who was killed by an impaired driver in December of 2015, as he was trying to protect us from this exact same crime. Now, I wake up every day, and my wife and I were talking about this morning, about how hard it is. The grief doesn't change. It's there all the time. And I could go through all the statistics and so forth, because I know 2/3 of the people in this room will be impacted by impaired drivers in their lifetime. I know that 30 people are going to die every day at the hands of impaired drivers. And I know what the intent of Noah's Law was when it was passed, because I was there. And the intent was that it would prevent all, it would be used for all people that were found guilty of impaired driving. That's what it was for. It ended up to be not only guilty, but it dropped out the part of conviction. In other words, if they're not convicted, if you had a PBJ, that's where the loophole resides. So rather than go through any more, what I ask you to do finally, think about the citizens of Maryland. Think about all the victims of impaired driving. Think about your own families. Will this make a difference? Will this save lives? Forget the damn cost. What's the cost of a human life? What's the cost of Noah's life? If you don't do something, and if you don't do it now, what you have not done year after year,
And that's why you say it's Groundhog Day. This will be the same result for others in the state of Maryland. This is Noah's resting place. Let's not make this something that happens to others in this great state of Maryland. Do the right thing and pass this bill for once and for all and save lives. What would Governor Moore do? He would pass this bill. Thank you. Thank you for your time and your consideration.
Thank you, Mr. Chair. I got a question for Mr. Morales, if you can go to the podium for me. Just first want to just say, have a quick comment for you. You did an excellent job. You're a very impressive young man. And you're a great representation of Prince George's County Public Schools. And we really appreciate you.
Thank you so much.
And my question for you though is, where is Roosevelt High School? Is that in District 22 in my district?
Yes, it is.
Okay, that's all. Thank you.
I'm glad Mr. Morales is a Prince Georgian, so he'll be running for my seat anytime soon. Questions from the committee. So say thank you all for being here, and Mr. Liotta, thank you for your continued work on this issue and your tenacity. You and your family have been just fantastic. I remember the first time you came forward with this with Noah's Law. So you are no sunshine patriot. You've been here for a long time. So I appreciate your work. Thank you for being here again. All right. All right. Seeing no questions from the committee. Thank you all from the panel. Thank you. All right. We'll now move on to, is Frank Harris here? Michelle Westfall. Vicky Porter. Lenny Stam. Oh, sorry. I'm sorry. Lenny, wave off for a second before we switch over. Is Vicky Porter here though? All right. Okay.
Mr. Chairman, members of the committee, my name is Frank Harris. I'm the Director of State Government Affairs for Mothers Against Drunk Driving. I just want to clear up a couple points here. Maryland is one of 34 states plus DC that already requires the use of interlocks for all convicted drunk drivers. As was noted, they're not required for PBJ agreements. And Mr. Chairman, to Senator Carter's question, there's roughly 10 states that have laws that mandate the use of interlocks for the state's equivalent of PBJ, but no state is like Maryland. We're going to other states to make sure that interlocks are a condition of plea agreements, because we know plea agreements happen. We want to make sure an interlock is a common condition, just like VIPs and other things are here in Maryland. Drunk drivers, they continue to drive drunk because they can. Judicial discretion, the best argument for judicial discretion over the last 38 years is 500,000 deaths from drunk driving. And that's not all because of judicial discretion, but it doesn't help that the laws aren't equally enforced. And here in Maryland, drunk driving is still a big problem. It's gone up during the pandemic, while traffic stops have decreased dramatically. And we need to do more. This legislation is that more, and it fixes that glaring loophole. And it was mentioned that there is an indigent program already here in Maryland. Many states don't have that. Maryland does, to make sure that this is inclusive to all folks. And I understand that we are missing another sector of people who might not have the full access to this device, and that is the deaf and hard of hearing community. And we support any type of actions to make sure they are included and that these devices do serve that community as well. Because there should be no excuse that an ignition interlock device is not installed. And again, this legislation is about one thing, saving lives. And we want to make sure that it's available to all Marylanders who are granted a PBJ. And Matt urges a yes vote on this bill when it's brought up for a vote. Thank you.
Good afternoon, everyone.
I'd like to introduce myself. My name is Vicki Porter. I am a board member of the Maryland Association of the Deaf. As well, I am serving secretary for the Maryland Advisory Council for the Deaf and Hard of Hearing. We advise the Governor's Office of the Deaf and Hard of Hearing on various issues related to deaf constituents within the state of Maryland, as well as hard of hearing and deafblind constituents. I am here today in a personal capacity, however, because I've had personal experience with some issues related to the ignition interlocking device. What I'm going to go ahead and do right now is use my speaking privilege, okay? So I'll transition to that.
Okay, so as I mentioned, I've had personal experience with the IEP program. My husband, he's hard of hearing. He was convicted of double DUI, and he was given a choice to join the IEP program. So he did that, but from the start, it was a lot of issues with accessibility. For example, the vendor did not provide closed captions with the training videos, did not provide interpreters to explain how the device will accommodate with the car, and also how to teach them how to breathe, because it was very hard to hear how you're supposed to breathe in the device in order for you to work and start the car. So he had to learn like that. But the biggest issue was when he was actively driving the vehicle, the device will beep to let you know to keep testing while you're driving. Unfortunately, it's audio and it's not very accessible for deaf and hard hearing drivers. So you have this really tiny, small light that will go off. But a lot of times he either missed it because he was actually paying attention to driving on the road, or the weather conditions such that the sun glare and you can't really see the device. So a whole bunch of issues with that. Another issue is because he missed the cues from the device while he's driving, he got letters saying that his participation in the program will be extended. And so that means he has to pay additional fees. And then he tried to talk to the MBA to figure out what's going on, because he thought he wasn't involved because he didn't hear these beeps. Unfortunately, he was starting to have his license suspended or revoked. So I got involved in using my role as MACDA staff as well as MDAD. I actually contacted the head of the MBA, Christian Nezzer, as well as the secretary of the transportation to discuss these issues. So the bottom line is right now the IEP is not accessible, but for hard hearing drivers, we should not be penalized because we can't hear the device. So that's why I'm here to say, please consider the amendment regarding the deaf and hard hearing drivers, because we should not be penalized at all for not being able to hear due to our disability. That's all I have to say. Thank you for your time.
Hello, good afternoon, committee. I'd like to introduce myself. My name is Michelle Westfall. I am chair of the Maryland Advisory Council for the Deaf and Hard of Hearing, as was previously mentioned. I'm here today because I think we all can safely agree that no one wants drunk drivers on the road. Absolutely not. No one does. And I think we share that same agreement. That being said, unfortunately, the program itself is not perfect as it currently is. And unfortunately, the devices themselves and the way the program operates is designed from, you know, the typical individual with typical hearing. It is not designed, and when it was designed, it was not thinking about drivers that don't have what is considered typical hearing or typical sight. It was designed based on the assumption of just the industry standard and assuming that those drivers wouldn't have any additional challenge or different needs. And unfortunately, that's not the case in society. For our deaf and hard of hearing individuals and some of our senior citizens, they've experienced problems with the devices as they are currently designed. And it's not just one device. There are many vendors and different types of devices available through those vendors in the program. My understanding, there's approximately 8 different vendors that work with the state, and so no two devices are the same. And so one problem is the accessibility of the device. The light is very, very tiny, very, very easy to overlook. The beep varies in terms of volume, and depending on the auditory access of the individual, it might be completely inaccessible, compounded by the fact that a lot of times there are environmental noises taking place in the car, something as simple as maybe having your windows down. And when you miss that, it can lead to some serious consequences. My goodness, you're penalized with heavy fines, with additional time in the program itself, which incurs its own charges. So it's really harmful for the deaf and hard of hearing community. Therefore, Senator West's amendment would really be mission critical to alleviating some of those concerns and help address some of the issues that our deaf and hard of hearing constituents face. So we ask for a favorable decision for SB for this particular bill.
I'm sorry, I didn't realize you had already testified, sir. Any questions for this panel? All right, seeing no questions for this panel, we'll move on to the next witnesses who are signed up unfavorable. Yeah. Oh, I see him here. Okay, Mr. Hill in the waiting room for virtual. Seeing no questions for this panel, we'll move on to the next witnesses who are signed up unfavorable. And Robert, as you're coming up here, if you have a tab open with the YouTube stream, if you could turn that off.
Okay, let me do that.
In the waiting room.
Got it. Okay.
All right, go ahead, Mr. Hill.
All right, Senator, good to see you. I want to thank you very much for your sponsorship of this important bill. I've heard you in the past talk about, and I think this is an important description. This is a tool for public safety. This is not a means of punishment. It's a tool of public safety. Let's think about it. You get a first-time DUI driver. The judge has no idea who this person is or what their history is. They could be it could have been a one-time mistake. Oh golly, I drank too much and I got in the car. Or it could be someone who has a serious alcohol problem who has driven drunk countless times. And it's just this time that they got caught. And what's scary, and I think some of the other folks talked about some of the statistics, is the court grants some 6,300 probation before judgments for persons charged with DUI and DWI every year. And so those people, by and large, aren't required to get on the ignition interlock. They are just sent out there. Good defense lawyers will have someone do a program before they ever get to court, and they just simply put on probation, and that's it. No monitoring, no meaningful monitoring. This will require somebody to blow into the device before they can start their car. And if they blow into the device and they've got, I believe it's over 0.04 alcohol in their system, that's going to be recorded. And it's going to be recorded every time they blow into it and have alcohol in their system. So the probation agent is going to be able to see what's going on, and the judge is going to be able to see what's going on and know what they're dealing with. There was also a study done by the Maryland Task Force to combat driving under the influence. This is 2008 study, and they found that this device changes behavior. And bottom line is it reduces recidivism greatly. Thank you very much. I urge a favorable report. And Senator Folden, if you have a question still about Rito, I'm happy to answer it. Thank you.
Senator Folden.
Yes, sir. I would appreciate if you have any insight into the redo program that Montgomery County facilitated for I don't know if they still are or not, but I'm curious.
Well, this is going to show both of our ages. I was here when they withdrew it in 1997. So it's been gone for over 20 years, and it was a diversion program, and the problem was that the record would be wiped clean, and then the offender could come back and get into the redo program again, and then it would be, you might have somebody had 3 or 4 offenses, you just never could pick up on it. So no, we don't do that. Now what we do is we have for multiple offenders, multiple subsequent offenders, we can put them in drug court. But the good news is that we're actually creating in our district court a DUI court.
Right.
So that's it.
What's the current diversion program for those convicted of DUI?
I don't think there's any diversion. There's it's been a long time since I've done DUIs, but there's got to be a conviction. And if the court agrees to a PBJ, that's what they get. But our concern is I want them to be under meaningful supervision. I don't want a situation where somebody, if they have urinalysis, they stop drinking a couple of days before they go in for the urinalysis.
Sure.
Urinalysis to go back on it. This way, this will save lives. It absolutely will.
Absolutely. And I appreciate your insight and pointing out how very old I have become. So thank you.
I didn't mean it that way.
Appreciate it.
Senator Sidnor has a question.
And good afternoon. Earlier in some's testimony, they've described the PBJ or the lack thereof being put into this particular program because of PBJs as a loophole. I know Senator Carter, I believe she, in her line of questioning, it kind of was getting to the question and something that I've had some difficulty in dealing with was whether or not a PBJ was actually a conviction or a finding of guilt. The vice chair said, well, that debate is there. This could be looked at as a condition. But I think you may be the only attorney that's testified, at least that I know that's an attorney that's testified. And I wanted to find out from you if legally is a PBJ a conviction?
No, under Maryland law, it wipes away. It strikes the finding of guilt. Now, there's another bill circulating the legislature that's discussing the probation before judgment bill. And one of the problems is that because there is a momentary finding of guilt, the federal authorities, immigration authorities, find that to be a conviction. But under Maryland law, it wipes it away, and then you can have it expunged so that nobody can look on case search and see, oh gosh, he's had a prior DUI. So the answer is no.
Does a judge, when a judge is making their decision, do they have access to information about that defendant's history in terms of drinking and driving and the like prior to them given a PBJ?
If there is information that we have, namely a record, we'll do a record check to see if there are prior DUIs before we would engage in any sort of plea negotiations or if there's a sentencing, we would want to know. But in the case, and this is what I'm most concerned about, is that person who for years has avoided being stopped, but has driven drunk over and over again, and then we find them, but we don't know anything about them because there's no record of it. And so then they get their probation before judgment, they're turned back out on the street and they go right back to it. And that's the big concern. And that is the loophole I think that we're all concerned about. And again, I think I want to emphasize what Senator Waldstreicher has said, is that it's a tool for safety, not a punishment. Not a punishment.
Thank you very much.
Thank you.
Good colloquy. Any further questions for Mr. Hill? Thank you, Mr. Hill. We really appreciate your being here.
Thank you.
And now we will move to the opposition and Mr. Stan.
Thank you, Senator Wallstreicher and members of the committee. By the way, Senator, I don't know if you remember, I met you when you visited my neighborhood of Woodside and Silver Spring. I voted for you and I'm glad to see you there, although I don't know if that's going to help me today. But I wanted to answer all of your questions and perhaps correct some misinformation that I think you've been provided. By the way, I remember the redo program very well. The defense bar was against it because there was some question about whether we could ethically represent somebody who knew they were going to come into court and get their case dropped. So we were glad when they got rid of that. PBJs cannot, for DUI, cannot be expunged. If you get a PBJ, say for possession of marijuana, you can, even for murder, I think, but not for DUI. Can't be expunged. It remains on the records of the MVA. What we see this law about, and certainly it's very well intended, and we have a lot of sympathy and empathy for people who have suffered at the hands of drunk drivers, and we're not in favor of drunk driving. But what I am advocating for is balance, fairness. I think it's a question of where you draw the line so you achieve the maximum benefit with the least amount of harm to people who perhaps don't, low-risk individuals. Senator, when you testified earlier, you mentioned 35 states that require interlock for every case, but every DUI case. But Maryland also criminalizes 0.07. That puts us in a very small minority of states. I know New York has a driving while ability impaired law. Colorado, I think, may even go down to 0.05. But I'm willing to bet, I don't know, I don't have the statistics, but I'm willing to bet that the vast majority of those 35 states are at a 0.08 and don't go below it. And if you blow below that, they're not going to prosecute you. So, and I'm not arguing that 0.07 shouldn't be prosecuted. I haven't even made any of my points. I'd ask for additional time if I could.
So we do limit our witnesses to 2 minutes, but we started about where you live and who you voted for. So take another couple of seconds and conclude your remarks, and we'll have some questions where you can also.
The typical male, if they have more than 3 drinks, they're going to be over the limit. Typical female, over 2 drinks. And a lot of these folks go out first time. By the way, they're going to be punished by the MVA with the interlock. These laws are, when you improve one law in your view, it needs to be consistent with the other laws we already have on the books. The vast majority of my clients on a first offense are getting interlock because they either refused the test or they blew over the limit and they had to get the interlock beforehand. This is mainly going to be targeting low-risk drivers who can't do the interlock for either job-related reasons, and CDL drivers, there's an exception for drivers who plead guilty or found guilty of driving while impaired for 0.07. They're not going to, but the MVA will not allow them to put an interlock in the truck. There are just many different problems, and in 2 minutes is way less time than I really have, but I'd ask you to take a look at my written remarks that go into more detail. But the vast majority of my PBJs have interlock already, and those who don't, there's a reason for it, and they're afraid they're going to lose their jobs and or not be able to do whatever they have to do to get through life. So thank you.
Thank you. Senator Fulton.
Thank you, Mr. Chair. Mr. Stam, how are you, sir?
Good. How are you?
Good. So
I feel like that gentleman in Tiananmen Square facing the tank.
You called?
Not from you. I mean, just the.
Oh, okay.
I'm the only one.
I was like,
here.
look, I don't feel like I'm putting on that much weight. Thanks a lot. Now you're really striking at my core.
Not
I'm
you.
really going to be upset here.
No, I'm not addressing that.
So you always have the way to bring up some good points to create this deflection, this diversion, but you never offer a solution. This is my concern, that when I respect your word, I respect the history of and being involved with this. One thing I just can't stand by. You talk about the 07, the 08, 08. What's the difference between 08 and an 07? Even an 05, you can be convicted of a DUI with an 05, can you not?
No, under Maryland statutes, you're presumed to be innocent at a 0.05.
Correct. The difference being prima facie.
Right. You could be. It's possible. Absolutely.
My point is that 08 is your prima facie level. 07 provides another level, right?
That's right.
below that, you can still be convicted of driving impaired
You can be.
if you're able to articulate all the variables of the degrees of
Sure,
impairment.
some people are impaired under
Correct.
5, no doubt.
So when you come in here and you offer this, I guess I just wish you would offer some type of solution, because I hear
Okay.
you pointing
Sure.
out holes and you're trying
Well,
to say, and I don't really agree with them. I'm gonna be honest with you. I don't agree that they're holes, but I disagree with the idea that when someone comes in on a bill like this, which has meaning, and we're talking about you were talking about what's the balance? The balance is right in front of you. Look around you. Look at the people that are holding pictures, Mr. Sam. I did fatal crash reconstruction for about 24 years. I got tired of making notifications to these loved ones that their loved ones are not coming home.
I agree with you.
And there's ways to try to mitigate this as best we can. We always talk about people wanting to get to, 0 fatalities. I'd love that. That'd be fabulous. The reality is here, these people that come out and they champion for their loved ones, and you're coming out here and you're talking about why that we shouldn't do this time around, but you haven't given any reasonable, in my opinion, no reasonable solution on how to mitigate the balance that you're speaking of. So I want to ask you,
I'm
what
going to answer.
would be the balance that
Okay.
you're requesting versus something that is pretty non-invasive, has a little bit of a monetary cost to have it maintained in your vehicle and installed for an infraction that you did, that ultimately you're driving around potentially a 3,800-pound projectile. And the one lady was, I believe she left, she's talking about 125 miles per hour that her 12-year-old son, Mr. Brown, was killed. That car is traveling at 187 feet per second.
Okay.
So where's the
can-
balance?
Okay, so I believe that when the legislature enacted Noah's Law, that created the balance between, or drew the line between people who are required to get interlock and people who are not. Now, one of the things that I've expressed, and I think there are some things that can be done. For example, when a person gets probation before judgment for DUI in Maryland, they're required to have an assessment, and there are standardized testing. It's all done under the purview of the Maryland Department of Health and Mental Hygiene. And the assessment is either the person is high risk, they're a problem drinker, and they're required to do a 26-week class, or they're deemed to be low risk, social drinker, and they're asked to do a 12-hour class. I think that if you want judges to, the first question I have, and this is not an answer your question. Well, it is partially.
I'd like
The
to
first
answer my question.
I'm going to answer your question.
Okay.
One of the questions I think that if you're, first of all, who are the people that are targeted by this
Mr.
bill?
Sam,
And
I would ask you to answer my question. I didn't give you the platform to go off on some other path. My
Okay.
question's pretty balanced,
So
I think.
my answer is that judges have judicial discretion, and that, first of all, if a person comes in front of them for a PBJ, and that person has not already had the interlock in the car, because if they already had the interlock in the car, under existing statutes, they get credit for that interlock.
Correct.
That's a wash.
It's done.
So the question is, if of those people, and I believe it's a very small number that come in front of them that have not had interlock, they can use their discretion by seeing what the official evaluation is. Is the person low risk or high risk? I agree that high risk drivers should be required to do the interlock for a period of time. I agree with that. So I think that would be something that you could put in a bill, that the judge has discretion and they should consider what, the person's history, whether they're assessed as a high risk or low risk individual.
Mhm.
What I'm objecting to is requiring low risk people who have legitimate reasons why they can't do the interlock or didn't do it already. Maybe they blew below a 0.08, or maybe they went to a hearing and elected a work permit. So if somebody goes in front of them and gets a work permit, and that's the sanction that they get, is it really fair to say, okay, you did your work permit, could have had the interlock then, but because you didn't do the interlock then, we're now going to require you to do the interlock on top of the work permit that you already did. That's where the proposal I believe is inconsistent with section 16205.1, Maryland's implied consent law, that does give people the option of a work permit if there's a good reason, and most people elect interlock because think about it. Would you want to be limited to driving from Frederick to here and back, period, and no other driving? You can't go to the grocery store. Some people might prefer that, but you can't do any other driving. Most people with the 6-month option are going to, and in my experience, do elect interlock. So this law is focused on what I believe, and I do think it would be helpful if there's some data. How many people that get PBJs have not already had interlock, and how many of them violate their PBJ in the first 6 months after they get because we know there's recidivism rates, but how many of those people are actually violating their PBJ in the first 6 months because they don't have an interlock? And I think it would be helpful to see what that is. This is not,
Well, I appreciate that, Mr. Stammen. And obviously it's data that I'm always about good data. So if you would be willing to stop by, I don't want to belabor this anymore, Mr. Chair. I know it's your bill, but I would be all in to go and try to gather that data to get you the answer, because the balance,
the conversation with you.
the conversation can continue, but the balance is already pretty clear to me on where the balance needs to be. But I'm curious to see those numbers and how it helps you. So want to stop by the office sometime. I'd love to talk to you.
I agree with the legislature for 5 years.
Thank you.
Senator Kelly has a question.
Thank you so much.
Thank you.
I have a question for you. Because I was here when we passed the original bill and I don't think it went far enough. Senator Folden and I are pretty much on opposite ends of the spectrum, but I can't echo what he was saying enough. And I want to work towards productive solutions because my concern is that we're not doing enough here. I'm a parent of 2 teenage drivers and I live in terror. And I think a lot of parents and everyday citizens live in terror. And so I think we need to do more. So my question is also about data, because when you gave that 2 drinks for your average woman, 3 drinks for your average man thing, I looked up the weight of the average woman and the average man. And that's not what I'm seeing on this chart. I'm seeing it's actually 3 drinks for your average woman and 4 drinks for your average man. And so I would like to know
under or over. I'm saying
sorry?
3 drinks for the woman is over and 4 drinks for the average man, they're going to be over.
No,
And a lot of the information.
Well, let Senator Kelly clarify. It sounds like she wanted to clarify her question.
Right. Well, so you had said anything more than 2 drinks. So what I'm saying is, what I'm seeing on the chart is the average woman doesn't hit until 4 drinks. Average, I don't know what weights you had for average, but what I'm seeing in this chart is the average woman doesn't.
Use it for average weight.
Well, that's what I'm asking you.
Oh,
My
I was
question to
using
you.
130 pounds for a woman.
170 pounds is the average woman and 200 pounds is the average man. So that's the data.
Oh, okay.
Thanks. So I just think realistically, right, I need us to be doing more. I think our community needs us to be doing more. And I like the working towards solutions. If there's refinement that we might need to make things work better, I would like to see us working in that direction, but definitely towards the doing more. That's where I'm
I
at.
agree with that. I mean, the legislature carved out an exception for commercial drivers who blow under 0.08. This would eliminate that because the MVA will not allow commercial driver. We can talk about it later. No, under 0.08. If you require somebody to get an interlock who gets say a commercial driver blows in 0.07, under this proposal, they go to court. They're going to have to get the interlock. They're out of a job. So I think that it's possible to accommodate all of these interests at the same time.
Thank you, Mr. Stamp, for your testimony. I appreciate it. I think that concludes the hearing for Senate Bill 528, and we'll now move to Senator Muse, Senate Bill 503. And thank you for all our witnesses and guests here today.
Had Senator Carter back to me the other day.
Bring them up. Yes, come right up. Thank you very much. There you go. I'm sorry. And I promise. Thank you very much, Mr. Chairman and Vice Chairman. I have a panel that will join me here. Barbara Burketto on behalf of Maryland Psychological Association, Dr. Pat Savage, Dr. Wolf, and Dr. Olarte. They are here as the panel today. This is a bill that former Senator Lee, who represented Montgomery County, as you know, was a part of this committee. I served with her as well when I was on this committee prior to coming back. She's now representing all of us as our Secretary of State. And she asked me if I would, she distributed some of her bills among us to ask us if we would help her to get these passed because they were important to her. So let me quickly say that SB 503 would require child advocacy centers from across the state to institute best practices to protect children receiving care from CACs and making sure there's no lapse in care. The child advocacy centers are an essential part of care for children who are abused. These children, as you know, and as we have heard, are very vulnerable, and these children can often be suicidal because of the abuse they have suffered. This would require oversight, and I should say more oversight, and regulation over child advocacy centers to make sure that these vulnerable children are being treated correctly. We're not saying in any way that they're not. I'm simply saying we want to go all the way and be sure. You'll hear from my panel today about an incident that happened in Montgomery County. Some will say, well, that's only one incident, only affected a few children. No, that's not, I don't think the attitude we want to take. Make no mistake, there are many child advocacy centers that do an amazing job, and no system is perfect. But I hope you, as I do, want to see anyone that has care over vulnerable children to never get to the place where we feel as though we've put in too much oversight, especially when that oversight is not antithetical to what we are trying to do in caring for our children. Many of them are going to say we don't need legislation to address one incident. But much of our legislation comes out of an incident, not because it's one incident, but because we don't want to see it happen again. That's what we're talking about. Vulnerable children are lost. One lost is too many. Now, let me, if you don't mind, and this is one time that I want to share this with you. I don't share it often, but let me put a face to this personal story. And the face is my face. Up until I was 10 years old, I never knew my dad. I had a stepfather who was extremely abusive that led to chaos in my life. I still have pictures of lying in my own blood and being beaten and kicked and stomped. My head is bleeding. I'm in the corner. I'm or trying to defend my mom. At age 10, and I don't want to talk about any more of it except that part, but here's the good part. At age 10, not good, but at age 10, my mother left my stepfather. She thought that my grandmother would take me in. My grandmother refused to take me in, and I ended up in 11 foster homes. In and out of 11 foster homes. Some of them were very abusive, to the point that I chose to run away, and I chose to sleep in the streets at 11 and 12 years old until I was picked up again, hoping I would never be picked up by law enforcement because they would return me to social services, and I just didn't want anybody else to hit me again. But in that situation, 11 foster homes, kicked out of 3 school systems, beaten severely, and on and on and on. If anybody knows about a child who needs care and whether or not there are limitations to that, it's me. The story ended well because when I was 13, the neighborhood pastor adopted me. He gave me my first home and put me back in school and fixed my entire life and gave me a second chance. Some of these kids won't get a second chance if that kind of care is not there for them. That's my personal story, and that's why I am personally involved. This is not about legislation. This is about reality for all kids who can't speak for themselves. I hope you hear not just the institutional side, but the personal side of this legislation, and could put a face on the child and not just see the face of those who are standing in front of you on their behalf. I will turn it over to my panel, and I urge a favorable report, and I'll never tell that story again, but I wanted to tell it because I feel as though if I went through it for nothing else, maybe it was because so I could stand here and do something that would help somebody else to not go through that. I thank you much.
Wow. Chair, Vice Chair, members of the Judicial Proceedings Committee, thank you for the opportunity today to address you. I am Dr. Pat Savage, a licensed psychologist in Maryland who has served children and families for almost 40 years in Montgomery County. Today, I'm testifying in strong support for SB 503 as the chair of the Maryland Psychological's Legislative Committee. SB 503's intent is simple: to protect one of the most vulnerable populations of Marylanders, traumatized kids and their families, as well as the providers who treat them. A simple ask for guardrails consistent with the standards of care and ethical principles of those professionals who provide mental health services to the public. The ask is designed to fill a hole brought to our attention by a member of MPA who experienced firsthand the harm that can occur to kids, families, and therapists when the procedures outlined in the bill are ignored, not followed, or simply not present, period. The opposition will claim that our goal is somehow to tarnish the good work of CACs. They will also say no children or families were harmed by the situation that occurred in Montgomery County, and that these protections exist through other processes or via other oversight organizations. These protestations are not consistent with what we know. You will hear from witnesses of the harm experienced by children, their families, and the therapists. You will also hear the extent to which therapists attempted to reach out to organizations in order to prevent harm to these same children and families, as well as themselves, and were told nothing could be done or received no response. The organizations included both the Maryland and National Children's Alliances and the Licensing Board for Psychologists and Social Workers in the state of Maryland. Opponents will also say that the ethics mental health providers must abide by are protection enough. Not so. The bill provides guardrails for organizations to ensure that mental health providers can meet their ethical obligations and mitigate the kind of harm that the kids and their families experience as a result of a forced abandonment. I ask that you join us in attempting to see that no kid or therapist finds themselves in this position again, and provide a favorable report on SB 503. It is one small step to improve the effectiveness and safety of our mental health delivery systems. Thank you for this opportunity again, and I'll be glad to take any questions you might have.
Good afternoon. Thank you for the opportunity to speak today. My name is Dr. Stephanie Wolf, and I am a child trauma psychologist here in Maryland. I'm the vice chair of the Maryland Psychological Association Legislative Committee, and I'm here to testify with strong support for SB 503. I love CACs. I have worked at CACs for many years in the past. CACs are wonderful places. However, no place is perfect. And when you are within a place, the problems are often harder to see. Through an incident which over 40 children lost their mental health providers and had insufficient continuity of care, this is how we learned of a gaping hole. Children were harmed. Many children and families were harmed. These children had been abused by parents, people they love, and people they trusted, but found a safe space with their therapist. When an abused child is in treatment and suddenly loses their therapist, this is especially devastating. This loss is another trauma and undermines their openness to treatment. The child is left with a message that not only can they not trust whoever abused them, but they can't trust therapists and even the centers created to help abused children. The opponents of this bill have pointed to the OIG report as finding that no children were harmed. However, the OIG only spoke to the management of the CACs, who were the ones responsible for the actions. The OIG did not speak to the therapists, did not verify through their record system how many kids were in treatment, and did not talk to any of the families impacted. I am here to shout as loudly as possible that children were harmed and are still at risk. I can also tell you firsthand that the guardrails out there are not sufficient. We reached out to the NCA, National Children's Alliance, and were told there was nothing they could do. We reached out to the Maryland Children's Alliance, and there was nothing they could do. We have emails showing, and if the committee would like to see, that we reached out and were told there was no response. So for all these reasons, I ask that you support and protect the kids even more in SB 503. Thank you.
Good afternoon. I'm Dr. Stephanie Olarte, and I'm a child and adolescent psychologist in Silver Spring in private practice. I'm also the chair for the Child and Family Subcommittee for the MPA Legislative Committee. Thank you for giving me the opportunity to voice my impressions of Senate Bill 503. And I really want to stress that I have the privilege of being able to do so because I get to control my own schedule, which is not something that a lot of other mental health providers and average citizens are able to sacrifice to do in person. And there's also a fair number who are actually afraid to speak up publicly about their experience with this matter. Some parties who oppose this bill are suggesting that children were not harmed by the actions that we're trying to prevent with this bill. My most polite response is to say that I would find it alarming for any mental health provider to suggest that losing a therapist abruptly would not cause further psychological damage on a child. This is why we have ethical codes as far as that guide us in the termination process. But more specifically, I have a personal story about the resulting harm on a child and their caregivers after their therapist was abruptly terminated. Years ago, I was contacted by a friend asking about the ethical codes that psychologists abide by as it relates to termination of psychotherapy. Their child was receiving services at a child advocacy center. They were asking me because their child's therapist had been terminated abruptly and their child never had a chance to say goodbye. A child with a significant history of attachment trauma lost their trusted therapist abruptly. Their caregivers received little to no support as their child suffered this sudden loss. Their caregivers' attempts to raise concerns about the psychological damage this would further inflict on their child was met with deeply concerning efforts to silence them to the point where they are afraid to tell their story publicly. And I just want to thank them for allowing me to share it on their behalf. Thank you.
Good afternoon, members of the committee. My name is Richard Block. I'm general counsel to the Maryland Psychological Association and have been practicing in that field for about 44 years. The purpose of this bill is to provide child advocacy center clients with notice of a termination of their mental health provider, so that the process for terminating with a client, which is required of all mental health providers under Maryland codes and regulations and the codes of ethics, to be implemented. Without the notice, the provider is at risk as well as the child. They're obligated under their ethical codes, under COMAR, to notify, properly terminate, be available for transition, and in the case of emergency for a period of time. If they don't have the information because they've been terminated, they can't do their responsibility. So this not only protects children from all the harm that you have heard about from the prior testimony and we'll hear further about, but it will also help the providers, the mental health providers who I have represented for decades, do what they're obligated to do to assist that child in the ability to understand why they are no longer going to be providing those services. It is an important element of the child's growth. I've seen it as a lawyer. I've seen it in cases in which I've been involved. And what happens is the family gets upset and they suddenly are filing a complaint with the licensing board against my client. This puts their license at risk. So this is a protection for not only children and their families, but for the providers. Thank you for the opportunity to address you.
Senator Meeks.
Thank all of you for coming. My question is, let's see, Dr. Stephanie, would you, yeah, I'm sorry. Many are not aware of the event of which we speak. It is in their package. We don't have to go over it, but in reading some of the opposition, here's what I've gotten taken away from it. We don't need it. It will only confuse people who are working here, which I don't understand, because any legislation that we pass out, anybody overseeing an institution that can't make it plain, no matter what it is, there should be no confusion, no matter what we pass out of here. So it's going to be confusing. It will confuse the workers. It's too much oversight. But the question I ask is, what's the harm?
So I think that's a great question. I don't know. I can't see a harm. The harm is to the children, right? If it doesn't happen. The harm to the organization, there should be no harm. It's you're following the best practices and you're following these standards that everybody should be doing anyway. And we've heard from the opposition in other testimony that they are doing these practices, that they are having continuity of care and they are doing this. So even more so, encoding this only ensures that no harm is done to children.
Thank you. And thank you very much for your question. And this one from you were telling the story and I wanted to get the rest of it so I could get it in here.
I'm sorry, excuse
you were
me.
telling a story of what happened and people who are not responding. Anything else you want to say about that? Because I wanted to get that.
That's about as much as that family is comfortable having me share on their behalf.
Okay, thank you very much. All right, thank you. And thank you, Mr. Chair.
No one else had a question. I had a couple of questions just for clarity. Let me see. One, I've heard that you all mentioned that there's some providers that do this. So I'm wondering, so this is something that's done voluntarily? Oh, I'm trying to understand the need for legislation to be put in place if it's something that they're already doing.
Well, they should be doing this. But when a provider works for an organization, what happened in this situation and what is still possible to happen continuously is that the organization doesn't allow the provider to be doing that. And so what happened in the case of the CAC that we're talking about, the providers were prevented from doing that. And so filling that hole is what this legislation does. So it codifies and it puts those guardrails in place because right now what's out there isn't sufficient to guarantee that providers are allowed to exercise their due diligence and exercise their ethical duty to protect kids and to help link services.
And the other thing that I'm somewhat confused over, the children that are in these centers, I think someone said that sometimes they've suffered, I guess, abuse from parents and guardians, but the legislation is mandating that that notice go out to the parents and the guardians. Although I think there's a caveat in here that says that unless they have a reason to believe that the child is in danger.
Exactly. So there's
oh, go
ahead.
So the question that I have is they're in the center probably because of the parent or the guardian mistreating them.
Yes.
And if is that generally why the children are in these centers?
Yeah, so it depends, right? We have for the most part, children are referred from child welfare services, et cetera, for abuse by guardians. Not always the case. If they've been removed, such as some of the testimony we've heard, then they're in foster care, and so then the guardian notified would be the foster parent. The caveat, the kind of phrase in there that prevents harm to the child that says, right, if it would be harmful in some way. And so absolutely, I agree with you that, and I think that would fall under that catch-all, that if there was something that somehow would be harmful by notifying the parent that the therapist had left, then that absolutely would not be done. We're not wedded to this language. We're wedded to the protection of kids and to close this hole in child advocacy centers. So if there's a better way to phrase it, or, you know, or some better way to approach it, we're open to that. But, you know, the important piece is really to be able to protect kids from ever having to experience that abandonment, especially the most vulnerable kids, such as the kids that are being treated at child advocacy centers.
I guess I'm just trying to understand what the bill does if it's the child advocacy center that's prohibiting the professional from doing the notification. But then in section 3, you're giving the child advocacy center the ability to make the decision whether or not notification may endanger the child. Then it all goes back to the child advocacy center saying, no, I don't want you notifying them, which then puts us right back. I'm trying to understand. It feels like a circle. And
Yeah,
I'm trying to
so I
find how you
believe,
get out the circle.
yeah, so I believe another part, I think the sentence below also gives the therapist, if I remember it correctly, and I'd have to look at it, but also gives, if that does not happen, then gives the therapist the right to make that happen. If I'm recalling correctly, I don't have the language in front of me, but having that ability codified in law ensures that these kids can have the proper notification and can have that continuity of services.
So the child advocacy center can say no. And then it talks about a previous provider. Is that the professional?
What, I don't understand the question.
You said the next section below, it talks about a previous
Yes,
provider.
yes.
That's talking about the service provider.
Sure,
Not
sure.
necessarily the child advocacy center. So the previous provider shall be allowed to contact the child and the child's parent or guardian to conduct a termination session and to assist in transferring the child's care to the new provider.
Yes.
Unless the child advocacy center has terminated the previous provider for conduct detrimental to health, safety, and welfare of the child.
Yes.
How is that getting us out of that?
So it's if a child advocacy center improperly determines that there is a risk and there in fact is not a risk, then the provider has the legal authority to go beyond what the child advocacy center is saying and
Just
have
make
that.
sure I understand. So the employee can override what the employer is saying under this legislation?
Well, I think they're a former employee, right?
I don't know. I'm trying to
So
understand.
there may be another panelist that wants to respond. You know, again, I think that if there are issues with the way that it's written, we're very open. You know, if there's a way that we could be more clear, we're very open to talking about that because the goal isn't wedded to this language, right? The goal is really just protecting kids and making sure that these vulnerable kids are not in a situation that we know can happen again. And most of the child advocacy centers, almost all of the child advocacy centers would, you know, hopefully act in the best, most ethical way. But now that we know that that's not always the case, and now that we see that there's this hole, it's hard to understand what would be the downside to just codify something that helps kids and doesn't do any harm.
Thank you.
Thank you.
Can I offer some clarification?
If Senator Meese.
I think that what one of the things that's being said that's confusing is people are saying, well, we already do this. It's codified already. This doesn't do anything. This doesn't do anything. And what we want to make clear is that which we're after from you, what's not codified? What is it that this does that is not being done already? And why do we need to codify it? If you can answer that, because I think that's the confusing part. People are saying, and who are opposed to it,
Sure.
they're saying, well, oh, it's codified. We don't need it. It's just language. But that's not true.
Right. So there's nothing that there's no way to enforce it right now. Right?
That's why we're
the way right now that there's no enforcement. There's no, when this happened, when the situation that we've referenced, when it happened, all of the areas, all the organizations that would have been or have been suggested by the opposition that could enforce that these were followed, nobody could help. Right? We still, there was no organization that could step in. There was no licensure that could step in and say to, okay, you can contact these kids, you can say goodbye. So there's nothing else that can be done, which identifies that there's this hole.
So what we're trying to do is to make sure that what happened, because people will say, well, what happened? Gee, it would have happened anyway. What we're trying to do is to quantify what they're saying they could have done, but didn't do. And we're trying to say, here's some things you have to do.
Exactly.
Even if you don't want to be told even if you think here are some things that were not done before. We want it into law.
Exactly.
So when they say, oh, we don't need this because we're doing it anyway, we're saying if you're doing it anyway, then why you worry? Then why you upset? If you're doing it, then you have no problems with us putting this in statute and putting it in the law. And that's been my problem. They say, we're doing it. I'm saying, then we're just codifying what you're doing. Why are you so upset? And nobody's been able to answer me. So I think you just did by saying, the difference is what we're asking for is we're putting it into law and into language. And right now, that's not the case. Is that right?
That's correct.
Thank you. Thank you.
Can I add a comment? Because I think there was a second part to his question.
And I meant to direct it to you and I meant to ask him to, but yes, because I know you knew that.
There was a second part to your concern because the reason we put in there the prohibition that the CACs should be allowed to have against allowing a therapist to work with a family or kid if they've been terminated. If the CAC, for instance, were to find out that they had a therapist that was a sexual predator, they should have the right to prohibit that person from having any further contact with the kid because that would be extraordinarily dangerous. So we wanted to make sure that protection was built into this legislation as well. So I hope that answers the second part of the question you were asking initially.
Actually, I think I just got confused. Can you explain that again?
Yeah, I think he was asking about the third part where the CAC is in the position of terminating a therapist who then they determine is in some way dangerous to the health and welfare of the kid or the family. And the reason it was included is because we recognize that the CAC could identify somebody as being a child predator and discovering that information, terminate them. We wouldn't want that person to have a termination session with the kid and the family at that point. It would be appropriate for the CAC to say, you're out of here and you're not going to have contact with the individual. So that was the purpose of that piece in the legislation.
Okay, no, what I was trying to understand and to the testimony that was mentioned earlier, child advocate centers under the legislation would have to give the 48-hour notification unless they deemed doing so would be would endanger the child. My question was, or my statement, or my understanding from reading this is that this bill is asking or essentially mandating that the Child Advocacy Center give notification to a party that likely put the child in the advocacy center. Then I think the testimony was that the provider, at least my understanding from what I heard, was that the therapist or whomever could essentially ignore the Child Advocacy Center. But I think now it's my understanding that that's if the provider was fired or no longer with that particular Child Advocacy Center. Is that correct?
I believe so, if I understand what you were asking.
So if that therapist is still within that Child Advocacy Center, they can't override their employer. They can't contact, they can't give notification to the parent or guardian, right?
So you're talking now, I think, about a different situation than we envisioned. You're talking, I think, if I understand you, about a therapist who's working in the center, who's working with the kid, and then told they have to discontinue treatment with that kid, but may still continue to be an employee in the system. Is that correct?
The way I was reading this bill, it seemed to be all about notification. Right? This is, my read is, it's all about notification. Right?
About codifying
Not notification.
both notification, continuity of service, and the ability of a therapist who has formed a relationship with these highly vulnerable kids who don't trust people very easily to all of a sudden not be abandoned with no explanation for why the therapist can't continue to work with them. Because one of the things, and in another hearing, in the House side of this hearing, there was a whole group of people who had gone through sexual abuse who basically said in those kinds of situations, what the victims end up believing is they somehow caused the termination of the therapist or the absence of the therapist or the abandonment. So it's further damage that's occurring to those individuals on an emotional basis.
Okay, so there's three parts to this bill. Section C1 is about notification. And the Child Advocacy Center eventually can say, if there's a belief that the child is endangered, that notification doesn't have to happen. Part 2, I think, is now what you're talking about, which is someone who is no longer with the Child Advocacy Center being able to reach out to some parent or guardian about those services. And then the last section is a section given that part of, I guess, whistleblower protection, if they do reach out to this, the parents. Is that your understanding of the legislation?
Yeah, you want to address the whistleblower?
Please.
Yeah, so that's a different, the whistleblower piece is a different piece. And it's codifying just the fact that that there's whistleblower protection within a CAC system, because that is also an area that has been very unclear. But that piece is way less important, right? You know, we're happy to get rid of that, et cetera. This is really about kids, continuity of care, and making sure that no child within a child advocacy center ever loses their therapist suddenly and isn't told that their therapist is gone, doesn't have to show up to a Zoom session like what happened to many of the patients in the situation that we've discussed, show up to a Zoom session in part of the pandemic and their therapist wasn't there. No child has to wonder, what did they do that this therapist they trusted is no longer there and didn't even say goodbye. No child has to wonder and not believe in therapy because they were abandoned by their last therapist. This is to protect against that. The whistleblower piece is, you know, it was an additional piece that came out of the situation, but it's not why we're here today.
Thank you.
If I may, and to my colleagues, the only thing that is the only intent of this legislation at the root of it is this. If I'm a kid and I'm 10 years old and I have a therapist and I've been interacting with that therapist, but someone else decides I want to bring in another therapist, that if we terminate the services of the therapist who has been with that child, let's say 2 or 3 years, that one therapist would at least have the ability, if that child says, what happened? That to be able to say, I'm terminating this, because often the children feel as though they've done something wrong, right? So they feel like I've done something wrong. Why is the person that I've been built a relationship with now suddenly gone? The only thing that this legislation would do is give the opportunity to say, goodbye, I'm leaving, there's someone else who's coming. And that can be with anybody in the room, it could be by a letter, but know what is happening with these kids is that so many of them are being shuffled, these therapists are being shuffled around. No kid says, why have I had 2 therapists, 3 therapists? Where's the one that I want? What did I do wrong? Which is what they've always said, this is just to eliminate that. Everything else is just would. Okay, that a correct analysis? Okay, I mean, I know.
All right,
that.
this is the last go around here, all right? So, sir, yeah, very succinctly and briefly, please.
very
Thank
brief.
you very much. Thank
The
you.
reality is that what you are doing is showing that we are accepting that there needs to be language adjustment. That's really what we're talking about. The intent of the bill is critical, though, for the protection of these kids. And that's all, I agree.
All right, seeing no further questions, thank you all very much. Thank you. All right, we'll now hear from is Barbara Brocato here. Barbara, there you are. Daniel Shattuck, Renee DeBoard, and Joyce Lombardi. Oop, sorry, Joyce, scratch that. We'll just Renee DeBoard.
Mr. Chairman, members of committee, I'm Barbara Brocato, here in support of Senate Bill 503 and on behalf of the Maryland Psychological Association. Just a couple of points here. These centers are treating children coming out of our public systems under the most tragic circumstances. They receive public funds, federal, state, and local. I'm not a lawyer, Mr. Chairman and members, but I see what they're doing as assuming a state responsibility, yet we have no state law that provides any recourse or any protection. When we went to Senator Lee about this, it was just some simple guardrails, because what happened in this one center pointed out that the centers dismissed folks for objecting to standard of care issues. And those folks, by virtue of their contracts, could not say goodbye to maybe these clients, the only people that these children could rely on. It was traumatic. We're not glued to language. We told the opponents, let's get together and fix it. Let's get some basic language that gives some notification to whoever is legally responsible. Someone has to be legally responsible for these children. State law can provide some recourse here. And we ask you to really look closely at this and consider it. And consider that it is some protection by the state for these children. Thank you. And be glad to answer any questions. Thank you.
Hello, my name is Renee DeBoard Lucas, and I'm a psychologist specializing in work with children and teens impacted by trauma. Thank you for the opportunity to speak today. I previously worked at a CAC and helped support families in the aftermath of physical and sexual abuse. I believe strongly in CACs and their mission's focus on reducing and preventing childhood trauma. I'm here to speak in favor of Senate Bill 503. This bill closes an important loop that currently exists where children may and have been suddenly and traumatically separated from their therapist if treatment ends unexpectedly. At the CAC where I worked, 40 children and families experienced an abrupt and unexplained end to their existing trauma therapy when myself and several of my colleagues were terminated. We were told that there was no more need for our services. This was at the height of the pandemic when there was a massive increase in mental health needs and a wait list at this particular CAC. Sometimes people ask me how I can do this work when I see so many children in painful situations. I love this work, and I do it because I can help children feel better. When my colleagues and I were terminated, I immediately worried for the impact on these children. I worried that they would think that I had abandoned them, that I didn't care, and that they didn't matter. I worried that one client who had experienced recent thoughts of suicide might be in danger when his treatment ended without warning. The family was matched with someone who was not trained in the child's treatment, which disrupted their care further and made the family understandably concerned. Fortunately, this family was able to find me through LinkedIn. They were distraught at the separation and at the fact that they were denied information on how to find me. I still worry about the impact on the families that were not able to find me and who might still think that yet another person who was supposed to care for them abandoned them. I care deeply about my patients and my ethical duty to do no harm. It was devastating to be prevented from upholding my duty, which I typically would have exercised by informing my patients of my departure and by having a termination session. The children and families seeking care at a CAC have already been through enough. They deserve to be treated with dignity and respect and to have this loophole closed. Thank you.
Matt, if I could, thank you. Sometimes these terminations were due to a therapist seeing something and blowing a whistle. And if they said something that was in the interest of the child, but it was not, but the administration disagreed with it, they would just fire some as the therapist. And all the therapist was asking was, even if it's through you or with you, can I just say to the child, you're not responsible, I have to leave.
Yes.
That's the crux of the legislation. And that's really the heart of many of the problems that we're trying to get at. Not that you can't terminate, you can't, but if you do. But the whistleblower part is there because a number of people came forward after the incident, said what happened, and they won't terminate. And they didn't even ask for their job back. They just said, can we come and say, all is well, you're going to be in good hands, which I know when I was in foster care, when I was in those homes, I went through 11 of them. It's traumatic. And I just wanted somebody to tell me what was going on. I didn't care about the adult issues. I cared about somebody telling me. That's what you're saying. Is that
That's
correct?
exactly right. Children often assume that they're responsible for something, even when they're
Correct.
not. It's just the way their brains work. And so we just wanted to be able to share with them that it wasn't their fault and that they had done nothing wrong.
Thank you.
Yeah,
Thank you for
absolutely.
that opportunity to clear. Thank you.
Mr. Chair, members of the committee, my name is Dan Shattuck. I'm here today on behalf of the Maryland Psychological Association. You've heard a lot of great testimony. I thank the senator for bringing this bill forward. I just want to echo a couple points. And as the senator so eloquently said, this is really a simple goal to protect the children and to protect the providers. For the providers that you've heard today, there was this incident, they had nowhere to turn. They had nowhere to turn to help the children. And that's what we're focused on today. And if language needs to be changed, you know, we'll work with that. But the goal and the bottom line is that essentially these are best practices that are outlined in the bill. They should be applauded. And if they're not applauded, they should be worked on until we can get to a point where everyone comes together and agrees this is the right way to go forward. But we don't want to let an incident happen again. And we want to make sure that the state of Maryland has embodied in the law the pathway that will help children, that will help families, and will help the providers to make sure that nobody is traumatized or harmed again. Thank you.
Excellent. Thank you very much. Seeing no questions from the committee, thank you all very much for being here. So now we'll turn to our virtual participants and we'll start off with Allison Kramer-Kuhn. Allison, you're up.
Thank you. My name is Allison Kramer-Kuhn, and I'm a child psychologist. I'm licensed in Maryland and DC and specialize in trauma-focused treatment. I'm a staunch supporter of CACs and have worked at 2 of them. I think people generally understand that the relationship between a therapist and a client is important, but it's that much more important for kids who've experienced trauma, specifically maltreatment by an adult that they trusted. So trust, stability, and predictability are critical in treatment. This is because by its nature, child maltreatment is confusing, it's chaotic, it's unpredictable. It goes against our expectations of how people are supposed to behave and how the world is supposed to be. Trauma fosters uncertainty and mistrust. For children who make a disclosure of abuse, unfortunately, the chaos and uncertainty doesn't end there. Kids have no idea what's going to happen to them or to their family. Many are shuffled between family members or foster homes. They may have to change schools. They can be suddenly separated from parents, siblings, friends, or even pets. Any abrupt and unexplained separation in the aftermath of an abuse disclosure contributes to this chaos and unpredictability, and it undermines treatment. So if the therapeutic relationship is disrupted before treatment is finished, it's our responsibility to provide a planned and thoughtful transition. And if that's not possible for whatever reason, can we at least ensure kids have the opportunity to say goodbye to their therapist? I'm confident that most therapists and CACs already do the right thing. But the fact is that children can be and have been harmed because of abrupt disruptions in care, and some kind of regulation could prevent additional harm in the future. To me, the purpose of this bill is to prevent organizations from even inadvertently contributing to traumatic separations. So if there are disagreements about the wording or the practical implications of the bill, I respectfully urge interested parties to work together to please craft something that addresses any concerns so that the purpose of the bill is not lost. Thank you.
Thank you very much. Next, we'll hear from Emily Pecan.
Pecan, thank you.
Pecan, there you go. Got it right the first time.
My name is Emily Pecan, and I am a licensed clinical social worker working primarily with children who have experienced trauma in Maryland. I sincerely appreciate the opportunity to speak in support of SB 503. I worked at a Maryland CAC for almost 2 years. I am bilingual, and so a large percentage of my client load were under-resourced Spanish-speaking families. When I was terminated abruptly, I would have been happy to see any families that chose to continue therapy with me or even have one closing session with them. However, my clients did not know why I was suddenly gone or how to reach me. In the following weeks, I did have 2 clients find me on LinkedIn who chose to resume treatment. They were both English-speaking families. I never reconnected with any of the Spanish-speaking families. There was only one other trained Spanish-speaking therapist at my CAC when I left who already had a full caseload. As you can probably imagine, there are typically long waiting lists to see a Spanish-speaking therapist. So I worry about what happened to these clients. I especially worry about the 2 children who had been recently hospitalized for suicidal ideation and the young client who was experiencing trauma-based psychosis that threatened his ability to continue attending school. In the middle of all of this, their therapist essentially disappeared with no proper transition or termination. It has been scary and sad to consider the additional and completely avoidable trauma these families may have experienced. I understand that the requirements being proposed in this bill may appear onerous for some CACs. Much of what we are already required to do to care for our most vulnerable child clients responsibly could be considered onerous, but we do them because they matter. We should not deny these children the care they deserve because it is too much work. Many systems are set up to allow these marginalized individuals to fall through the cracks. It is our responsibility to do the work required to protect our most vulnerable. Thank you.
Thank you, Ms. Pecan. Thank you very much. And we'll now hear from Mr. Look.
Yes, thank you, Chairman Smith, Vice Chair Wallstreicher, and I'm Dr. Bill Fluke. I'm a retired psychologist. I spent my entire career in public education. You've heard about the importance of trust, and childhood trauma is a fundamental betrayal of trust, can cause lifelong damage. Early intervention is essential with a skilled therapist. It's really essential to get it right. I'm speaking today on behalf of 2 organizations that I'm affiliated with. First, NAMI, the National Alliance on Mental Illness, which is a grassroots organization of individuals with mental illness and their families. The early trauma left untreated is often a factor in mental illness and has lifelong consequences. Secondly, I'm here to speak on behalf of the Maryland School Psychologists Association, an organization of almost 900 school psychologists in Maryland. We provide essential behavioral health services in Maryland's public schools, and we're painfully aware of the terrible impact of physical and sexual abuse on kids. It's essential that we get it right. A little state regulation of this process would be a good thing, and we urge your support of Senate Bill 503. Thank you.
All right, thank you very much, Mr. Fluke. Senator Kelly has a question.
Sorry, I have a question for Emily Pecan. Hi, I just wanted to say hello. I texted Shahar and told him you were here today. I want to thank you for your service and particularly to the Spanish-speaking community. And thanks for being here to testify today.
Hi, Ariana.
Isn't that so?
That is so. Good to see you.
It's fun. All right, additional question? No, it's good. It's good. Emily, you're getting a lot of love in the room right here. Shimmy, shimmy, shake, shake. There you go. All right. Everyone, no further questions? All right. Thank you all very much. Thank you for your time today. All right, now that'll end the testimony for the proponents of the bill. We'll switch to the opponents and we'll start off with Joyce Lombardi, Sarah Sample, Wendy Myers. And is Wendy Lane? She's virtual as well. You can let her in.
Good afternoon, Chairman and members of the subcommittee. I am Wendy Myers, and I'm the Executive Director of Maryland Children's Alliance, or MCA. MCA is the accredited statewide chapter which serves as the convener of Maryland's 24 Child Advocacy Centers, or CACs. You've heard a lot about CACs today. We serve child victims of physical abuse, sexual abuse, exploitation, trafficking. In 2022, Maryland CACs served more than 5,700 Maryland children. Between the years 2016 and 2022, Maryland CACs provided services to 37,529 children. We've been on the front lines for decades, establishing best practice standards and successfully responding to the needs of children and families in Maryland. Each CAC team includes specially trained forensic interviewers, law enforcement, child protective services, family advocates, prosecutors, medical providers, and trauma therapists. There are layers of oversight at the county, at the state, and at the federal level for our CACs. The requirements set forth in Senate Bill 502 have a dissimilar impact on each of these 24 CACs in Maryland, given the differences in their organizational structures. 14 of the 24 are operated by the Department of Human Services, 5 are nonprofit entities, 3 are operated by counties, and 2 are operated by law enforcement. Additionally, 20 of the 24 do not employ in-house mental health providers. These CACs instead coordinate services through linkage agreements with external providers. In Howard County, for example, the CAC director is a law enforcement officer. He would have to communicate the change as a result of information provided by a victim serving organization, which provides services by way of a linkage agreement from a separate agency. Senate Bill 502 proposes a one-size-fits-all approach to CACs that are of all different types with different professionals and entities at the helm. For these reasons, we respectfully request an unfavorable report. Thank you so much.
Good afternoon, Chairman, members of the committee. Joyce Lombardi. I represent Center for Hope, which is Baltimore City's Child Advocacy Center. You do have our written remarks. We join the many groups who are opposing this bill. And so I want to address just a few things in our testimony and as we have written on page 2, we do believe that current law does protect the patients. You heard the proponents talk about the notion of abandonment. That is common law. So if your therapist is in fact terminated and cannot receive care, they are able to bring a claim. Also, a claim can be brought under current continuity of care against the provider, the supervisor, and the Child Advocacy Center. For the reasons we stated that even if Maryland did need a law, this one is not it for some deficiencies that we list in our testimony. Even so, the law fundamentally misunderstands the nature of child advocacy centers. As Ms. Myers said, then it's simply unworkable. It sounds good to say let's regulate them, but it's simply not going to work because of their different structures, which I'm happy to elaborate on. The termination agreements having one of the standards is being able to have a termination session if someone that is fired. That is a matter of putting that, codifying that in a statute. It's not in fact common practice. That is up to the discretion of a mental health service provider. In terms of the things that are in the bill before you, those are not in fact best practices. Those are not codified in any statute. They are something that doesn't certainly exist in law and certainly not in this one, which is a provision of the Criminal Procedure Article, which states on its face that the Maryland Children's Alliance is the one that creates standards for CACs, and we urge an unfavorable report. Thank you.
Good afternoon, everyone. Thank you to the chair. Thank you to the members of the committee for having me here today. My name is Sarah Sample, and I'm here on behalf of the Maryland Association of Counties. And from the professionals, you have heard for the most part what this bill does. We are here in opposition to Senate Bill 503. As you've heard already, that there are 3 county governments that operate CACs, and there are 2 law enforcement agencies, which is why we're interested in this, obviously. You've heard that we operate through linkage agreements for the most part. And so we're a handful of steps removed from the actual providers. But we would urge an unfavorable report on this. The other thing I would also mention is that we've heard a little bit about the language of the bill in its current condition, even just in the advocacy, the proponent of the bill panel. It does sound like it's something that does need further work, either way you look at it. But so we would go ahead and urge an unfavorable report. I'll take any questions. Thank you.
Thank you, Mr. Chairman. Anyone can answer this question. I'm looking at the testimony. It only part that you guys think that we should add an amendment to is the what does it say? The non-notification piece in here. For the other piece about notifying the child of the person leaving for whatever reason, is there anything that you can live with within that bill that doesn't codify exactly what's there? Of notifying a child that their care provider, their mental health professional has left?
Thank you, Senator Washington. So I can take that. So I just kind of want to give an example from Prince George's County. So what this bill would mean is that, and as Ms. Meyer said, they're all different. All the structures are different. So in Prince George's County, it's similar for Harford County, parts of Baltimore County, and they contract out for their mental health providers. So what that means is if I am in charge of the CAC, I'm the sheriff in Harford County, I'm the Child Advocacy Center, I'm DHS in Prince George's County, I'm law enforcement, or I'm DHS in Baltimore County. What that means under this law is that I have all of a sudden, and I want to turn you to the testimony, I think it's from Springboard Community Services, and they are a mental health provider for 3 of our county's child advocacy centers. And there they say, look, I heard some testimony about these relationships going on for 3 years or so, and so forth. That's not how a child advocacy center works. In Springboard, they say, some of these are very short term. Some of the mental health provision is only 3 or 4 sessions. So as she said, it's not one size fits all. Some of them are longer. There's a few child advocacy centers that are nonprofit. Treehouse in Montgomery County is one. Ours in Baltimore City is one. And then yours, for example, would not be. And so when you're saying it's something we can live with, who's the we? Because if you're putting pressure, if you're trying to create liability on the Harford County Sheriff's Office or the DHS office or your very own Prince George's County to take care of a termination over here in a third-party provider that you have a linkage agreement with, how does that work? You can't control it. And this is going to be up to the discretion of your third-party provider over here in Prince George's County. I don't know if it's appropriate for me to have it's to allow a termination session that somebody that I was able to terminate. And as you know, the facts in this particular issue are contested. These are in litigation, and so you don't see, so we're not allowed to talk about the facts of this case. And so in that case, I think it's hard to answer it because there's no we. It's
because everybody's different.
They're all different, right. And the body under Maryland statutory law who's responsible for setting these standards is right here, and that's in 11-9-20.
Isn't there an equity issue when they all are kind of different in 24 jurisdictions? Shouldn't there be like one consistent procedure for all of these? I think that's what they're trying to get at, right? A consistent procedure and how to handle these types of situations. Like, speak to the equity issue. Why is it seems to me that it's inequitable because every system is different, and I think they're trying to bring some type of consistency throughout for all of these facilities at some point of how you handle a certain circumstance.
Sure, and I think the mental health, the outpatient mental health providers for a child advocacy center is as different as they are for Kennedy Krieger or Shepherd Pratt or Springboard or ours, right? I mean, there's a lot of people that do this work and you could say those are all different. Just the fact that they have a linkage agreement with the Child Advocacy Center doesn't all of a sudden put them in any different category for someone that's working with very, very vulnerable and sensitive populations, as we all do every day. But to the smaller answer, there actually is a body, and you're going to hear from Will Laird, I see, who's up next. It's the National Children's Alliance. These are nationally accredited. Those accreditation standards are codified in the very bill that we're looking at, 11-928, and it says here is what you need to be a child advocacy center, and that's just kind of like the bricks and the mortar. It doesn't get into how to mix the cement. If you want to talk about how to mix the cement, then you go into the actual accrediting standards that are done in the national agency and then through the state. I keep pointing at you, but you know, sorry, excuse me. And through the Maryland Children's Alliance, right?
Yeah.
And so the place for fine tuning any standards, should we need them, and we submit that we do not for all the reasons in our voluminous testimony, that would be the place under Maryland statute, or go to Comar and health regulation. Like this is fine tuning best practices in outpatient mental health, and we're doing it in the Senate Judicial Proceedings Committee, as opposed to health and people that do this stuff day in and day out and already have those standards.
Got it. Thank you.
Okay.
Thank you.
Thank you. The one thing that I think I was hearing the proponents talk about, I guess the best interest of the children, was letting them know, I'm talking about the children, that this provider may not have left on their own accord and they didn't want the child to feel abandoned. Is there some sort of notification or some sort of communication that's given to the children when that sort of thing happens?
Yes, if I may, Senator Sidner. And so the answer is yes, because and so the people who are doing any mental health provider has a licensing board. And so this bill, as you see, and in our testimony, the intent might have been mental health therapists, but it gets everybody. It gets everyone that has a license. So a mental health, any health professional, they all have licensing boards. They all have continuity of care standards. And those we put in our testimony, and they're alluded to by the proponents. There's things you're supposed to do. You're supposed to ensure continuity of care. If I fire everyone at my child advocacy center and I'm the clinical director, guess what? You're going after my license, right? Because I just fired everyone, and you can name my boss, and you can sue us for abandonment. So I can tell you that the internal policies for us, our child advocacy center, and they're voluminous. We have them because we have ethical duty and because, you know, we're all trauma informed. And so what we do, if it's a planned termination, we can sometimes offer a session. If it's appropriate under those circumstances with that therapist, we can offer a session if that's the right thing. If we know that this is going to be a planned termination. If it's a not planned termination, it might not be. Anytime anyone leaves, we will absolutely notify the parents immediately, and then we can try to reassign them in-house or give them the names of 3 behavioral health therapists. Best practice, it's standard. People generally have standards. I think the question in this case is what happens if something goes wrong? Are there remedies?
And since you're up there, I was familiar with LifeBridge, they and their CAC, but from listening to your panel's testimony, we're talking about different government agencies having them and nonprofits, and so I'm curious if you could just walk through, this bill, and I'm assuming it affects each of these would affect them a little bit differently.
It does. Thank you. For yours, for example, I think would be Baltimore County. So your child advocacy center is run by DHS and law enforcement together. So that's the entity. And so at in the Baltimore County, I believe there is a part-time mental health. You have one part-time mental health person who's in-house, and the majority of them are outsourced to a third-party provider with the linkage agreements that Mako was talking about. And so if you are asking them, your Baltimore County government agencies, to be responsible for the internal procedures of your third-party linkage agreement, how does that pressure work and where does the liability? And so all of a sudden, we're asking that you be sued or whatever. There's no enforcement mechanism in this bill. It's just sitting there in criminal procedure on its own. I don't know the enforcement mechanism, right? And so it's unworkable. And then provisions that could be unworkable is not just termination, it's the notice. Well, how are you going to give notice? What it means is if you have a change of provider, your third party mental health provider has to call up the CAC and say, hey, we're going to terminate this provider. Could you call CAC? Could you call the families? Well, the families don't have a relationship with you about that. The provider should be the one doing that, right? And so it's making you liable for what's going on. And it's also making you a conduit of communication, which has confidentiality issues. It's got independence issues, which could be challenged by defense lawyers in court. Right. And so it's when we say it's unworkable, it's not because we don't want to be regulated. It's just because the bill fundamentally misunderstands the complexity of child advocacy centers in the state. It's confusing.
And just so that I'm clear, you said that these children aren't going to be left feeling abandoned because they will be told or given some sort of notification that their person is no longer going to be providing services.
Yes, and I think there's testimony in the packet, and I think Will Laird will say this, but there's 939 advocacy centers around the country. There's 23 here. An issue of sudden terminations without notice is just not something that has ever come up in any of our attention. There is this one case which has disputed facts, and so the current laws and standards we think on abandonment and the duties of healthcare agencies we think have been sufficient so far among the professionals who have been doing this work.
Thank you very much.
Thank you. I don't want the assumption to be that every therapist that's terminated has done something wrong and they can't go back and tell the child what's happening. That's kind of the impression that we're having, is that there will be some reason that one would say this therapist cannot have any more contact, not even to say goodbye. That's not the case in 90% of the terminations of the services between a therapist and a child. Is that accurate?
Thank you. Thank you, Senator Muse. And also,
Now, I want to just check
Yes.
because we're going and so.
Sure.
policy
And
out.
so
But we have one thing here, how can, and if this is not the bill,
sure.
how can we be assured, not through policy, because that doesn't occur. I know I'm in and out of places a lot. How can we be assured that when there is nothing negative, and we say, well, can you contact the parents? Well, many times the parents aren't in their lives. If the parents were in their lives, they wouldn't be there. So that's not an issue. It's not, can you contact the parents? No, most of the times you cannot. But for that child who is now a therapist is no longer there, what is the guarantee, not by policy or word, because that if there is nothing negative in the relationship, meaning we're not talking about a therapist who is, blah, blah, half-witted, no, but for whatever reason, and in some cases, and that's why I did not want to bring up the case by name, because I know, but there are those who have claimed that they were terminated because they were whistleblowers. Now, if that is the case, then obviously the process doesn't work perfectly all the time. But we only have a kid here, not a process. We're here just to make sure that that therapist is able to say, not I'm leaving, goodbye, here, and not even here's why, but of my own accord, because of the devastation. Now, some people will take that lightly and say, well, who cares? If you were in my situation where you had to do it 11 times, no father, me, no, and you feel worthless already, what's the big deal about putting something in place that just makes it safe and guarantees it that will happen? What's the big problem with this?
I think because putting it here in the criminal procedure section of the code has nothing to do with licensing board, mental health professionals, mental health standards. And it's also, the mechanism is who? It says to the Hartford County Sheriff's Office, you now have to allow your third-party provider, Springboard, to have a termination session with whoever you fire, for whatever reasons you fire them, because otherwise the Hartford County Sheriff's Office or the Prince George's County Department of Health is now going to be sued if you don't. It takes away that discretion. There are procedures in place for termination. It is highly unusual. Again, I'm a lawyer, not a health practitioner, but I'm told by our clinical staff, highly unusual to allow somebody terminated that has the therapeutic relationship has been severed. And so it would be highly unusual to allow that. But to your question, I'm sorry, the best body to decide that probably would not be this one, but it would be the licensing, a child advocacy center, or the health professions that deal with this all the time.
Why don't you do this then so that we can both be involved? Why don't you give us the language that you think will accomplish this, then let us codify it, and then everybody's happy?
Because I think the language already exists.
Well, you think it exists. We're saying it's not. That's why we're presenting the bill. So does it exist or does it not?
When you, in terms of termination procedures?
Does the language exist that we're referring to relative to this bill or not? If it existed, then we would have known that before this bill was printed. You're saying the language exists that covers this. Where is it?
Right. It doesn't exist in.
That's my point. That's my point. And we keep going around in circles, and I just want us to be upfront and not talk in circles. No, it does not exist.
Right.
Because we want to make it exist. 3, we don't want general, because we're talking about children, Mr. Chairman, and I don't want generalizations that just confuse us for the sake of confusing us, because I've been there. So no, the language does not exist, even though you say where I think it exists. No, it doesn't exist. But if you leave us that way, we're going to believe that. So no, that's not the case. Number 2, if there is language to accomplish this, and if you really say we really want to get this done, long after you're gone, if you work there 20 years, 30 years, this will still be in place. It's not about you or anybody else. Give us the language that says this will assure that the goals of this legislation will be accomplished. I'm willing to take it, codify it. It's done, because it's for the good of the child. It is for when you are gone, when I am gone, that it's still done. So you know the intent. To be sure, we're not saying, and the other impression that is being given, of course, we're not saying if the therapist sexually molested the child. Of course, there are limitations. And what I'm getting from your side is that there are no limitations, that whatever, we have to do it now because it's law. No, we expect common sense to prevail. We expect a relationship, and a relationship that is important to that child, to be able to say, I have to leave. If you can give me that language that assures that, we'll work it that way, and then we're done with it.
Sure. And I think that mental health practitioners would be the best ones.
No, ma'am, I need to disagree with you, because everyone who comes in here says that, yet we have to legislate it.
Right.
If you're the best, I just don't want to hear we're the best one to do it. And that's my problem. Because when you say you're the best one to do it, it's as if you're saying no one is worthy of, I can't take advice. No, ma'am. We have to make those decisions. Police officers come in here and say, gee, you're not a police officer, but we have to make the decisions. I don't want us to be put down as if we not capable of understanding the issue and making decisions. And when you speak that way, that's what it says to us.
Right. And I'm not a mental health provider, so I would,
Okay.
I think that's.
Thank you, and thank you.
Thank
Mr.
you so
Chairman.
much.
Thank you.
Thank you very much. Seeing no other questions, we thank the panel. We're going to go now to the unfavorables, which are both virtual. Wendy Lane and Will Layard. Ms. Lane, you may begin. And it looks like you're on mute.
Okay, are you able to hear me?
We can hear you. Thank you.
Okay, thank you. Thank you, Chairman, members of the committee. My name is Wendy Lane. I am a child abuse pediatrician. I provide medical care at 2 child advocacy centers in Maryland, and I'm testifying today on behalf of the State Council on Child Abuse and Neglect and the Maryland chapter of the American Academy of Pediatrics. And let me say, first of all, that SCAN and Maryland AAP applaud the goal of SB 503 to ensure continuity of care for vulnerable children. Unfortunately, the way that the bill is written, the requirements it establishes aren't clear, and it does create an unrealistic burden on child advocacy centers and the medical and mental health professionals who provide care through those CACs. We talked a lot about the linkage agreements, the way that CACs are structured, and the requirement that CACs provide notice when the mental health providers aren't actually based at the CACs. There's also an issue for medical providers because those medical providers may be providing care on a one-time basis, and they are included in the language of this bill. And so it's not clear at what point we would need to give notice to a family that, let's say that the medical provider is leaving the child advocacy center. Who do we give notice to? Do we give notice to every child that we've ever seen? Do we give notice to any child who is coming back for repeat labs? It just doesn't quite make sense. And again, while I completely support the goals of the bill, the way that it's written and the fact that it's in criminal law really is concerning to pediatricians and to healthcare providers. So I ask for an unfavorable report. Thank you.
Thank you very much. And we'll finish and then we'll stay on. You do have a question coming from the sponsor. Mr. Liard.
Thank you, Mr. Chairman and members of the committee. My name is Will Laird, and I'm the State Government Affairs Officer for National Children's Alliance, and I'm here today to represent NCA's opposition to Senate Bill 503. National Children's Alliance is the nationally recognized accrediting body for 939 children's advocacy centers and state chapters in all 50 states. With all due respect to the bill's sponsors and proponents, we find this legislation to be ill-informed at best, unnecessary at least, and potentially harmful at worst. We believe the proposal is well-intentioned, but we also believe that there is good reason we know of no similar legislation anywhere in the country. Maryland statute requires that all CACs meet or exceed NCA's rigorous standards for accreditation. These recently revised standards represent the work of more than 130 child abuse intervention professionals, including members of the American Psychological Association, working from the latest data, evidence, and research. Continuity of care is, of course, an ongoing priority for all CACs. For this reason, NCA standards for accreditation require that therapists be licensed or working under the supervision of someone who is licensed while seeking licensure themselves. The effect of this existing requirement is to ensure that therapists are duty-bound by American Psychological Association and National Association of Social Workers codes of ethics. As such, all therapists have an ethical duty to appropriately transition those they can no longer serve for whatever reason. Again, we assume that this legislation is well-intentioned, but the actual effect of putting this requirement on CACs would be to confuse ownership of responsibility and could be used to deflect blame for dereliction of duty. I would caution this body against assuming that the narrow one-size-fits-all approach proposed in this bill would make sense for all CACs, given the diverse nature of their structures. In many instances, it would be wildly inappropriate for a staff member of a CAC involved in an investigation to then become directly involved in the provision of related health services, medical or mental. For those reasons, we would urge an unfavorable report and would refer the committee to our written testimony submitted in the bill file. Thank you for your time.
Thank you very much. Just to be clear, those of you who've already testified, you're welcome to leave. Senator Meeks.
Yes, thank you. Just a question, a comment. We keep saying it may be, and then we use the worst case scenario. And those worst case scenarios are not the norm. How about it may not be? It may not be a therapist that's terrible. It may not be a relationship that is in any way harmful. We're not talking about that. We're talking about the normal situations in which I suspect 95% of the therapists that your groups, that those that you're talking about, that you hire, at least 90 to 95%, unless there's some bad judgment on the part of hiring the wrong people, you're doing that. 95% of them, they work out. Is that correct? Any of them? I've talked with Mrs. Lane or Mr. Larrabee. They work out, right? You just shake your head or say. 99% of the therapists that you bring on board, they more than likely work out, and that you never find out that they were, it doesn't end with a bad relationship. Is that right? 95%, 90%, 80%. How many of them end in bad relationships to the point where you say to a therapist, you can't talk to this child anymore because you're in a toxic, and your termination and saying anything else to this child could very well be harmful?
Ms. Lane, could you answer that question?
I'm sorry, Senator. I didn't realize that question was directed at me. So I don't provide mental health services. I provide medical services, but I can say that it's very unusual. You are correct that either a mental health professional or a pediatrician or a forensic nurse would be terminated from a child advocacy center.
Then if it's unusual, how come those are the only examples that's being presented to us? They're telling us that it can't be done because of toxic relationships. They never getting to the point of what we're saying. Healthy relationship, the therapist has to leave, and the therapist wants to say, oh, the child wants to do it. And now stop with this. I heard many of you, and even in this room, say, I agree. They say, I agree on all the goals. You agree on the goals, you just don't agree on the process. If we're able to come up with the following, all of the goals we want to have accomplished, then you tell us how to get it done and we'll codify it. If that can happen, I'm willing to work with you 100%, because they keep saying I agree with the goals, but I don't agree with the process. In other words, I don't agree that you all should be telling us what to do by putting it in by codifying it. Give me any other way to accomplish these goals. I'll work with you and get it done. And it doesn't matter how it gets done. I'll wait to hear from you, Mrs. Lane, and anyone else who says that's not the way to do it. Please tell me so everybody's happy. I don't need to know now, because it's been a long day for the committee. Get it to me, get it to the chairman, just say, here's the way, and I'm going to give everything to my committee, and we'll try to work that out to get it done so that we accomplish the goal and the only thing that we will not been doing is you're saying, but we don't want you guys involved. If you can find a way that we can all work together, since we all want to do it, it'll be done. Thank you, Mr. Chairman.
And on that note, we end the hearing for Senate Bill 503. We're going to move on to Senate Bill 459. Senator Washington, you may approach, and if you have a panel.
Hello, everyone. Perhaps just to save some time, maybe my panelists would like to come up, if you don't mind. I think you know who you are, so if you just come up, Kimberly, Natasha, Bruce, there you go. Great. Thank you. Good afternoon, colleagues, Vice Chair, Chair, members of the committee. For the record, I'm Senator Mary Washington, District 43. Proud to represent Baltimore City and Baltimore County. I'm testifying today and requesting your favorable report on Senate Bill 459, restrictive housing limitations. To be clear, this bill is about the use of prolonged solitary confinement in our state correctional facilities. Solitary confinement goes by a number of names, including special housing units, administrative segregation, disciplinary segregation, restrictive housing, but the conditions are generally the same. 22 to 24 hours per day spent alone in a cell. Long ago, the UN condemned the practice as degrading and inhumane form of abuse, and that it amounts to little more than torture by any other name. Others say it is a violation of the Eighth Amendment, the Eighth Amendment's ban on cruel and unusual punishment. There are harms caused by solitary confinement. We know that. It creates or exacerbates existing mental illness. Many studies have documented that the detrimental psychological and physiological effects of long-term isolation. We think about our experiences over the last 3 years with our voluntary isolation and COVID and the feelings of being trapped and what those opportunities to not interact with those people who you see as a part of your social network, what that has done. It has disparate impacts on people of color. I don't need to explain that to this committee. The impact of solitary confinement especially impacts young people and young adults. Youth are still developing mentally and physically. A traumatic experience like solitary confinement can exacerbate or create the first time short and long-term mental health problems. Again, this experience can actually create mental health problems, and it severely heightens the risk of suicide. Now, this legislation is titled after Nelson R. Mandela. And for those of you who don't know, he served as the president of South Africa from 1994 to 1999. He won a Nobel Peace Prize. And also, for those of you who are still not quite sure, Morgan Freeman played him in Invictus with Matt Damon. Nelson Mandela spent 27 years in prison. He had received a life sentence in 1964 for fighting against the apartheid regime of South Africa. And he spent the first 18 of those years on Robben Island off the coast of Cape Town. Mandela's period of long-term isolation, however, began in 1982 when he was transferred. And he spent as much of the next 6 years in solitary confinement. I'm honored today to take up this human rights issue that has been championed by a former member of this committee, Senator Susan Lee, who now serves as our Secretary of State, and also many others in this committee. Most recently, this bill was Senate Bill 45 and was pre-filed by Senator Lee, and I've taken it up. Now, where have we been on this? In 2010, a study showed that Maryland places 8% of inmates in restrictive housing, twice the national average that was just 4 to 5%. In 2015, the state revealed in a letter to a legislator that Maryland's use of restrictive housing remained at 8%. The average length of stay in segregation was between 124 to 130 days. Mentally ill inmates fare even worse, according to the state's letter. They were placed in restrictive housing at a rate of 15%, twice that of the general population, and spent about 224 to 228 days in segregation. Now, it looked like we're about to do a turn in 2016. The Maryland General Assembly passed legislation to require the Department of Public Safety and Correctional Services to report annually on the use of solitary confinement or restrictive housing. Now, at the time, legislators and leaders and advocates had great hope. Former member Senator Mike Huff said, "This bill is a simple but crucial transparency measure. Unfortunately, people with mental illnesses often end up in prison and then in solitary confinement. This bill will help identify if that is a problem in Maryland." Former Senator Lisa Gladden said, "I have been fighting for the passage of this important bill for several years. I am grateful that the Maryland General Assembly is moving towards rectifying the multitude of injuries created when solitary confinement is imposed. Even the federal government is making great strides to curb the use of this form of punishment." And then Senator Jill Carter said, "Maryland uses solitary confinement at twice the national average. That is unacceptable. I hope this reporting requirement will encourage our corrections officials to rethink the way they treat our brothers and sisters behind bars." And this is a bipartisan, as you saw with the first pass, but even former Delegate Trent Kittleman said, "Transparency is the first step towards accountability and reform." Secretary Moyer, then Secretary, is committed to reform in this area, so this bill will support his efforts. And Tony Holness of ACLU said the overuse of solitary confinement is inhumane and a waste of taxpayer dollars. This bill will shed light on this ineffective practice. And finally, again, in 2016, upon the passage of that legislation, Rabbi Feinberg of the Interaction for Human Rights said, "At last, transparency about the use of isolated confinement in Maryland, good for us all." 2017, November 12th, 2017, Emily Butler, age 28, died of an apparent suicide at the Maryland Women's Prison in Jessup. It was the fourth reported case of an inmate committing suicide that year, and it appears to have been part of a pattern linking such deaths to the kind of physical confinement inmates experience behind walls. Emily Butler wasn't in her cell. She was in solitary confinement, but at the time, Maryland officials said solitary confinement did not exist in our prisons. 6 weeks prior, an inmate who we will call Elaine was discovered with a sheet tied to a vent around her neck. Emily Butler was discovered also in a segregation unit, hanging from a sheet tied to a vent in her cell. Emily was going to be paroled in 6 months, but because she had received this disciplinary action, it would extend her time, and she was not willing to do that. 2018, the year of the last substantive report that was required by the 2016 legislation, revealed that 50% of those in prison were placed in solitary confinement. 2019, the chair of this committee and your former legislator Lee sponsored legislation to mitigate the isolation of pregnant women or of minors. In 2022, according to a report published by DPSCS, the average length of placements on any form of restriction in housing was 42.5 days, and 75.6% of our prison population was put in restrictive housing last year. There has been a 70% increase over the time I have spent in this legislature. It appears that the steps that we have taken have been half measures and that they are not forceful enough or decisive, and they have not reduced, but rather emboldened solitary confinement use. Therefore, it would appear that solitary confinement has become a part of ordinary practice rather than the exception. This cannot continue. So how do we take meaningful action? Colleagues, Senate Bill 459 is 12 pages long, and it does not remove solitary confinement as a form of discipline or inmate safety. While imperfectly drafted, I admit, it aligns closely with what are considered the Nelson Mandela rules, the rules that have been set up by the United Nations, which seeks to achieve the goals that if you go to page 11 of the bill and read page 11, lines 22 through page 12, line 6. The Department of Corrections shall, under SB 459, they shall, 1, improve the conditions of confinement in restrictive housing by allowing opportunities for out of cell time and congregate activity, provide incarcerated individuals in restrictive housing daily outdoor recreation, limit the number of violations, 2, limit the number of violations that are eligible for disciplinary sanction. Emily Butler was put in solitary confinement for throwing coffee on an inmate. They were friends having a fight. Even the friend said, no, admitted that they were just having a fight, a friendly fight, as that goes. So limiting the number of violations, the bill does go into a great deal of specificity around that. Eliminate restrictive housing sanctions for the minor relations. Those are violations, those are related. There's disciplinary sanctions. This is not to be a form of discipline. Solitary confinement is not to be a disciplinary sanction, but rather should be for safety. Okay. Create de-escalation spaces. There are alternatives. Establish a system that allows incarcerated individuals in restrictive housing to access those spaces. Create, in coordination with incarcerated individuals entering restrictive housing, some strategies, and amend the policies to specify that disciplinary segregation is a sanction of last resort. As I said earlier, the bill before you as drafted is imperfect, but the issue that it seeks to address is well documented and the research is clear. Solitary confinement causes long-lasting harm. It does not increase protection of the inmates. The effects of solitary confinement on mental health can be lethal. Nationally, even though people in solitary confinement comprise only 6% to 8% of the total population, they account for approximately half of those who die by suicide. Say her name, Emily Butler. In conclusion, I ask for your favorable report of Senate Bill 459. I'll now have my panel talk with you, and after they've spoken, we're here to answer your questions.
Sure, go ahead, quickly.
Let me say, thank you for bringing this bill. It's a good bill. And I will say that name. And I did say that name when you said it, because there's so many Emily Butlers who are unnamed, but they go through the same thing. The only question I have is this. You made the point that I would like for you to just lift up, that some people think that solitary confinement is because you deserve it. You did something so bad, not presently, but well, they robbed somebody. I don't really care if they in that. That's a long time ago. They deserve it. Deserve it. Others will say, well, they threw a cup of coffee, they disrespected me. But isn't it really just you're only to be there when you are a risk to yourself and to others, not based on someone's perception of I like you, I don't like you, you spit on me, you made me angry, you did armed robberies, so I don't care how many times you go in there. All of that's irrelevant. Am I correct in that it's only for safety to yourself and to others?
Senator, you are correct. The punishment is incarceration.
Correct. That's right.
There is no need for additional simple discipline punishment.
Thank you.
Again, very clear, that does not say that there is no reasons or reasonable reasons, and again, they are set forth in this legislation, and if the committee wants to, can further elaborate them or not, but there's very clear, because it's not clear about what is discipline and what is punishment and what is to protect the safety of the public that is within the institution. The other thing I neglected to say is that one of the amendments, and it probably affects a lot of the people, we tried to get notices to folks, but this will only have to do with state-run institutions. So we are not extending, there's an amendment, and we're not extending this to jails, to local jails. We should clean up our own houses first, and then we'll get the rest.
So if someone comes and it's not state run, we don't have to listen to them.
Well,
We
this
can-
is the state.
We can tell
yeah,
them they can go
if
home.
they want.
They can go home now if they want to, so we don't have to go over. Okay, that helps us a lot. But thank you very, very much. It's a good bill. I want to support it all that I can. And I think it helps us with some real ills. That we
Many
need to do.
people have carried this for many years. I hope I can help take it over the line. And you're going to hear from them now.
Good afternoon, Mr. Vice Chair, members of the committee. Welcome, Senator Kelly, welcome. My name is Kimberly Haven, and I am the legislative liaison for Interfaith Action for Human Rights. 75.62%, 11,953. I want you to keep those numbers in your head while I'm talking. What I want to do is say what this bill is and what it doesn't do. First of all, as Senator Washington said, this legislation does not apply to, it does not include, nor does it impact local jurisdictions. We heard their concerns in the House, and we offered an amendment that would exclude them, an amendment that was agreed to. What this is an opportunity for Maryland to do better, to rise up to our moral mandate of humanity, to become a national leader and be on the right side. The numbers that I opened with are the number of individuals that were placed in restrictive housing in fiscal year 2022. The 75.62% number is the number of our total population that was placed in restrictive housing. The United Nations has determined that more than 15 days in solitary confinement is torture. Maryland practices exceed that level and do so in far too many cases. This needs to change. Restrictive housing must be our sanction of last resort, not our first response. This bill puts into place guardrails to address the misuse, overuse, and abuse of restrictive housing. I want to end very quickly with invoking again the name of Emily Butler. I knew Emily Butler. I'm still traumatized by Emily Butler. Her death while in solitary is going to cost our state millions. Now take that millions and multiply that by 11,953. The Maryland Mandela Act can answer the question. I swear this was 2 minutes when I practiced. May I have 1 more minute to finish my thought, Mr. Vice Chair?
So not more, 1 more minute, but if you have a couple concluding remarks, we'll be happy to hear them.
I do. Okay. The Maryland Mandela Act can answer the question. When presented with the opportunity to be on the right side of a movement, of a moment, of history, did we do the right thing? People are sentenced to prison for punishment, not to be subjected to torture. Did we do the right thing? Will we do the right thing? We urge a favorable report on Senate Bill 459. Thank you.
Dr. Lucy Steinitz, thank you, Senator Washington. Thank you for accepting my testimony, particularly Senator Jeff Wallstreicher from my own district in Silver Spring. I come here as an active member of Major IAHR and as a mother of a formerly incarcerated person in the state of Maryland. You'll hear arguments today still that this applies to local jurisdictions. It does not. You may hear that it involves millions of dollars of training, which it does not. You may even hear that solitary confinement benefits mental health and is used only for people who are actively violent, as was said in the House. That is so untrue, I don't even have words to think how to respond. Maryland ranks among the top 10 states in the country with prisoners in solitary confinement. Our state's use of restrictive housing, solitary, is twice the national average even today. On a percentage basis, it's higher than in Mississippi, Texas, and Alabama. Really? Is that how we like to see ourselves in Maryland? 40 states have lower rates of solitary confinement than we do, often with lower recidivism rates. By contrast, we actually increased our use of restrictive housing by 39% last year. Why are you going to hear so much opposition from DSPCS, the Maryland Sheriff's Association, and the Maryland Correctional Administrators Association? The reason is that putting prisoners into long-term or repeated solitary confinement makes for easier staff management. Let's be clear. We are saying that solitary confinement can be used as a temporary measurement for someone's own protection or others in the facility. But solitary confinement should not be used as a tool for management for repeated or long-term isolation when there's no immediate threat to safety. Most persons in restrictive housing come out of prison one day, putting our communities at serious risk to the increased mental health damage incurred during solitary confinement. That puts our families and communities in danger too, not just those behind bars.
Thank you, Ms. Stein.
Please give this a favorable review. Thank you.
Thank you.
Hi, excuse me. I'm Judith Lichtenberg, but I'm now here to give the testimony of Margaret Barry, who had to leave early, thinking that this was going to be the first bill heard. She is a professor emerita of law at American University.
So I'll just repeat, we generally do not allow designated hitters here and we, but it's an important issue. We'll certainly allow you to testify and we're sorry for any confusion. But just for everyone who is here, you should know that our policy is that if you're not here, you're not able to testify. So go ahead.
I will tell her. She just really wanted to give one example of a person in Maryland that she knew as a lawyer. She as a lawyer knew. He was in prison for 40 years, spent 5 years in solitary, allegedly for his own protection. But he never wanted it and fought all the time to get out of solitary. He described battling to hold on to his mind. He said he was lucky that he had a few books, a tattered Reader's Digest, a dictionary, and from time to time a book. Others he knew had no such luxuries. He was in a small, essentially barren cell for 23 to 24 hours a day by himself. The 1 hour he had out had to include exercise and what he called the dog run, a shower, and any phone contact he could squeeze in if allowed. On weekends, he was in the cell for 24 hours because staffing was reduced. He's been out for 10 years. He says he still battles the paranoia, the difficulty in being with others, the anxiety attacks, the battle to build, the battles to hold on, and what he describes as physical deterioration that happened in those 5 years of isolation. We know that solitary doesn't work. We know it's cruel. And so we urge the committee to favorably report on the Maryland Mandela Act. Thank you.
Good afternoon, Vice Chair Wallstreicher, my Senator Ariana Kelly, welcome, and members of the Judicial Proceedings Committee. My name is Bruce Turnbull. I'm a resident of District 16. I'm testifying today in support of SB 459. I'm speaking on my own behalf, but I am authorized to say that Jews United for Justice supports this legislation. I want to make 3 points quickly. First, core principles of my Jewish faith, principles that are largely common to all faiths, include a belief that all persons are made in the image of the divine and must be treated accordingly, and further, that those who commit wrongs and those against whom wrongs are committed must be afforded the opportunity for restorative justice, allowing healing to take place in order that all affected, including the broader community, can return to the path of righteousness. The overuse of restricted housing is fundamentally at odds with the treatment of human beings as in the image of the divine and with restorative justice that is needed for all. In short, such treatment is immoral. Second, the international community and the psychological community have found that extended solitary confinement, longer than 15 consecutive days, is tantamount to torture and results in serious, often permanent, and psychological and sometimes physical damage. Third, I want to emphasize that the sponsors and supporters of this legislation have listened to the comments received in relation to the House Judiciary Committee hearing on the companion bill in that body and are prepared to make several amendments. As you heard, the most significant is the exclusion of jails and other detention facilities operated by local jurisdictions. With these amendments in place, it is hard to understand any objections that continue to be raised. The bill would simply ensure that Maryland prisons no longer engage what is generally agreed to be torture. Thank you, and I urge favorable report.
All right, questions for the sponsor or this first panel? Senator West.
Thank you, Mr. Chair. So I guess Senator Washington, you said twice during your testimony that this bill was imperfectly drafted. I don't think I've ever heard a presenter say that before. Would you be able to provide us with an amendment which you believe would cure the imperfect drafting of this bill?
Absolutely. Several. There are, as noted, and some of them, in fact, were pointed out when you read the letter of the Department of Corrections. There are some inconsistencies in days. There's just, some drafting differences. As I said, I accepted this. So I believe, yes, I believe that we can work to make it better.
So the Department of Public Safety and Correctional Services states that this bill poses operational challenges.
Right.
Can you respond to that concern?
I think you'll have to ask them that. That was one of the things that I did not agree with. I'll just, but the one that I did agree had to do with, they pointed out some contradictions between, some times and days and amount of time. And I agree that those should be there. I also believe that their job is to manage and operate our correctional facilities. And I would hope that they would want to do it in a constitutional manner and a way that protects human dignity of all involved. So if there are procedural or management issues, then we can certainly raise that. We also know that many of the over the last 8 years that many of our agencies have been decimated in terms of their staffing and lots of core support. I anticipate, given the commitment of Governor Moore, that the Department of Corrections, just like any other department, will be fully staffed and supported.
Okay, next, there's a lot of unfavorable testimony planned in this bill from various county sheriff's offices. As I recall, you told us that the applicability of this bill to the local counties has now been eliminated.
Absolutely. And so if you'll know, I don't know if they had an opportunity to do it, but the Maryland Chiefs and Sheriffs Association and the mayors, they have withdrawn their opposition through their lobbyists. And then again, I had my phone numbers. I tried to call all of them in particular to say that, this no longer applies.
And the last thing, let me just refer to one portion of the testimony that's going to be provided by the Department of Public Safety and Correctional Services that moved me. They said the bill defines restrictive housing as any form of housing that separates incarcerated individuals from the general prison population. And they say that broad definition would include specialty placement units and protective custody that incarcerated individuals may request. Do you agree that maybe
So
some work needs to be done on that definition to provide exceptions or narrow it?
So, no, so there would be very clear that it's by request, right?
Right.
And so then it sounds like there's someone that wants to address it more broadly. So I will allow her to do that.
I'm so sorry. Senator West.
Could you stand up to the podium?
Sorry. Senator West, thank you so much for that question. We went line by line through the department's letter of information and addressed every single one of their points, including issuing amendments to the bill to clarify the dates and times in the process and putting in those guardrails. So we have addressed every single one of those conditions and the concerns that the department had.
Are those amendments reflected in the copy of the bill that we have here? Or are they separate amendments?
No, they are being drafted, and actually even through my last review, my personal review, I have additional amendments. So we will do the work so that this can be acted on in a timely fashion, but it will be comprehensive.
Okay.
As I pointed out earlier, this has been long within our purview, and we should do some action. We should act.
Okay, let me just finish by one last question, preceded by a comment. You know, we're at the end of at the effective end of our time to pass bills. What I call it the crossover crunch. So we got to stop working on these bills a week from next Monday. Sounds like there are lots of amendments. Would it be helpful in this case for us to consign this to summer study so that you could come next winter with a bill which contains all the respective amendments and perhaps with some buy-in from those who are opposing the bill today? Or do you think we can still get it done this year?
You've been here probably a little more than 8 years, and you know miracles happen.
Same amount of time.
Bills just out of nowhere.
All right.
But the amendments and you know, I'll just can show you that I'm not, they are very specific. We've gone through, we know exactly where we want to change. We'll be able to work very closely with the bill drafters. We're in dialogue with them now. I truly believe we will be able to provide you with something that's workable and votable.
Thank you for that.
The other thing I'd like to point out, Senator West, if I may, is that this version mirrors the House version. And the delegate in the House, Delegate Bartlett, is amenable to keeping them as conformed as possible because we have tried to work on this for so many years, as you know. But also, I had a very long conversation with the Correctional Officers Union today, and they're in support of this bill. They offered an amendment. We accepted it. We want to work with them. We want to work collaboratively. And so to the exclusion of the locals, which I just want you to kind of keep in the forefront of your mind, but I also want you to think about the 76.28% of people that we're talking about. Because we have been working on this for a very long time. As the senator said, most of you have already known that I've come before you. We've talked with, all of you at some point have had your hands on this bill. It is time for Maryland to do the right thing. There's already 20 other states that have done this without any adverse impact. In fact, when they show that there are alternatives and there are de-escalation opportunities, violence goes down. And this is just good policy.
Thanks for your.
Thank you.
Thank you. Any further questions for the sponsor of this panel? Seeing none, thank you very much. We'll then go to the list here. Jason Billingsley, Quiana Johnson, Natasha White, Ms. Hilliard, Ms. McKinley. And that's it for our favorable, it appears. Whomever would like to go first.
Good afternoon. My name is Sarah McKinley, and I'm a student social work intern with the Office of the Public Defender in Washington County. March is Social Work Month, and this year's theme is Social Work Breaks Barriers. I invite you to join us in breaking down barriers for a historically vulnerable and underserved population. Something that is not often considered with individuals in carceral settings is the role that trauma plays in criminal behavior. ACEs are potentially traumatic events that occur before the age of 18. An increased ACE score correlates to an increase in mental, physical, and behavioral negative outcomes. According to the Compassion Prison Project, 98% of people in our jails and prisons have one or more ACEs. Since I've been an intern with the Office of the Public Defender, I have seen a common preponderance of ACEs and mental illnesses when performing assessments with our clients. Many people in our carceral system are being punished for having mental illness, which directly correlates with their ACEs. And for that reason, we have some of the most traumatized people in our society inside of our jails and prisons. Because correctional settings serve people who bring their traumatized and troubled histories into the jails and prisons with them, the characteristics of confinement can trigger PTSD reactions. This makes it essential for anyone working with individuals in solitary confinement to be trauma informed so they can recognize and respond to the signs, symptoms, and risks of trauma to better support the health needs of people who have experienced ACEs and toxic stress. Additional training to ensure that all staff are trauma informed is beneficial to everyone and will in turn provide a sense of safety, empowerment, and trust in correctional settings. The UN considers solitary confinement to be torture, and it has been reported that the psychological effects of solitary confinement are equivalent to physical torture. Physical and social isolation combined with sensory deprivation and forced idleness create a toxic combination associated with a variety of harmful effects. As lawmakers, it is up to you to make the best decisions that provide the most beneficial outcomes for the individuals and communities you represent. I ask that you make a favorable report and pass the reforms outlined in the Mandela Act that will bring Maryland in line with the rest of the world. Thank you for your time today.
Good evening, Vice Chair, remaining members of the committee. I'm just going to reiterate 3 points. First, when someone spends more than 15 days consecutively in solitary confinement, that is psychological torture. It's torture. It's not punishment, right? The person is already incarcerated as their form of punishment. It is not cognitive behavioral therapy. It is not a way to change the behavior of someone. It is torture. My second point is that we understand that this bill proposes a significant increase in the training of the people who are working with our incarcerated individuals. We think that it is paramount, regardless of the cost and regardless of the hours that it will take, that the people who are in charge of the Marylanders who are in cages understand trauma, understand the impact of trauma, and understand how to treat people who have been traumatized in their life. Third, and finally, we urge that the committee consider that as we've removed the county and as we've removed the county detention centers, we are giving DPSCS an opportunity to forge a new path and to seek healthy, both mentally and physically, alternatives to solitary confinement because it cannot continue. We urge a favorable report and we thank you for your time.
Thank you. Questions for the public defenders, Senator Washington.
Fast for the public defender, just because you mentioned that 3 days of solitary confinement is too.
15 consecutive days.
Got it. Thank you.
Yeah.
Thank you. Appreciate that. All right, seeing no further questions for the proponents, we'll move to the opponents. My understanding is that the bill is being amended to write out our local jails and detention centers. I know a lot of these folks signed up before that amendment happened, so may not be here, or if you are here, you are certainly not obligated to testify if the amendments address your concern. And with that, I'll just go through the list here. Walt Pesterfield, Timothy Seelan, Thomas Reese, Daniel Lasher, again, if you've been written out of the bill but have other specific concerns, please let us know, but no obligation to testify if you're now written out of the bill.
Mr. Vice Chair, you didn't call my name first, but I would like to clarify something because it's important on what you just said. I've seen the amendments and they weren't officially drafted, but I've seen them in a Word document. I've seen the response to the DPSCS's letter of information. There's this talk about the locals being taken out, but I want to draw everybody's attention to the current law. The preamble to this bill specifically talks about repealing and reenacting 9614 A1 and A3 and then adding two other sections. What it doesn't repeal and react is A2. A2 defines a correctional unit. Subtitle 9 affects both the state and local correctional facilities. Item number A2 defines a correctional unit as defined in Correctional Services Article 2-401, which includes both state and local facilities. So unless A2 was addressed, and no one's talked about that, I've seen the amendments, I've seen the preamble, I know it's in the bill. If A2 is not repealed and reenacted, there is no amendment to pull the locals out, because the section of law defines the correctional unit as both the state and local correctional facilities under Correctional Services Article 2401. So I just want to state that for the record first. I'm Director Brandon Foster from the Charles County Detention Center. I am signed up for testimony. Mr. Vice Chair, members of the committee, thank you for having me here today. I'm Captain Daniel Lasher. I operate the detention center in Allegheny County, and I've been in corrections for 32 years, 25 of those years in management, and I'm here today in opposition to Senate Bill 459. I manage a facility that currently holds 172 inmates. 97 of my inmates are on psychotherapeutic medications. That's over half my population. Some manage well, however, some, even medicated, cannot control their behavior. Some refuse to take their medication and are constantly disruptive to staff and other inmates. Over the past year, my staff have dealt with inmates that are screaming racial slurs and sexual content for hours upon hours, day after day, beating their heads against the wall until bleeding and both their eyes are blackened, constantly kicking cell doors, spitting in the face of the correctional officers, throwing urine on staff repetitively and flooding their cells, smearing feces upon their cells and themselves so that they would be more difficult and we'd have to deal with them. These are just a sample of what my colleagues and our staff witness regularly. It's reasonable to assume that these individuals need intense psychiatric assistance, and you'd be correct. So petitions are filed, evaluations are scheduled and held, commitments are issued to transfer these people to MDH, and this process alone takes several months. Once a commitment is obtained, we're waiting several weeks or months for placement into a facility. Month after month, MDH has reported to us that they have between 130 and 160 inmates that are being held in local detention facilities who've been committed to their custody, but they have no beds for them. In my facility, I currently have 7 inmates who've been committed to MDH and are awaiting a bed and transfer. This bill identifies a vulnerable individual as a person who has a serious mental illness. It states they may not be placed in restricted housing. In a facility with over 50% of the inmates on psychotherapeutics and acting out the way they do, I have no other option but to restrict those who act out for their protection, the protection of my staff and others. The bill dictates that the same services be provided to these individuals when it would be unsafe to do so. It requires to be able to be out for 4 hours to their cell for programming plus an hour for rec per day. There aren't enough hours in the day for the people on restricted housing to do that. So I ask that you rule unfavorably on Senate Bill 459.
Good afternoon, well, almost evening. I'm Captain Tim Seal in Frederick County Sheriff's Office, and I'd like to thank Mr. Vice Chair and members of the committee. I'm going to talk about only a couple little things. Training that is in the bill on page 2, sections 5 through 9. It talks about the training in order for us to comply with this bill. And this would actually apply to DPSCS. All staff would have to have an initial training of 40 hours. That means all staff that would be working in those sections. In Frederick County, we basically have 4 posts that have worked the housing units. 3 of my posts have some form of restrictive housing based on the definition in this bill. There's also an additional week of training at the academy, since everybody that goes through our academy would have to have 40 hours of training. On top of that, the bill also requires 40 hours of specialized training for staff involved in disciplinary hearings. All total, for, at least for my facility, we figured that would be approximately $200,000 for the first year. And $50,000 for every year after that, and we only have 100 officers. Just keep in mind that my facility's budget for overtime, because we have to do all our training on our days off. My entire overtime budget is only $277,000 for the year. The next thing I would like to talk about real quick, since I have 10 seconds. The definition of restrictive housing means anywhere not in general population. This would include mental health, suicide watch, people in our medical unit, protective custody, disciplinary, our youthful offenders. We had last year 7 youthful offenders in my facility. Most of the time, there's only one. If they're by themselves, I can't put them because of PREA with adult. What am I supposed to do?
Thank you so much for your testimony.
All right, thank you.
Good afternoon, Vice Chair and members of the committee. My name is Walt Pesterfield, and I am the Director of the Baltimore County Department of Corrections and Detention Center. I am speaking on behalf of the Baltimore County Department of Corrections and the Maryland Correctional Association. I'm here today to support MCAA in opposition of this bill 459. Baltimore County Department of Corrections has the largest capacity of any detention facility in the state of Maryland, and our current population is 1,057. Of the 1,057 offenders, 33% or 342 offenders would be ineligible on age alone with this bill. Baltimore County Detention Center's data from December 22 indicates that 34% or 366 offenders would be ineligible for restricted housing only based upon age. I'm not going to get too much into the cost of it, but I'll say it's over $500,000 for training in the first year for our department. One of the biggest concerns that I have is between the ages of 26 and under. That's a large portion of our clientele that comes through as inmates in pretrial. That's very restrictive. Also, I'm going to hit on the point of when individuals identify as or perceived as lesbian, gay, bisexual, transgender, nonconforming, or intersexual. That also is a big section. I have a staff of about 243 officers. 60% of those officers are female. And I'll just pull up our data sheet from our dashboard. Between 10/1 and 20 and 9/30 of 21, we had 0 placements or anything else but discipline. We were at 10 days median and restricted housing. We were at 9.9% of placements. If we don't have the ability to do that, officers get hurt, they get injured. Inmates get hurt, they get injured. It's a tool that we have to be able to utilize for the safety of our facilities, any facility, any detention or prison facility. You have to have this to be able to manage those to a certain extent. Do we want long-term? No, but it is very important.
Thank you for your testimony. Appreciate it.
Good afternoon, Mr. Vice Chair. Good afternoon to the remaining committee members. We appreciate you sticking around. I'm Major T.D. Reese, the administrator of the Calvert County Detention Center. And I'm just going to break down a simple formula of jail populations. 90% of all inmates held in jails and prisons, they know what they're in jail for. They accept their situation and will patiently await their trial date or their release date. This population does not want inmates running the facility. They do not want to be threatened, intimidated, or assaulted. They do not want to feel the stress and the pressure to choose a side for their protection or their living conditions. They only want to do their time and not be bothered. Approximately 10% of a local jail's population wants to continue to operate their hustle and their crimes while incarcerated, using fear, intimidation, and cunning to enact their will over others. They do not like the rules and regulations, nor are they prone to abide by any. Within this 10%, however, there's 3% that are dangerous. They're dangerous to the other inmates as well as the staff. This 3% of the population desires to be in control, to lead the other 7% into bullying, assaulting, stealing, intimidating the other 90%. One major responsibility of a correctional officer's job is to ensure this 3% is not successful. When this small segment of the population acts out, no matter the degree, there must be a reaction by the staff. The other 90% is watching us. They know it is our job to ensure a controlled and orderly housing unit and facility. A sound, orderly, and consistent disciplinary system shows support for the 90% that are not a problem. If this 90% believes that we don't care about them and we are leaving them to the mercy of the 10%, then all 100% become a problem. The facility becomes inefficient and unsafe for everyone. The use of restrictive housing is an essential tool for the shift supervisor to protect and reassure the 90% that we absolutely do care about them and we do appreciate their appropriate behavior. It encourages the inmates to let us handle the problems through the use of disciplinary process. The inmates do not need to handle the situations on their own. This very restrictive bill would erode this control and result in chaos. And I ask you to support MCAA in all local jails by opposing Senate Bill 459.
Thank you. Senator Washington has a question.
Sir, this might be for you, whomever wants to answer it. What's the current process for training, or is there a current training for individuals or personnel who supervise individuals in restrictive housing currently? Are there any current training standards? And it can be yes or no. You can just send it to us. If there's not, there's no. Okay. For restrictive housing. Okay, thank you.
All right, thank you so much. Any further questions for this panel? Seeing none, we'll move on to other opposition to the bill. Mary Ann Thompson, Guy Merritt. Mr. Foster, if you had further testimony that you'd like to give. Dennis Strawn. Please.
Yes, Mr. Vice Chair, members of the committee, I am Brandon Foster, the Director of the Charles County Detention Center. I'm speaking on behalf of the Charles County Sheriff's Office, the Maryland Correctional Administrative Association, and also represent the exceptional and often unrecognized correctional officers across the state and incarcerated persons in Maryland who simply desire to do their time safely and be better people when they are released. I also represent our brothers and sisters in DOC as well. Our first mission and role is to provide safety for the safekeeping and welfare of those placed in our custody. Our secondary mission is to provide meaningful programs and services for the rehabilitation of inmates and to be a positive influence in their lives while they're in our care. We would never be able to accomplish either without the use of restrictive housing. Contrary to the testimony of many advocates for the abolishment of restrictive housing in jails and prisons, modern-day correctional managers do not torture inmates nor lead them to suffer mentally and physically. Restrictive housing decisions are very carefully made. The mental and physical well-being of inmates are always priority and least restrictive means are always considered. The use of restrictive housing in correctional settings is critical necessity, and the decisions concerning its use must be under the full authority and discretion of experienced managing officials. Limiting the use of restrictive or restricting its use by law would place managing officials in a very terrible situation whereby they would be limited in taking necessary action to protect the vulnerable and maintain good order and discipline. These conditions would set the stage for managers to ignore risk and be deliberately indifferent toward the safety of all persons in a correctional facility. The language of this bill demonstrates a misunderstanding of jail and prison operations. It is extremely dangerous and would create potential risk of life and limb to confined persons and those responsible for their care and custody. Whether it be enemies, co-defendants, witnesses, mentally ill persons, vulnerable persons such as elderly and youth, or those who are extremely violent, the decision to place an inmate in restrictive housing must reside with managing officials of jails and prisons in Maryland. This bill is very intrusive. I would mention that in California's 22 legislative session, a similar bill was introduced and reintroduced this year under the name the California Mandela Act. And California's Governor Newsom vetoed it in writing last year, quote, saying the bill establishes standards that are overly broad and exclusions that could risk the safety of both staff and incarcerated population within these facilities. I think Governor Newsom in California recognizes the risk as we do, And we ask for this committee to give an unfavorable report on SB 459. Thank you.
Whomever would like to go next.
Good evening, members of the committee. My name is Guy Merritt. I'm Deputy Director for the Bureau of Administration for Prince George's County Department of Corrections, whom I represent here in opposition of this bill. I'm also a licensed clinical professional counselor in the state of Maryland. Prince George's County Department of Corrections understands the health and welfare of each inmate is positively affected by housing the individual in the least restrictive and most appropriate environment possible. Our overarching goal is to successfully move individuals as quickly as possible to the least restrictive environment manageable for that individual. Senate Bill 459, however, holds generalized mandates that ignore individual clinical and facility safety needs. The maintenance of order within the housing units and thereby overall safety depends upon the disciplinary process which addresses presented behavior. Our hearing process is timely, requiring classification staff to complete a hearing within 72 hours. Our staff uses behavioral incentives to accelerate movement towards less restrictive housing environments as reward for positive behavior and engagement. In cases affected by psychiatric diagnoses, and in our case, it's over 50% of our population, the individuals are referred to mental health staff and the case is handled by a special board consisting of medical or mental health staff and the classification staff to determine a plan that works towards least restrictive housing. Senate Bill 459, however, relies on timelines and approaches that do not consider the individual nor the safety needs of staff and other incarcerated persons within the facility. Thank you.
So good evening. I'm Mary Ann Thompson. I'm the warden of the St. Mary's County Detention and Rehabilitation Center and the president of the Maryland Correctional Administrators Association. The safety and security of those entrusted to our care is paramount. The old philosophy of lock them up and throw away the key is no more. Correctional philosophies have evolved to a health equity mission. Our facilities must be safe and secure, providing therapeutic environments for the physical and psychological well-being of both the incarcerated individuals and those corrections professionals who walk, quite frankly, the toughest beat in America. Without restrictive housing, jails lose the ability to keep those in behavioral and mental health crisis safe, as well as other incarcerated individuals living in the same housing unit. No two jails are alike in Maryland. There is a misnomer. The jail medical and mental health programs provide the same level of service as a hospital. Jails have become de facto mental health institutions. An individual cannot be forced medicated as jails do not have the resources of the state mental hospitals, nor are jails authorized by law. The Maryland Department of Health is underfunded for hospital bed space, and there are not enough mental health resources in the community. The law clearly states the incarcerated individuals to be transferred within 10 days of being found incompetent, and this is not happening. There are many incarcerated individuals who are found to be competent, however, have serious mental illness. Administrative segregation is the only option for these incarcerated individuals. The offender reentry process begins at incarceration to ensure the best possible safety net at release. House Bill 116, which is now law, requires all local detention centers to screen all inmates to provide medication for opioid use disorder. And it also requires all local detention centers to screen for substance abuse disorders and behavioral health, provide medication, substance abuse and mental health counseling, peer recovery specialists, and every incarcerated individual to have an offender reentry plan. So case management for an offender reentry begins at the time of incarceration. Local jails are the places to effect positive change in an individual's life, but there must be safe environments for the incarcerated and the corrections professionals who choose to walk within these walls. So thank you very much. I appreciate it.
Good afternoon, Vice Chair. Thank you for this opportunity to testify today. I'm Colonel Dennis Strine from the Carroll County Sheriff's Office and the warden of the detention center. I'm here today in opposition of Senate Bill 459 on restrictive housing. Our correctional officers work hard, often for long hours and under difficult conditions. We must protect them from unreasonable danger and be able to effectively handle and classify inmates that conduct predatory and aggressive infractions within our institutions. Administrative and disciplinary segregation is the key to ending immediate threats to staff or other inmates that eliminate potential for further dangerous interactions among others. One of the reasons that you do not consistently hear traumatic and grisly stories from local jails is primarily due to the ability of the wardens to exercise their due diligence in segregating problems to maintain control. If the deterrent value of disciplinary confinement is removed, as this legislation would do, inmates will have little incentive to follow the rules. People will get hurt or worse, to include other inmates. Without a system to prevent order, the inmates will be forced to take matters into their own hands and to protect themselves. Corrections have been asked to support and accomplish many legislative items, but I cannot support legislation that I and the other wardens see as posing an unacceptable risk to the safety and security of inmates, staff, and the public. Allow me to finish by asking each one of you to recall the definition of vicarious liability. If this bill is passed and signed into law, it not only forces me to make irrational decisions, but to take unnecessary risks that I know are detrimental to the health and safety of every officer, employee, visitor, and inmate, and completely opens myself, the staff, our county, and the state to future litigation. Please vote against this intrusive measure. It's not only bad, it eliminates us as professionals and our decades of experience to run effective and safe institutions. Thank you.
Thank you all for being here today. Seeing no questions for this panel, we'll move on to the next panel. John Jenkins, Wayne Rumsey, Patricia Solik, Sarah Sample.
I'll go ahead first since I'm up here. So thank you to the chair. Thank you to members of the committee that are remaining. I'm Sarah Sample. I'm here with the Maryland Association of Counties, and you've heard a lot of really great testimony from the locals. We are still in an unfavorable position on Senate Bill 459. We did go ahead and read the original draft, and we've also read the amendments, and it's not quite there yet, but we are completely committed to continuing to work on the language. I think Mr. Foster did a great job of characterizing what the changes needed to be. So myself and Mr. Foster would be happy to work with the bill sponsors to get this to a place where the locals would actually be excluded from the provisions. But other than that, I would just really like to reiterate, you're hearing a lot about, some of the safety concerns that would be an issue, some of the spacing concerns, and then also some of the fiscal restraints that our local facilities would have with something like this. The one size does not fit all when it comes to the different facilities. And that's, there's a lot of variability from the state facilities to the locals, and even across just, the way that the different local facilities operate across jurisdictions. And so we just want to be leery of that. And then the other thing I would like to reiterate is the mental health transfers that I think the President Thompson had pointed out. When you look at the designations for serious mental illness in this bill, these are a lot of instances where those individuals would be required to be transferred to a state psychiatric facility. And like you've already heard, that the state is short on beds. And so we're constantly hearing that we cannot transfer these individuals out. And so we would just want to be cautious of trying to create, any new requirements that would allow for these individuals to stay in correctional facilities when they really need to be transferred to the state. And we really need the state to uphold their end of the deal when it comes to those transfers. So for these reasons, MACO is still in an unfavorable position, but we're certainly happy to go ahead and continue working on the language to get the counties out of the bill. So thank you.
Good evening, Vice Chair and committee members. I'm Captain Wayne Rumsey, the Support Division Commander at the Harford County Detention Center. And at the Harford County Detention Center, our continuing mission is quality incarceration for the inmate population, treating all inmates with respect and dignity while providing a safe and secure environment. Senate Bill 459 will severely hamper our ability to maintain a safe and secure housing for all inmates. All local detention centers in Maryland are facing an ongoing challenge with housing inmates with severe mental health and disabilities diagnosis. Inmates deemed incompetent and ordered by a judge, either circuit or district, to be transferred to the state of Maryland Health Department facility. These court orders specify an inmate will be transferred to the Maryland Department Mental Health within 10 days. We immediately communicate with the admissions office and are told they have no beds and they can't take the inmate, which causes us to hold the inmate for several months past the allotted 10 days ordered by the court. We communicate these delays to the judge in circuit court, district court, the office of the public defender's attorney, as they are the normal attorneys representing the inmates awaiting a bed in the state hospital requesting assistance. Due to the severity of mental health conditions affecting inmates, we see the deteriorating while they are in placement. Senate Bill 459 will not allow our special confinement team to safely house the individuals that are a danger to themselves or others. To help the inmate population, please don't grant favorable status to this bill. Please inquire why the state of Maryland Department of Mental Health can knowingly defy a court order to receive the inmate ordered into their care. Thank you for your consideration.
Hello, my name is Patricia Solok. I have nearly 40 years of experience as a licensed mental health provider in Maryland and have been mental health director for 2 facilities, including now in Arundel County, where 35% of the population is mentally ill. Throughout my career, I've advocated for the humane management and treatment of this population in hospitals because they don't belong in jail. We cannot stabilize them. Restrictive housing is our only option to safely manage them. So with MCAA, I oppose Senate Bill 459 for 2 reasons. Number 1, lacks understanding of the population in restrictive housing. Number 2, ignores unintended consequences. The population is the sickest. Chronic and severely mentally ill, have poor judgment, exhibit delusions, hallucinations, lack insight, refuse treatment. They smear feces on themselves or throw them in urine onto others. They drink toilet water. Their conditions can become life-threatening if they, for example, refuse treatment for chronic medical conditions like diabetes, heart disease. And they can be violent, vulnerable, or engage in self-harm or suicide attempts. They do not respond to logic. I like to quote a statement that one of these inmates made to our psychiatrist. I crave male genitals. I want to eat flesh. I'm going to kill them all. Where do you house this person? They need to be in hospitals, and that is the problem. Unintended consequences include, if not in restrictive housing, they would require shadowing, one-on-one supervision, arm's length. We don't have that staff. Assaults or self-harm incidents would increase, and so would liability and lawsuits. They would actually incur more charges because of the assaults. And healthcare providers would quit because they have to have the autonomy to be able to direct patients or house patients where they think it's safe for everybody else.
Thank you so much.
Thank you.
Good evening, Mr. Vice Chairman and the committee. I'm Captain John Jenkins, Operations Division Commander with the Harford County Sheriff's Office Detention Center, and I'm here today in opposition of Senate Bill 459. After review of this bill, it is evident that the writers are misinformed as it pertains to local detention facilities, their available resources, and their mechanisms to maintain and restore order as needed. The sentiment here is one of good intentions, but fundamentally undermines the authority of the local correctional system and its administration. Furthermore, the bill does not consider the limited resources of local detention facilities. Between inmates with keep separate issues, state's attorney requests for separation, inmate classification status, and institutional adjustment, local facilities do not have the luxury of additional jails or buildings to house disruptive offenders. It is not a secret that the correctional system manages society's biggest issues. Within the correctional system's population is a small percentage of inmates that, despite being removed from society, refuse to comply with the structure that is provided and enforced. These refusals are what constitutes a threat to the inmate population and the general order of the facilities. It remains crucial that correctional facilities maintain the ability to implement internal sanctions, including segregation, as a behavioral modification tool to prevent further disruption. Without this ability, the effectively managed inmate behaviors, inmates will continue to toe the line and will consistently undermine the integrity of imposed sanctions. As an administrator, it is my duty to safeguard my staff as well as the inmate population. Inmates who fail to conform to the set standards are a risk to their fellow inhabitants. It is a well-known fact that in the correctional industry that emotional contagion often drives inmate behavior.
Having an inmate that brazenly and openly defies directives without any respect or consideration for the implementation of behavior modification tools is a recipe for disruption. In my experience, I can strongly attest that there's no resource as effective in the disciplinary tool belt as a removal from peer motivation and a placement in a segregated area. Jail and detention facility administrators must maintain the discretion in conformance with Maryland standards to apply all forms of behavioral modification to maintain and restore order and ensure a safe environment for both the inmates and the staff. For these reasons, I ask this committee to find an unfavorable review of Senate Bill 459. Thank you.
All right, questions from the committee? Senator James.
Really a question. I just wanted, I'm the senator from Hartford County, and I just wanted to thank you all for coming down. It's been a very long day. And when you come down to testify, everybody, but I want to acknowledge the people from my county, when you come down to testify, it's very helpful to us to hear what is happening in our local communities. And I want to thank you very much for helping us with this bill. So thank you.
Thank you.
Thank you for that, Senator James. Seeing no questions, thank you all very much. We're going to switch to our virtual participants, and we'll hear from Emma Holcomb and Lauren Pruitt. Emma, you can go first. Welcome.
Thank you. Good afternoon, and thank you to the chair, the vice chair, and the committee. My name is Emma Holcomb, and I'm here today for Disability Rights Maryland. Disability Rights Maryland is the state designated protection advocacy agency authorized to protect and advocate for the rights of individuals with mental illness in Maryland. DRM has worked to document serious issues in state correctional facilities and advocate for improved conditions, particularly in restrictive housing units. As you've heard today, studies have shown that confining an individual to a cell for 22 or more hours per day is a harmful practice. It can cause depression, trauma, paranoia, anxiety, suicidal ideation, and exacerbate existing mental illness. Most people in restrictive housing in Maryland state prisons receive very little mental health care to mitigate these harmful effects. Healthcare records that we at DRM have reviewed indicate that some individuals in state prisons may not receive any structured out-of-cell services or programming for months at a time. And DPSCS has actually increased their use of restrictive housing for people with serious mental illness over the past 2 years. Instead of providing mental health care to incarcerated individuals with mental illness, Maryland is punishing them, taking away any classes or programs or contact with other people that may help them, and putting them in the torturous conditions of solitary confinement for months at a time. We do this to people on disciplinary segregation because they have violated a prison rule, but also on administrative segregation, which they may just be on because they are going to be transferred to another facility or for a variety of other administrative reasons. Why can't we find a way in Maryland to keep people safe without taking away these programs, these classes, and their essential mental health care? This bill would prevent the placement of individuals with serious mental illness in restrictive housing. Many organizations, including the National Commission on Correctional Healthcare, have recommended that restrictive housing not be used for individuals with serious mental illness. DRM urges this committee to address these issues and provide a favorable recommendation for this bill. Thank you.
Good evening. My name is Lauren Pruitt, and I'm the legal director for Free State Justice, Maryland's civil rights advocacy organization for LGBTQIA+ Marylanders. I'm here today supporting Senate Bill 459, not only as an attorney, but as a former corrections officer. A history of abuse and profiling towards our community by law enforcement, along with high poverty rates, homelessness, and discrimination in education and employment, has contributed to increased contacts with the criminal justice system, leading to higher levels of incarceration. When finding themselves incarcerated, jails and prisons are traumatizing, dangerous places. Many LGBTQIA+ people are placed in solitary confinement just because of who they are, and many times against their will. This protective custody remains in widespread use in many jails and prisons, even when evidence shows the considerable health risks to prisoners and likelihood it undermines correctional security. A report in 2015 examining the experiences of incarcerated LGBTQ people found 85% of respondents reported they had spent some time in solitary confinement. Of those, almost 50% had spent 2 years or more in isolation. Correction systems have increasingly relied on solitary confinement as a prison management tool to the detriment of isolated individuals. A former FSJ client who's a trans woman held in a male facility relayed to us that it is much easier for the prison to keep her in solitary confinement than to punish or protect her from those who may victimize her. her words, they do not want to anger the gangs. Solitary confinement jeopardizes our public safety, it's fundamentally inhumane and wastes taxpayer dollars. We must insist on humane and more cost-effective methods of punishment and prison management. The Mandela Act's additional training and monthly reporting requirements, which include recording gender demographic information, coupled with overall time limitations and out-of-cell movements while on restrictive housing, are the types of protections needed for incarcerated individuals. No one opposing this bill answered the basic question of why we are above average on this issue of using restrictive housing. And so for these reasons, Free State Justice urges a favorable report on Senate Bill 459.
Thank you very much, Lauren. Questions from the committee? Seeing none, thank you both very much. Thanks for hanging in there with us. Good to see you both. Have a good one. All right, with that, I believe that concludes the testimony and the hearing for Senate Bill 459. Yay. All right. Have a good evening, everyone.
I spilled water all over my Senate desk on the floor, okay? So I said, I gotta